especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Dati mihi Anglican priest, verbal Latino.
Oh, for Trump's sake.
That's literally not true.
Is that correct?
I didn't ask you to interrupt me.
All right, welcome to the Court of Public Opinion. I am the Recovery Addict. Good afternoon. This fine Tuesday, the 14th of October. Welcome back as we're about to return to court for closing statements, closing arguments. There we go. We're good now. Sorry. Here we go. All right. Welcome. We are a Pixel fam here. Can we get the cliff notes about this case? Yes, the cliff notes about this case is inmate gets his jail cell searched. It goes badly. It turns violent on both parts, the officers and the inmate, and now he's on trial for assault. That's it. But we're about to get closing arguments, which will really wrap everything up in a bow for you, Debbie. That's going to be awesome. It seems like a simple case. It's just a simple, like a 2-dayer here. So, and then we get verdict watch. And when they get verdict watch, we get to jump over to the Daisy trial. You guys remember that one, right? It's a good one. I was trying to play some music, but it wouldn't play. Let's try that again. Oh, yeah.
Through the cracks in the stone, I heard your voice, a whisper in the dark, no other choice. Metal bars can't cage the dreams we spin. The air vent carried you, and I let you in. The world won't understand this kind of fire in a concrete tomb. We built our empire. Daisy in the walls, reaching through the night. Planet in the shadows, growing toward the light. They'll call it madness, but it's just our way. Daisy in the walls.
There we go. All right. Great song. We're going to probably play it a little bit later in full, but that's just a reminder what's coming up with the Daisy Link trial. Unrelated to that Daisy song. It just happens to be inspired by a similar story, which may share some resemblances to the facts of that case. Who reads lips? I'm nosy. Well, I'm listening in, but the mics are not hot. Let's just see here. But I think they both think they're winning. That's my gut feel right now. Both sides are fairly confident going into this. Do we know what his original sentence was? I know it was for like home invasion, like something bad, something really bad. Thought I was on the wrong channel for a second. Julie, welcome. See, is the Daisy trial the air vent conception one? Yes, it is, but the air vent conception has nothing to do with the trial other than that's what she did in jail after she was arrested for murder. That's the only connection. They're both confident it's probably a split jury. I think Legally Blonde, I think that's actually correct. I think we're going to have a split jury on this one. That's my personal feel. And I'm not sure I never ended the poll last time. I just closed the live stream. That's terrible of me. What was the results of the poll? Did anyone see? Burglary and assault. Could not handle the witness and his demeanor. There were 3 this morning that could have fit that that description. Which one was the problem? Wouldn't that be contraband for the Daisy trial? No, it is now. They make rules based on when people break, do things that they think they shouldn't do anymore. That's when they make the rule. All right. Let's see. Sorry, but he clearly has violent tendencies. He does. And that's what's probably going to get him convicted. What he did to be in jail doesn't matter to me. I'm only looking at this evidence. That's the way the judge is going to instruct the jury to look at it as well. They can't consider, speaking of judge, here he is. Welcome, Your Honor. In a hurry. You're late. It's 1:33. Let's go back on the record. Click the button, Judge. Jury came back at 1:30, so they're sitting waiting in the hallway right now. It was 73-27 towards the end of the stream. 73% guilty, I'm guessing. And I think you're correct on this. I think, as I said before, 2 things can be true at the same time, and the defendant could be guilty, and the officers could be in need of either a reprimand or retraining. And possibly a new job. I mean, there's that. Not guilty was majority. Oh, okay. You guys are leaning, in that case, you're probably leaning to the self-defense side, which he said all the right things for. I just don't know if it's going to sway the jury. It's my paper, Judge. I left it on your desk. I'm sorry. That was mine. 73% not guilty. Chat not on screen. There we go. Chat's on screen. Regina Crawford, first in chat this afternoon. Congratulations, Regina. You are the winner. The big winner.
Thank you.
Thank you. Now we're back on.
We're on the record outside the presence of the jury. Anything additional on the jury instructions?
Nothing from the state.
Final form, anything on the verdict forms?
I don't know if we need on counts 2 and 3, since we've stipulated just additional findings. I don't need on the verdict form.
We do.
Yeah.
Because they're special elements or whatever, they have to be on the verdict form.
Mm-hmm.
Okay, anything else? Okay,
Yeah,
we'll get our jury.
You will bring the jury.
You will bring the jury.
Was it bad or was something better? What?
I think it was bad. I got like 5 people in there.
Something about 5 people.
You did good. I mean, we're back to 1. So
you did good. Thank you. You did good. Thank you. We are ready for closings right now. It's the first thing we're going to do when the jury comes back.
You may be seated. Welcome back, ladies and gentlemen. Was everybody able to follow my instructions and admonition since we saw each other last? All right, we're now going to hear the closing arguments of the attorneys. The closing arguments are not evidence. They are designed to assist you with the evidence. It is the opportunity that each side has to argue to you for a specific verdict, sum up what they believe that the evidence is shown. We have agreed in advance that each side will have up to 30 minutes for their closing arguments. Ms. Tranter, because she has the burden of proof in this case, will address you both first and last with Mr. Engel in the middle. Ms. Tranter, you may proceed.
Thank you, Your Honor.
It's a Mr. Engel sandwich.
All right. Good afternoon again, ladies and gentlemen. Thank you for your time and attention for these past couple of days. We're wrapping things up, and what I like to do in the first part of my closing, because the judge said, has already told you I get to address you twice, is we're going to go through the charges and the elements and the facts and evidence that you've heard that relates to each of those, okay? So, as you're aware, the defendant in this matter is charged with 4 separate counts, okay? Count 1 is felonious assault. And the language of felonious assault is that on or about July the 23rd, 2024, which is our date of incident, in Warren County, Ohio. That's what gives this court and Judge Oda jurisdiction to hear this matter, because it happened at Warren Correctional Institution, which is in our county here. Defendant, Thornton Demon Thomas, did knowingly cause serious physical harm to Owen Sycamore, who is one of the corrections officers, okay? Now, you're gonna get a lot of instructions, and I don't know, I apologize, because I don't know how to make that thing on the bottom go away. I don't know if that's me or...
That's the court.
Ms. Karolko, but we'll work around it. So, part of what we do in jury instructions is give you definitions, okay? And some of those definitions might not kind of coincide or jive with what we use in our normal, ordinary day life. So we give you the legal definition, okay? So as part of felonious assault, you're going to receive the definition of serious physical harm. That is any harm. It's 4 separate things can qualify as serious physical harm, right? First is any physical harm.
There are too many words on this.
That carries a substantial risk of death. Any physical harm that involved some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. Any physical harm that involves some permanent disfigurement, or that involves some temporary serious disfigurement. And any physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. That's a lot of words up there, so
it is.
Don't get overwhelmed in that. To meet serious physical harm, we only have to show beyond a reasonable doubt one of those, okay? So what we want to focus on, your attention should be drawn in this particular case, is to the third one down. Any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. You heard testimony from Officer Sycamore that he had injuries as a result of this attack. 2 things are important about his testimony. First part was he testified that he has a scar on his lip from his busted lip that he suffered. That's a permanent disfigurement. Second part of his testimony that is important is, of course, his fractured tooth. You saw the photos. He's got half a tooth missing. I would argue to you that is permanent disfigurement. No matter what he does, that tooth is never going to grow back, right? If you don't view it as a permanent disfigurement, you certainly can view it as a temporary disfigurement before he got the cap put on to look nice and neat and normal again. It certainly was a temporary disfigurement, but I argue for the purposes of this case, it is definitely a permanent disfigurement. He's going to live with that for the rest of his life. Count 2, assault. Same date, Warren County, Ohio, same defendant, did knowingly cause or attempt to cause. It's a little bit different language. First one was cause serious physical harm. This is cause or attempt to cause physical harm to, again, Officer Sycamore. He's the subject of this one as well. Okay, I had oh, I didn't have it. Okay, so count 2, and we're going to see as we go through on count 3 as well, have these additional findings, okay? When the judge reads you and your jury instructions, you are going to hear that both sides, myself and Mr. Engel for the defendant, have stipulated to all of these elements. So these are not even going to be a discussion for you, okay? The offense occurred in or on the grounds of the Department of Corrections or Rehabilitations. That's Warren County Correctional Institution. Victim of the offense was an employee of that Department of Rehabilitation and Correction. Obviously, we know he was a corrections officer. And the offense was committed by an incarcerated person. Mr. Thomas was incarcerated by the state of Ohio at the time. Again, those are all stipulations. You guys are not going to have to worry about those. Count 3 is the exact same language, except this time instead of Officer Sycamore, we're dealing with Officer Romine. Okay? Exact same language that the defendant did knowingly cause or attempt to cause physical harm to Officer Romine. Physical harm for this purpose, a little bit different than serious physical harm. So to prove physical harm, I have to prove to you any illness, injury, illness, or other physiological impairment, regardless of its gravity or duration.
She's turned around reading the PowerPoint.
A little bit of a difference in the language.
My least favorite style of delivery.
Count 3, those are the furthermores. From count 3, again, all of those findings have been stipulated by both sides, so those are not an issue. Strangulation, count 4.
Defense definitely going for self-defense.
On or about July 23rd, 2024, Warren County, Ohio, the defendant did knowingly create a substantial risk of serious physical harm to Casey Romine by means of strangulation or suffocation. So here, we're not dealing with an actual creating or actually causing serious physical harm. We're dealing with creating a risk of serious physical harm. So the relevant testimony to that obviously is Casey Romine describing how the defendant not only punched him for purposes of the assault, but also put him in a headlock chokehold for upwards of 30 seconds. Now we've done the basic elements. Defense has proposed a self-defense theory in this case. So you've got kind of a two-part analysis when you're going through these. And again, I'm going to highlight some things. Judge is going to give you the full instruction at the end, but we're going to break this down because this is a step-by-step analysis, okay? So the first thing you're going to do is you have to determine the amount of force that the defendant was subjected to by the corrections officers, okay? The law states that corrections officers may use force against an inmate in these specific situations: self-defense from a physical attack, or defense of another from physical attack or threat of physical attack, prevention of an escape or apprehension of an escapee, and controlling or subduing an inmate in order to stop or prevent self-inflicted harm. So if they're cutting or harming themselves. For this particular case, I am going to submit to you that the officers were within their rights to use force against Mr. Thomas because of these two reasons. When necessary to control or subdue an inmate who refuses to obey prison policy. Okay? He was directed to sit down and let them search his cell. He disobeyed that order by getting up, pacing around, knocking the water cooler over. He disobeyed that order by repeatedly refusing to obey their commands to cuff up. You heard Officer Blythe tell you the policy is you get 3 warnings and then you get a final directive. Cuff up, no response. Cuff up, no. Cuff up. No. Final directive. Cuff up. No. And then he gets OC spray. You also may consider that the officers could use force against Mr. Thomas when necessary to stop an inmate from destroying property or engaging in a riot or other disturbance. He knocked that water cooler right off. Possible destruction of prison property. Certainly created a disturbance. You can hear it hitting the floor. You heard Officer Blythe say that's the reason why he came out of the cell, is because he heard all the commotion. He certainly was committing an act that was a disturbance. These officers were well within their rights to use force against Mr. Thomas to get the situation under control. Now, let's talk about force. Reasonable force, and I've had to divide these up because there's a lot of words on them again, means force used in accordance with these following guidelines. Okay? Number one, corrections officer may use a small amount of force, as may be necessary to restrain, guide, support, or direct an inmate to apply handcuffs, waist or leg restraints in connection with accepted procedures, transport, or movement. Okay? We know that they were trying to apply handcuffs to him at this particular point. We know that he was resisting. Reasonable force can be also used in this manner. Corrections officer, considering the use of force, shall evaluate the need to use force based on the circumstances as known and perceived and considered. No Monday morning quarterbacking. No, if he did this, shouldn't you have done this? This is an in-the-moment time frame that we're talking about. This is not looking back and saying, could I have done things better? This is in the instant, has to be viewed from a corrections officer experiencing it at the time. Reasonable force may be used in this instant. Corrections officer may use force only to the extent deemed necessary to control the situation. Corrections officer shall increase or decrease that level of force as resistance increases or decreases. So if a defendant is escalating, their force can escalate. De-escalating, force can de-escalate. So it's kind of a sliding scale, up and down. Last two, a corrections officer should attempt to use only the amount of force reasonably necessary under the circumstances to control the situation and shall attempt to minimize physical injury, and force or physical harm shall not be used as punishment. Okay? You have heard testimony from all the officers involved that their reasonable force was used not as a punishment, not because defendant was bad-mouthing them, but because he was not complying with their orders and their commands. So if you determine that the amount of force that Mr. Thomas was subjected to was reasonable, and the officers were reasonable in that application,
is staring off into space.
Stop. Your analysis is done. An inmate has no legal right to resist reasonable force. Don't overcomplicate it. Self-defense argument is a no-go at that point. Your analysis stops. Defendant is guilty. Now, I submit to you that when you're back in the jury deliberation room, that's as far as you're going to need to go, because you're going to find that the force used was reasonable by Officer Sickman and Officer Romine.
You're going to find that? Blythe. Just tell them what they're going to find.
So your analysis should be done. However, if there's a question, which again I submit there's not going to be, you continue your analysis.
Jeez,
okay?
No.
If you determine that the amount of force that
Mr.
Thomas was subjected to was excessive,
read in the future,
then you can consider self-defense. So if for some reason you say the force was not reasonable, you move on to step 2. Self-defense, the state must prove beyond a reasonable doubt that the defendant, when using force, did not act in self-defense. To prove the defendant's use of force was not in self-defense, I have to prove to you beyond a reasonable doubt only one of the following four things I'm going to put up there. You've got four options, but I only need to show you one. It's not an and, it's an or at the end of each of these statements. Number one, defendant was at fault in creating the situation or giving rise to the use of excessive force by the corrections officers. If you find that he was at fault for creating the situation, stop. He's not entitled to self-defense. The second and third one don't really apply, but they're there as options for you, okay? Defendant did not have reasonable grounds to believe that he was in immediate danger of being subjected to excessive force, or defendant did not have an honest belief, even if mistaken, that he was in immediate danger of being subjected to excessive force. Now remember, if you're at this part of the analysis, you've already made a decision that the force was excessive and not reasonable. So we're going to move on to number 4. Defendant used unreasonable force. If you find that the defendant used unreasonable force in response to the force used by the corrections officers, he escalated the force, in other words, he didn't need to knock out Officer Sycamores' tooth, he didn't need to put Officer Romine in a 30-second chokehold, stop. He's not entitled to self-defense. I submit to you, ladies and gentlemen, that he was at fault in creating the situation, giving rise to the force. I still submit it was reasonable force, but again, if we're at this part of the analysis, we're talking about excessive. He created this situation. The officers conducted a cell search well within prison policy. They told him to sit down, let the cell be searched. He even testified, had he not argued, this would not have played out the way that this did. This is out of his own mouth. But rather than complying with the orders of the officers, he got upset. He got mad. He threw a temper tantrum. Started yelling, cursing, screaming, knocking the water cooler off, showing pre-assault indicators to the corrections officers. Let's take it a step further. He continues to create the situation because at that point they're ordering him to cuff up and he's refusing. He could have stopped it right there. He could have said, okay, I'm gonna put my hands behind my back, cool off, and again, testified that it probably wouldn't have played out the way that it did had he complied with their orders, but he didn't. Once, twice, I think one of them testified upwards of 6 or 7 times that he was told to cuff up and he refused. He would not do it. He created the situation, he escalated the situation. This is the video that we've seen so many times. He's pacing, which they testified that was also a pre-assault indicator. And there go the water coolers. This is the part where he's refusing to cuff up after multiple directives. And the OC spray is used.
×3.
He created the situation, no self-defense. Again, these are the part of the analysis, he didn't have a reasonable grounds to believe he was in immediate danger of being subjected to excessive force, and did not have an honest belief, even if he was mistaken, that he was in immediate danger of being subjected to excessive force. And finally, the defendant used unreasonable force to respond to the situation. This is the other angle from, I think, the laundry room camera. Defendant biting, punching, knocking Officer Sycamore to the ground, still being combative and not complying. Finally gets Officer Sycamore on the ground, strikes him multiple times, and ultimately gets Officer Romine in that chokehold. You heard Officer Romine's testimony yesterday that he thought he was going to die. That, ladies and gentlemen, is an escalation of the force. Self-defense does not apply. At the end of the day, ladies and gentlemen, we do believe that the evidence has shown, and the appropriate decision and only decision is that the defendant is guilty of all charges, and self-defense is not an option in this matter. Thank you.
Mr. Engel?
Thank you. Plug it in, plug it in. There we go. Both working off PowerPoints?
State, may it please the court.
Judge.
It has been my honor to represent Mr. Thomas in this case. Not because he's my friend, not because I like him or don't like him. If I've given you anything to think one way or the other, that's not my job. But my boss is not a politician or an elected official or someone who wants to seek office. My boss is the Constitution. And if you remember, one of the first things I asked you yesterday was, why are we here? Why are we here? Why are you here? And the answer is not because we have some kind of tradition. It's not because we think it's nice, but because it's important that the people be here, and that the people watch what the government and its employees do. You are the ones who get to say the government has gone too far. You are the ones who get to say this is how things should be. That's why you're here. You're here to say what is right, what is just, and more importantly, to make sure that the government does its job. And there's two ways I always think about this. The first is, I love this quote from Miles Davis. It's not the notes you play, it's the notes you don't play. Because one of the reasons you can trust the government and what it's trying to sell you is to make sure they have done the work. Make sure they've, for example, make sure they've interviewed everybody who can be interviewed so that they know what's going on. Make sure they've gathered all the evidence that you would want to know the answer to your questions. That's what they have to do. And if they did not do that, if you think that they didn't do some of the steps that they should have, you should not be complicit with that shoddy job by signing your name to a guilty verdict. Because it's your name and your honor ultimately on the line here. And if they didn't do their job, it's perfectly fine to say, you know what? I think maybe he is guilty, but the government didn't do their job of showing me enough evidence, of doing what's supposed to be done here.
That was
and that's
close.
okay. In fact, that's more than okay.
You almost
That
went to
would
jury
be the
nullification.
highest American ideal would be to say, I need more. I just don't have enough. That's what you do when you make the state meet its duty of proving things beyond a reasonable doubt. Making sure that you are firmly convinced of the truth of the charge. More importantly, making sure that they have convinced you firmly of the proof of the charge. Not just rhetoric, not just what you think happened, what just what you think probably happened. But do you have the evidence to support what you firmly believe happened? So here's where I think this case comes down to. The defendant acted in self-defense. He knowingly caused or attempted to cause harm to people. That's true. Absolutely true. No doubt about that. But he acted in self-defense because of three things. First, the corrections officers created and provoked this situation. Second, they violated their duty to de-escalate the situation. Excessive force in gaining compliance. So let's look at what this is. I think the big picture kind of comes down to something my kids would say. One rule for me, another for thee. So think about this. Every time they're talking about inmate Thomas, they're like, he knows the rules. I say cuff up, he's supposed to say, yes sir, cuff up. I do that. He knows what he's supposed to do. I'm going to force those rules against him to the letter of the law. If there's a blade that's out of place on that fan, I'm going to take it. Or I can take it. If he doesn't have a piece of paper in the right place in his cell, too bad for him, right? We're going to strictly enforce the rules against Mr. Thomas. That's kind of what Ms. Tranter's saying when she says, hey, he can avoid this by just cuffing up. They said cuff up, he's supposed to know to do it right away. Okay, fine. But when it comes to the officers, it's more like Captain Barbosa. The rules are more like guidelines. Remember I asked him, where does it say in these policies that you have discretion to do these things? And they're like, well, it's kind of implied. I'm kind of trained about this. I don't know. I sometimes enforce this rule. I sometimes don't. I can do these things not. When it comes to the officers, when they ask about themselves, they're Captain Barbosa. They're like, no, it's more like a guideline than a rule. I don't have to follow it. But when it comes to the inmates, they're Eric Cartman. They're all respect my authority, and if you don't, we're going to spray you in the face. So you're going to get, when you go back into the jury room, a copy of all these policies that we've been going over, and I encourage you to look at them real close. you're going to get Exhibit A. I'm sorry, Exhibit A is the cell search policy. Exhibit B is going to be the personal property policy, and so on. And so when you look at that personal property policy, you'll just see simply they're allowed to possess a reasonable amount of personal property. They're allowed to do it. And the officers kind of want you to think, well, it's kind of flexible, and maybe it's 2.4 things, this counts, and this doesn't count, or whatever. But they're allowed to have it, and that's the first start, right? They're allowed to have property in there. You'll get that search policy. It says that reasonable care should be taken during the search so as not to damage or destroy cell contents. And if they take stuff, take contraband, they're supposed to generate a list. You check it. So there's the first problem, right? Where is that list? Now, they want you to believe that there was contraband here. Follow their own rules. That's what I mean by doing your job. Maybe you believe this was contraband. Maybe you believe it's not. We'll talk about that in a second. That starts this whole thing. But if they followed their own rules, you wouldn't have to worry about it. They'd be able to say, here's the list, because I followed my policies. But again, one rule for them, I don't have to document everything. I don't have to create that list, even though my policy says I don't. Another rule for Mr. Thomas. When you look at that use of force policy, that should guide your consideration about whether there is excessive force here. You can take that into account. And we focused a lot of time, maybe too much time. You got frustrated with me, I'm sorry. Take it out on me later. Don't take it out on Mr. Thomas. But I think it's really important about what that policy says. There is a duty to de-escalate, and they are required to do so. Those are not choices. The word duty means you have to do it. The words required means you have to do it. And so when you think about whether there's excessive force, the first thing you should ask yourself is, did they comply with their own obligations? And if they didn't, it's excessive. That's what that means. You also have to be important to remember, should be mindful to create physical space to themselves. So think about that situation. They're in the cell, he's outside, he knocks over the water cooler. What do you see happen next? They walk up towards him. What does he do? You saw on that tape very clearly, he steps back. They keep closing that physical space. If there is a danger, it's because they are making that danger apparent. Again, against their policy. They're supposed to create that physical space so that they can use their de-escalation skills, which they're supposed to have, to solve this problem. And then they're allowed to bring in other people. Again, what's the cause of that situation? The suggestion is the cause of the situation is he's told to cuff up, he doesn't. But let's look at that world there. There's no one else around all the time in the world to make sure that things de-escalate. That's why it's excessive, again. And we haven't even gotten to the most important thing, which is, in considering whether it's excessive, you can't consider the fact that they violated their policy against creating jeopardy. People at ODRC who write these policies don't just find them buried on Mount Sinai and bring them to Ohio.
A Moses
they have experience
reference.
in the prisons. They know what's going on. They know how these things work, and they know that guards could sometimes provoke inmates.
He's got all the references.
This is not news to anybody. So they said,
Went
don't
full
do
10
it.
Commandments there.
You should never verbally or physically provoke someone. And they knew they were taking steps to provoke them. And then you'll get an investigations policy that says they're supposed to look into potential misconduct by the officers. And again, ask yourself, did they ever do that? You know they never did that. You didn't see one drop of evidence that anyone looked into this.
Kent, I asked them to time you out for the day.
You'll find out they lied about it.
And even if I didn't ask them, they'd be right to do it.
So here's where we start, right? The defense, CEOs create the situation. They're searching his cell.
And he said he's upset about it. He thinks he's being targeted about it. And they find hooch belonging to his cellmate. But again, he's just standing there quietly. Looking at his pad, writing that report. Nothing to see here. Right? You don't see someone who's angry, belligerent, upset. You see someone who's there. And I mentioned that because you heard that some of the officers in their use of force reports wrote that, hey, he was belligerent from the very beginning when we started searching his cell. He wasn't. Then, if you want to believe his testimony that he's being targeted, don't believe Mr. Thomas. Believe the words of the officers on the tape. I think this might be the second most important thing that's said on this tape, on these tapes, which is they say they're looking for a shank, they find a plastic knife and joke about it, and then you listen carefully, you hear them say, there's gotta be something in here. That's them admitting they are targeting him and provoking him. There's gotta be something in there. They're not looking for, they didn't say there's gotta be a shank in here. They didn't say it's gotta be in here somewhere. There's gotta be something in here because they're looking to get him in trouble and jam him up.
Found a knife. Gotta be something.
Then they take his pillows and put them in the trash, and the defendant's standing still calmly in the background. Now, you'll get to play that tape. I don't need to play it again for you. Let's talk about these pillows and these fans and their contraband, because there's a lot of argument about that. Officers claim these are all contraband. They're not supposed to have them. So let's start with that idea. Where's the proof? Where is it? They want you to believe them. They knew that this was going to bring criminal charges and that they were going to have 12 people like you sit and listen to it. Officer knew that the next day. Trooper knew that the next day, sorry. Trooper knew that the next day. Does he go and get that evidence? Because he knows he's going to have to present it to you? This is what we call a known unknown. Meaning, you don't know for sure whether these pillows are legal pillows or illegal pillows. But there was an answer to that question. Right? This could have been answered so easily if the trooper had done his job and taken the evidence in the case. He could have brought them into court, showed them to you, and said, they're not there. Or, he could have brought them into court, because he would do his job, and show you that they were legal pillows. So why did they disappear? Do you draw an inference from the fact that they disappeared? That maybe Mr. Thomas was right and they were wrong, and they didn't want to admit that? You could. You don't have to. It's enough for you to say, state didn't do its job. If we don't know, it's their fault. Same thing with the fans. They don't know, it's their fault. Second, they claim, even if that we have discretion to let them keep it or not. Two things about that. First, it's a lie. And I don't say that very often. I've been doing this a long time. And I rarely say that folks lie. But that's a lie. Absolute lie. Nowhere in their policy does it say they have discretion to do that. And you don't want them to have discretion to do that. You don't want these corrections officers having that authority, which could easily be abused. Remember we talked about the Stanford prison experiment earlier, at the very beginning. We talked about how people in positions of authority could abuse that authority. Well, one of the ways they can abuse that authority is to give them discretion. You could have an officer who's completely racist and who says, you know, I'm going to take stuff from black guys and not stuff from white guys, and that's okay because I have discretion to do it. It's not right. More importantly, you don't want to let them do what they did in this case, which is use that to punish him. He's running his mouth. Okay? They don't like that. Okay? He's using some words that I won't even repeat here. Okay? But they're not the ones who are supposed to punish him for that. And what are they doing? On a hot day in July, they're taking his fans to punish him for talking. Don't believe me. They told you that's what they're doing.
Objection.
Overruled.
Judge is like, yeah, I remember that. Yep.
I'll come back to that in a second. I want to pause on two other points here. I mentioned the investigation and the delay. Also want to focus on, and I should have mentioned this before, serious physical harm. You have that felonious assault charge. I think you could easily look at that evidence, testimony saying a chipped tooth that got repaired and a busted lip. That's not serious physical harm. That's a night out sometimes for some folks. That's not serious physical harm. But let's pause on their testimony before we think about why I said that they told you that they did this. State's witnesses were completely not credible. I want you to compare their testimony. You heard me ask them about things in their use of force reports. And you saw how in their use of force reports, they were not completely candid. They didn't include things that were important details. That goes to their credibility. They're not telling their supervisors the whole truth. So why do you trust them to tell you the whole truth? But you can also saw there were some flat lies on the stand. One of them said, for example, a couple of them said he was pulling up his pants, and that was an indicator that he was aggressive. They'd written that in their use of force reports, you heard. That's not true. And they even admitted it's not true. But again, they're not truthful in everything they're doing in this case. But I thought the biggest example was Officer Blythe. Officer Blythe says that when Mr. Thomas was confronted about the hooch, he was belligerent. But he wasn't.
He wasn't belligerent.
He wasn't. Videos to go back with you in there. And I encourage you to look at them.
Having some feed issues, sorry.
I'll warn you, by the way, on one of them, I think it's Officer Sycamores. That one, most of them are cut down to just the parts that are important and relevant. That one's actually 30 minutes long, and you probably have to fast forward to about the 15-minute mark to get to anything that's relevant to this case. But you get the whole tape. So just a heads up on that one. But Officer Blythe, Corrections Officer Blythe says he was upset when he pulled the tape. You look at that tape, you'll see he comes out with the hooch. The defendant's just standing there. And it's his cellmate who says, hey, it's mine. I take responsibility. He comes out and says, who wants to take ownership of this? Cellmate takes ownership of it. Detective Thomas is standing there. He wasn't truthful with you about that. You heard you heard a couple times in their use of force reports, they tried to pin the hooch on Mr. Thomas. That wasn't true either. These guys just can't tell the truth. But we said the worst thing he said was the admission that they took these things because these items from Mr. Thomas, not because they're contraband. Because they'd searched his cells many times before and never taken these items. But they took them because he had the audacity to complain about it. He had the audacity to maybe start to send a kite, that communication in the prison, out to supervisors about it. Don't believe me. Listen to Officer Blythe. He denied saying this. I asked him. My only question I asked him was, did you say they want to run their mouths? Fuck it.
Give me
said he didn't say that. He looked somebody in the eye. Actually, maybe he didn't even look you in the eye. He looked at me. He looked me in the eye and lied to me about it. So Judge Oda is going to give you some instructions in this case. He's going to tell you that the state has a duty to care for inmates. They have to treat folks humanely, appropriately. He's going to tell you that self-defense is available if there's excessive force, which will be defined as greater than reasonable force. And he's going to tell you within that instruction, quote, you must consider the conduct of the victims and decide whether their acts and words cause the defendant to believe he was about to be subjected to excessive force. In other words, it's from the defendant's perspective. Did what was going on, did what these officers did, the fact that they're taking his stuff for arbitrary reasons, because he's running his mouth, does that make him fear that something worse is going to come down the road? Put yourself in his position. But think about that. If you're being subjected to arbitrary actions of a state agent, are you going to trust that state agent further down the road? Now, it's true, and I'm not going to sugarcoat this. The defendant used some bad language. He knocked over the water cooler. But he was provoked to do those things by the defendant. He did not start this chain of events. Right? The prosecution wants you to think the chain of events starts when he's asked to cuff up. That's not right. The chain of events come when they start searching his cell and they don't do it appropriately. That's the beginning of the story. And you need to start at the beginning. That's the common sense, right? You don't start in the middle. You start at the beginning. And I want to emphasize the burden of proof here on self-defense. The state has the burden of proof on this. So if you're not sure who to blame, the state has not met their burden. That's when you put a not guilty verdict down. Again, you'll have this video. How did this start? They say, you know what? Keep talking. I'm going to take your finger. They're provoking him. And rather than play the video, just look at what's going on while this is happening. Again, he's standing there quietly. They ask him to cuff up. He says, can I get a white shirt from here? He says, they took my fans. And again, he's not acting aggressively. He never threatens anybody. His hands are down by his side. They're not in fists. This one's curled up a little bit. That one's not in a fist. You'll see the whole video there. See, he's pointing with his hands. Here's the thing. And here, this is probably the most important video. This is the frame. This is the moment when he's being sprayed. Where are his hands? They're behind his back. He's not a threat to anybody. His hands are behind his back. And then, what does he do? If he's supposedly aggressive, if he's trying to assault people, after he's sprayed in the face, does he go after them? Does he charge at them? Try to close that distance, prevent them from doing it? Some of you have had self-defense training, you know that's what you're trained to do, close that distance. He walks away. He doesn't even run away. He walks away. You'll see, he goes and walks slowly around to the other side. He's trying to wipe the spray out of his face. He's going towards that door where he says, help is coming, because he knows, having been there forever, as soon as they hit that spray, they're going to hit their button for assistance to come. He knows that a supervisor will then be coming. He knows that people he can tell this story to and talk to will come. And he'll get the help. And think about, go back to, when you look at this part of the video, I want you to go back to that excessive force, use of force policy. Talk about creating space. And think again, who's causing the problems here? The officers, if they're trying to, could have used their de-escalation skills again. It says specifically, you're supposed to kind of stop and reassess and move your force up and down depending on how things are going. He's walking away. They could have called for assistance. They could have just waited. He's not harmed anybody. He's not attacking anybody. There's no one there that he could attack. He's just standing in the corner, they're away. And what do? They close that distance again. They put hands on him again. They're the ones trying to go after him again. They're the ones escalating this situation to another level. And you saw the struggle, but I want you to be really vigilant at watching this struggle here. Watch what's really going on. Is this an effort to subdue someone, or is this an effort almost like a riot from corrections officers to beat him and make him suffer for not complying with this? Are they doing what is necessary to engage the situation, or do you see folks pulling his hair, striking him in the head multiple times, not to get compliance, but to punish him? You saw Sycamore back there. He's hitting him again and again and again in the head, even though he told you his training is not to hit people in the head. And this end.
Mr. Engel, you have about 2 minutes remaining.
You can see the close-ups on there. And you'll see that video where one of them comes up there and sprays him right in the eyes while he's being held down on the ground. So again, the state says this all could be avoided if he cuffed up. But Judge Oda says you must put yourself in the position to defend it. First, and I told you he did. His testimony was very credible. He acknowledged where he could have done better. The life in prison he described makes sense, and he's the only one whose testimony was consistent with all the videos. And the reality is this all could be avoided if the COs had acted in accordance with their policy. You should find him not guilty because he was not a risk to anyone. To escalate the situation, no effort on the corrections officers to de-escalate the situation. They took his property to punish him for talking. They could have called a supervisor, they didn't do it. They could have waited after spraying him in the face, they didn't do it. I could go on and on and on. You get it. You get it. This was not reasonable force. And so when you go back, I'll remind you, I'll leave you with this, a Bible passage. The Lord hears the needy and does not despise his captive people. Sir Thomas is a captive person, but he's a person. He deserves that dignity. He deserves to be treated with respect. He doesn't deserve to be provoked, to be taunted, to be treated arbitrarily. He doesn't deserve to be sprayed in the face for the audacity of asking for a supervisor to come and resolve a situation he's got. He was honest with you about what he did. He was honest with you about what he didn't do. He acted in self-defense. State has not proven it met its burden otherwise. You are doing your duty as Americans when you sign not guilty on that verdict slip. Thank you.
Mr. Trevor, you have 8 minutes remaining.
Thank you, Your Honor.
She's going to try to hit all those points while rolling her eyes.
You know who else is a person? Officer Sycamore is a person. Officer Romine is a person. And they deserve respect enough that they can go home to their families at night. There is nothing in any prison policy that Mr. Engel is going to put in front of you, ladies and gentlemen, that says they have to step back and wait to get hurt. that they have to step back and wait to react to a defendant who is a threat to them. You're not going to find that.
There was some audio
It's
issues.
officer safety.
Yep.
They told you all about pre-aggression indicators. They told you about their training, and they reacted and did as they were trained to do so. Like it or not, law enforcement, be it corrections officers, be it the highway patrol,
Where are you going with this?
be it a police officer who pulls you over for speeding, they all have some amount of discretion in their jobs. An officer can pull you over, for instance, and give you a warning for speeding. An officer can pull you over and give you a ticket. That's called discretion. It's no different than the discretion that is held within the prison, the discretion between that Officer Sycamore told you about and Officer Romine. Okay? They are not there to make lives miserable. In fact, they were trying to cut the defendant a break because it's July and it's hot, and they were trying not to take his fan. But he wouldn't comply. You want to know why there was no contraband log? Because the search wasn't finished. The search had not concluded.
That's weak.
To then go to the next step
It never concluded.
Creating a contraband log, because he didn't allow the search to finish. It was interrupted by his acts of violence. They went to the hospital. They didn't create the contraband log. They were a little busy at the hospital. This whole use of force policy, Mr. Engel has pointed out time and time again that there has to be use your interpersonal skills to de-escalate a situation. The part that he keeps forgetting is the next part of that sentence, as long as it is safe to do so. Again, they are not required to sit around and try to have a long talk with the defendant. This isn't someone you're disagreeing with out in the open that you can sit down at Starbucks and have a cup of coffee and work out your differences. This is a prison. This is an environment by its very nature that is violent. You can't just wait around for a supervisor just because some inmate demands it. That is part of the discretion. The situation did not call for that. I know you don't want to hear any more about the pillows, but I'm going to say one more thing. Legal or not legal, Mr. Engel says that answer could have been easily known if Trooper Klantz had confiscated them and so we could all examine them. Well, first of all, that's an administrative role. That Investigator Chamberlain told you that's his role. Okay? It's not Trooper Klantz's role to decide whether or not something is legal within the prison itself, as far as that kind of property goes. We could also get that answer another way. We could have gotten that answer if the defendant had followed the proper procedure and filled out the proper kite and paperwork to challenge what the officers took from his cell. And I think that Mr. Engel's description of the testimony given by Officer Sycamore and Officer Romine and saying that it was lies, I think that's disingenuous. Yeah, they filled out those reports. They filled out the use of force reports. But as you can tell from watching these videos multiple times, I mean, this is something that happened like that. even trying to watch them without slowing them down, your head is kind of spinning, I would submit to you. They did not have the benefit when they filled out these reports immediately after this incident of having months and months to dissect the video and slow it down and go frame by frame to see exactly what happened. So yeah, there might be details left out. That's understandable, because that's a lot of information to cram into one little report in such a little amount of time. This case, ladies and gentlemen, in spite of all the policies that have been thrown at you and the codes and the regulations, it really comes down to one thing. It comes down to the fact that the defendant threw a temper tantrum. He is a person who, I think, is evident, came through as evidence in his own testimony. He's an individual who's used to getting his own way. He was fine with discretion that other officers may have had in prior cell searches when he requested the white shirt, requested the supervisor, and that officer used that discretion to go ahead and call somebody down. He was fine with that amount of discretion. But they're not fine with the discretion that Officer Sikkema and Officer Romine used to not call somebody down. He's fine with the discretion that officers used in prior cell searches, maybe even the day before when they didn't take his unauthorized and altered fan. He's fine with that discretion. But he's not fine when they use their discretion to take the fan. When it doesn't go his way, he gets mad. It didn't go his way this time, and he got mad. He created the situation. He escalated the force. Officers used reasonable force to respond to the situation. They were not the one, he was not the one to end up in the hospital after. They were. Reasonable force, ladies and gentlemen. It's not complicated. They used reasonable force. Self-defense does not apply in this particular manner. Even if you think the force was not reasonable, self-defense, as I showed you in my first portion of my closing, doesn't apply. He escalated the force. It does not apply. He started the situation, created the situation. Self-defense does not apply. Thank you for your time and attention, ladies and gentlemen.
She keeps saying that
We would
because that's
ask,
what she's most afraid
on behalf of the state of Ohio, a finding of guilty on all charges. Thank you.
So, ladies and gentlemen, I'm in my 20th year as a judge here in Warren County. And what I've learned in that time is that different people absorb information in different ways. It is time now for me to give you the instructions of law, and it's been my experience that some people absorb this information by just listening. And if that's the way that you absorb information, then I am going to read to you the instructions. But also I have people who absorb information by listening and also reading along. So if you're that person who wants to listen and also read along, Ms. Kuroko is going to give each of you a copy of the instructions that I'm going to read you. So if you want to read along, you can. You can't skip ahead. That's you have to stay with me on that. Or
Read
if
fast.
you don't want to follow along that way, then you can just turn them face down on your lap. You will have the opportunity to have these with you. So you're going to take these with you into the jury room, and you will have them if you need them for your deliberations. Sometimes I depart from my prepared remarks a little bit. I'll try to tell you when it is that I ad lib and when it is that I return. So we'll start.
This was prepared.
Members of the jury, you have heard the evidence and the arguments of counsel. It is my duty to instruct you on the law. The court and the jury have separate functions. You decide the disputed facts, and the court provides you with the instructions of law. It is your sworn duty to accept these instructions and apply the law as I give it to you. You are not permitted to change the law, nor to apply your own idea of what you think the law is or ought to be. The case before you began with the filing of the indictment. The indictment informs the defendant that he has been charged with a crime. You may not consider the fact that it was filed for any purpose. The defendant has entered a plea of not guilty, which means that you are not to assume that any of the facts alleged in the indictment are true. A plea of not guilty is a denial of the charge and puts at issue all the essential elements charged in the indictment. The defendant is presumed to be innocent until guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged. What is reasonable doubt? Reasonable doubt is present when, after having carefully considered and compared all the evidence, you cannot say that you are firmly convinced of the truth of the charge. Reasonable doubt is based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's affairs. Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial. It also includes stipulations. The attorneys have stipulated to the following facts, which you are to accept as true. Number one, this incident occurred at the Warren Correctional Institution, which is located in Warren County, Ohio. 2, this incident took place on the grounds of a state correctional facility. 3, Officer Casey Romine and Officer Owen Sycamore are both employees of the Ohio Department of Rehabilitation and Correction. And 4, the defendant, Thornton Thomas, was an inmate incarcerated in a state correction institution at the time of this incident. You may consider both direct and circumstantial evidence. You will decide from all the direct and circumstantial evidence taken together whether the state has proved all of the elements beyond a reasonable doubt. Direct evidence is the testimony given by a witness who has seen or heard the facts about which the witness testifies. It includes the exhibits admitted during trial and the stipulations. Circumstantial evidence, on the other hand, is proof of facts and circumstances by direct evidence from which you may reasonably infer other related or connected facts according to the common experience of people. I'm going to depart from my prepared remarks to give you an example. My middle granddaughter has recently discovered that she likes orange popsicles. Let's say, for the sake of argument, it is your duty to determine whether or not Josie had eaten an orange popsicle. If we brought a witness in here and said, I saw her eating the orange popsicle, that's direct evidence that happened. But if we had a witness that said, I saw her before, and she looked fine, and I saw her afterwards, and she had orange all around her mouth, had a little stick in her hand that was orange on the end, that is indirect evidence or circumstantial evidence from which you can infer that she had consumed that popsicle. Returning here to infer is to make a reasonable inference or reach a reasonable conclusion of fact that you may, but are not required to make from facts that you find have been established by direct evidence. You may infer a fact or reach a conclusion only from facts that you find have been proved by direct evidence. Whether or not an inference is made rests entirely with you, and direct and circumstantial evidence are both of equal probative value. The evidence does not include the indictment or the statements of the attorneys. The opening statements and closing arguments are designed to assist you. They are not evidence. The evidence also does not include any statements that were stricken by the court or that you were instructed to disregard. You must not speculate as to why an objection was sustained to any question or what the answer to that question would have been, because these are questions of law that rest solely with the court. Likewise, you must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. These statements must be treated as though you never heard them. You are the judges of the facts, the credibility of the witnesses, and the weight to be given to the testimony. To weigh evidence, you must consider the believability of witnesses, and to do this, you will use the tests of truthfulness that you use in your daily lives. These tests may include the appearance of each witness upon the stand, the witness's manner of testifying, the reasonableness of the testimony, the opportunity the witness had to see, hear, and know the things about which the witness testified, and the witness's accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use the criteria that you believe to be most appropriate and assign to each witness such weight as you think proper. There can be a natural tendency to assign less credibility to a person because they do not look like you, talk like you, or worship at the same sort of place that you do. Or perhaps more credibility if they are the same race or gender as you. We talked about this in jury selection, what we call implicit bias. Make sure when you're deciding any of the issues in the case, including credibility, that you are aware that this may unconsciously be part of your thought process, and you should check yourself to make sure that your decisions are not based on race, religion, gender, disability, or sexual preference. You are not required to believe the testimony of any witness simply because the witness was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to decide what testimony to believe and what testimony not to believe. The testimony of one witness, if believed by you, is sufficient to prove any disputed facts. You are to weigh the testimony of the defendant by the same criteria that you use to evaluate the testimony of any other witness. Evidence was received that the defendant may have been incarcerated for an offense that is completely unrelated to these charges. That evidence was only received for a limited purpose. It was not received, and you may not consider it, to prove his character in order to show that he acted in conformity with that character on the day that this happened. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects in the same condition or whether or not they accurately depict what they purport to be. You will determine what weight the exhibits should receive in light of all the evidence. It may be that not all of the exhibits that were referenced during the trial were admitted into evidence. You are not to draw any inferences by the fact that some of the evidence may not have been admitted. You will have with you in the jury room the recorded exhibits and a computer without internet access with which to play these recordings. You shall consider whether the recording is a true record of what transpired at the time it was taken. If you find that it is, then you will determine what weight, if any, the recording should receive in light of all the evidence. If you're unable to play the file on the computer and you wish to view it, please contact Ms. Kuroko. She can help you with any of the technical aspects. The defendant is charged in count 1 with felonious assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about July 23, 2024, in Warren County, Ohio, the defendant knowingly caused serious physical harm to Owen Sekema. A person acts knowingly, regardless of purpose, when that person is aware the person's conduct will probably cause a certain result or be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all the facts and circumstances in evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of the defendant an awareness of the probability that the defendant knowingly caused serious physical harm to C.O. Sekema. Cause is an essential element of the offense. Cause is an act which in the lost my place here, hold on. Cause, an essential element. Cause is an act in which, in a natural and continuous sequence, directly produces the serious physical harm and without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act. The defendant is also responsible for the natural and foreseeable results that follow in the ordinary course of events from the act. The state of Ohio not need prove that the defendant intended to cause the specific harm that resulted, but it must be established beyond a reasonable doubt that the harm that resulted was a natural and foreseeable result of his actions. Proof of motive is not required as to the issue of whether or not the defendant acted knowingly. Serious physical harm means any of the following. Number 1, any physical harm that carries a substantial risk of death. 2, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. 3, any physical harm that involves some permanent disfigurement or that involves some temporary serious disfigurement. And 4, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged or intractable pain. Physical harm means any injury or illness or other physiological impairment regardless of its gravity or duration. In counts 2 and 3, the defendant is charged with assault. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about July 23, 2024, and in Warren County, Ohio, the defendant knowingly caused or attempted to cause physical harm to the victim, a corrections officer in a state prison. Count 2 relates to CO Sycamore. Count 3 relates to CO Roman. The terms knowingly cause and physical harm have already been defined for you, and you will use those definitions for these counts as well. An attempt occurs when a person knowingly engages in conduct that, if successful, would result in physical harm. If you find the defendant is guilty of either or both of these counts, you will continue your deliberations and determine whether or not 3 additional elements have been proven beyond a reasonable doubt. 1, whether the assault took place in or on the grounds of a state correctional institution. 2, whether or not the victim of the offense is an employee of the Department of Rehabilitation and Corrections. And 3, whether or not the offense was committed by a person incarcerated in the state correctional institution. If you find the defendant not guilty on either of those counts, you do not need to make these additional findings. The defendant is charged in count 4 with strangulation. Before you can find the defendant guilty, you must find beyond a reasonable doubt that on or about July the 23rd, 2024, and in Warren County, Ohio, the defendant knowingly created a substantial risk of serious physical harm to Casey Romine by strangulation or suffocation. The terms knowingly cause and serious physical harm have already been defined for you. You will use those definitions for this count as well. Strangulation or suffocation means any act that impedes the normal breathing or circulation of the blood by applying pressure to the throat or neck or by covering the nose and the mouth. Substantial risk means a strong possibility as contrasted with a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. The defendant has raised the issue of self-defense. Generally, a person has the right to assert self-defense as an affirmative defense to charges such as these. However, because the defendant is an inmate in a state correctional facility, the rules are a little different, and the standard for establishing self-defense is heightened. Ohio law imposes upon a corrections officer a duty of reasonable care to provide for the health, care, and well-being of an inmate. A corrections officer is permitted to use reasonable force to control an inmate or to respond to resistance by that inmate. An inmate has no legal right to resist reasonable force. An inmate does have the right to resist and to act in self-defense to reasonably defend himself against excessive force. Force means the exertion or application of any physical compulsion or constraint. Reasonable force means force used in accordance with the following guidelines. 1, a corrections officer may use a small amount of force as may be necessary to restrain, guide, support, or direct an inmate or to apply handcuffs, waist or leg restraints in connection with accepted procedures of transport or movement. 2, amount of force, a corrections officer considering the use of force shall evaluate the need to use force based on the circumstances as known and perceived at the time it is considered. 3, a corrections officer may use force only to the extent deemed necessary to control the situation. The corrections officer shall increase or decrease the level of force as resistance increases or decreases. A corrections officer should attempt only to use that amount of force reasonably necessary under the circumstances to control the situation and shall attempt to minimize physical injury. And finally, 5, force or physical harm shall not be used as punishment. There are 6 general circumstances under which a corrections officer may use force against an inmate. 1, self-defense from a physical attack or threat of physical harm. 2, defense of another from physical attack or threat of physical attack. 3, when necessary to control or subdue an inmate who refuses to obey prison rules, regulations, or orders. 4, when necessary to stop an inmate from destroying property or engaging in a riot or other disturbance. 5, prevention of escape or apprehension of an escapee. Or 6, controlling or subduing an inmate in order to stop or to prevent self-inflicted harm. Excessive force means an application of force which is greater than reasonable force, either by the type of force employed or the extent to which such force is employed. If you find the defendant was subjected to reasonable force only, then you are not to consider self-defense. However, if the defendant was subjected to excessive force, you may consider self-defense. If you find the defendant was subjected to excessive force, the state of Ohio must prove the defendant did not act in self-defense by proving beyond a reasonable doubt at least one of the following elements. 1, the defendant was at fault in creating the situation, giving rise to the use of excessive force by the corrections officer. Or 2, the defendant did not have reasonable grounds to believe that he was in immediate danger of being subjected to excessive force. 3, the defendant did not have an honest belief, even if mistaken, that he was in immediate danger of being subjected to excessive force. Or 4, the defendant used unreasonable force. In deciding whether the state of Ohio has proved beyond a reasonable doubt that the defendant did not act in self-defense, you need not be unanimous as to which of the elements were proven, so long as each juror has concluded the state of Ohio has proven beyond a reasonable doubt at least one of them. In deciding whether the defendant had reasonable grounds to believe and an honest belief that he was in immediate danger of being subjected to excessive force, you must put yourself in the position of the defendant with his characteristics, knowledge, or lack of knowledge, and under the circumstances and conditions that surrounded him at that time. You must consider the conduct of the victims and decide whether their acts and words caused the defendant to reasonably and honestly believe that the defendant was about to be subjected to excessive force. Substantial risk means a strong possibility, as contrasted to a remote or even a significant possibility that a certain result may occur or that certain circumstances may exist. Words alone do not justify the use of excessive force. Resort to excessive force is not justified by abusive language, verbal threats, or other words, no matter how provocative. An inmate is allowed to use force that is reasonably necessary under the circumstances to protect himself from an apparent danger of excessive force. If you find the state of Ohio proved beyond a reasonable doubt that the defendant used more force than reasonably necessary and that force was greatly disproportionate to the apparent danger, then the state of Ohio proved beyond a reasonable doubt that the defendant did not act in self-defense. If you find the state of Ohio proved beyond a reasonable doubt all the essential elements of each count and the state of Ohio proved beyond a reasonable doubt that the defendant did not act in self-defense, you must find the defendant guilty. If you find the state of Ohio failed to prove beyond a reasonable doubt any of the essential elements of each count, or if you find the state of Ohio failed to prove beyond a reasonable doubt the defendant did not act in self-defense, you must find the defendant not guilty. The charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the claim of self-defense as to that count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of one, all, none, or any of the offenses charged. I've instructed you on the law necessary for your deliberations. I will now instruct you on how to conduct your deliberations and prepare the verdict forms. You will have with you in the jury room the following verdict forms. I know you can't see them from there, but they look like this. They have the caption of the case, State of Ohio versus Thornton Thomas, and then each of them have a label here. Verdict 1, this is Form 1, felonious assault. It says, we, the jury, in the above captioned case, find the defendant, Thornton Thomas, and they have two choices, either guilty or not guilty on the charge of felonious assault. Circle the one that matches your verdict, scratch out the one that does not match your verdict, and there are blanks for all 12 of you to sign, and you need to sign in ink. The second one is for assault, count 2. This count 3 look pretty much the same. We, the jury, in the above captioned case, find the defendant, Thornton Thomas, again, either guilty or not guilty, on the charge of assault on CO Sigma. Count 3 is on CO Romine. Then you have 3 additional findings to make in the event that you find the defendant guilty regarding whether it took place on the grounds of a corrections facility, whether or not the victims were Department of Rehabilitation and Corrections employee, and whether or not the defendant was incarcerated in a state institution. Finally, count 4, which is strangulation, just says we, the jury, find the defendant, Thornton Thomas, either guilty or not guilty of the charge of strangulation. When you have reached a verdict, you will complete the verdict form that corresponds with your verdict and sign the verdict form in ink. You must make all your decisions free from any sympathy or prejudice, nor should your deliberations be influenced by any consideration of race, sex, religion, national origin, age, or disability. It is your duty to carefully weigh the evidence, to decide the disputed questions of fact, and to apply the instructions of law to your findings and render your verdict accordingly. Your duty as jurors is to arrive at a just verdict. Consider all the evidence and make your findings with intelligence and impartiality and without bias, sympathy, or prejudice, so that both the state of Ohio and the defendant will feel that their case was fairly and impartially tried. If during the course of the trial I did or said anything that you believe to be an indication of my view on the facts, you are instructed to disregard it. Because this is a criminal case, it is necessary that you have a unanimous verdict. That means all 12 of you must agree in order to bring a verdict back into this courtroom. You may not discuss or consider the issue of punishment. Your duty is confined to deciding whether the defendant is guilty or not guilty. In the event that you make a finding of guilty, the duty to decide punishment is by law placed upon the court. When you go into the jury room, the first of your functions will be to select one of your number to serve as a foreperson. The person that you select to preside over your deliberations does not have any greater power, nor does that person's vote have any more importance than the others. The foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each of you the opportunity to express your opinion. The foreperson also has the additional duties of making sure the verdict forms are filled out properly and being sure that the blinds are closed during deliberations. In case it matters, you should know that it is not the responsibility of the foreperson to read the jury verdicts. After they are returned, I do that. Your initial conduct upon commencing deliberations is important. It is not wise to immediately express a determination or to insist upon a certain verdict, because, having so expressed yourself, your sense of pride may be aroused and you may be hesitant to change your position even if it's shown that it is not correct. Consult with one another in the jury room and deliberate with the view of reaching an agreement if you can without disturbing your own individual judgment. Each of you must decide this case for yourself. You should do so, however, only after a discussion of the case with your fellow jurors. Do not hesitate to change an opinion if you become convinced that it is wrong. However, you should not surrender your position simply to be congenial or to reach a verdict based solely on the opinion of the other jurors. Deliberations may take place only when all 12 jurors are in the jury deliberation room together and with no one else present. Should any juror leave the room, all deliberations must cease until all the jurors are together. During breaks, you may not discuss the case with anyone, even your fellow jurors. It may be difficult to remember all the evidence or the law. If you disagree about the evidence, you should try to resolve the issue based on your collective memories. If you disagree about the law, refer to the written jury instructions, which you will have with you in the jury room. If you are still unable to resolve the issue, the court may, under certain limited circumstances, furnish this information. If you have a question, it should be reduced to writing so there is no misunderstanding as to what you request. Then deliver the question to the bailiff, who will submit it to the court. Do not include the status of your deliberations in any question that you might submit. Except for those terms specifically defined in the instructions, you will use the ordinary, usual, and customary meaning for those terms. Ms. Lee, an alternate does not participate in jury deliberations unless one or more of the other jurors is unable to complete their service. Thankfully, this has not happened. But I am going to retain you as an alternate juror in this case. Ms. Karolko will get your contact information. We will get in touch with you if you need to return. Otherwise, you will be discharged. You are still bound by all the previous instructions. Do not discuss the case with anyone or permit anyone to discuss it with you. You are not to disclose to anyone how you would have voted. When the case is over, Ms. Karolko will advise you of the verdict and you will be released from these instructions upon your discharge. We only have a few more minutes of instructions. Ms. Karolko will see you out while the jury is getting settled. On behalf of the public and the parties, the court expresses appreciation for your services in performing this important public function. After your verdict is returned and your jury service is complete, you may discuss the case with anyone, but you are not required to do so. Whether you discuss the case with counsel, the press, if there is any, or anyone else after you are discharged is a matter of your own free choice. The court will place in your possession the exhibits and the verdict forms. The foreperson will retain possession of the exhibits and those records, including the verdict, and return them to the courtroom. Until your verdict is announced in open court, you are not to disclose to anyone the status of your deliberations or the nature of your verdict. Ms. Kuroko is going to collect your cell phones, smartphones, etc. Keep them during deliberations. If there is a pressing need to contact home, let us know that, and we will try to work something out. Make sure that we turn these devices off when you give them to the bailiff. Mr. Kraut, this does not apply to you because I assume you will need your phone to adjust your hearing aids. Just make sure there is no communication with anyone during the time that you are deliberating. Does counsel desire any further instruction at this time?
No, Your Honor.
No, Your Honor.
After you retire, select a foreperson, and all 12, I repeat, all 12 of you agree on a verdict. You will sign the verdict
12,
form
huh?
in ink
All
and
12.
advise the bailiff. You will then be returned to the courtroom. Make sure that you do not begin deliberating until all 12 of you are in the jury room, the door is closed, and the blinds are down. Ms. Kuroko, you can take the jury out.
All the lights are on and the blinds are down. What song is that? What song is the all the lights are on and the blinds are down? It's the only part I can think of. Somebody help me. All right, the jury leaves with a set of instructions and a packet, including the verdict forms. When the door shuts, we start the timer. Sounds like a Shaggy thing.
You may be seated. We're on the record outside the presence of the jury. Anything additional from the state?
No, sir.
Mr. Engel?
No, Your Honor.
All right, make sure that Ms. Kilgore has the exhibits and that she gets your cell phone if you're not going to be in the immediate vicinity of the courtroom. We're in recess.
All right, while they go in recess, we're going to jump to another trial. Yes, because we're falling behind in the Daisy Link trial. We're going to keep this going with audio as well, I think. Give me a minute to get the screen the way I want it. Super Source 1. Make this a little bit bigger. We're going to get rid of the thousandth of seconds. Just slide this over like so. And down just a teensy bit. Probably make it bigger. Okay, there's our verdict clock. We'll keep this running for a little bit. No spoilers. No spoilers. Please, no spoilers about the Daisy stuff. We want to catch up. But we will have to go. Where are we at? 7. That's 5, 7. There we go. We have got a lot to catch up on. A whole ton. Because they started early this morning. So let's go full screen here. We've got make sure we've got audio. We do. And let's go. Super Source Box 2 is going to be 7. There we go. This was this morning. We are a couple hours behind. We need to probably do some catch up.
She gave the name of Angel Wilson. Prior to any of that happening, I think it was Friday morning, the defendant said that these officers were talking to her, they weren't supposed to be, and she used the word they coerced. Mr.
God, starts off with spice.
Were
Nice.
in my office yesterday to conduct depositions. He and I were having a conversation where I mentioned I'm likely going to be calling Detective Wilson in rebuttal if the defendant takes a stand. He says something to the effect that they were saying things to me, they were trying to push me and convince me to waive Miranda. So I got Detective Wilson's phone number, I reached out to her, and Mr. Tomas was actually in my office, and I confirmed her availability at that time. A few hours later, as I was preparing for today, I called Detective Wilson and asked her kind of what the process was of everything. Terrible. And she's seen on that interview as well. Detective Wilson advised me that at a point in time, both her and Detective Janoris took the defendant to the bathroom. Her and Detective Janoris, because Detective Wilson was shadowing at this point. She was a domestic violence detective at that point, and she was shadowing both robbery and homicide to see if she wanted to go to either of those units. They're having a conversation about where Detective Wilson is, what she wants to do, etc. The defendant is in the bathroom stall at this point in time, comes out, washes her hands, and goes to Detective Wilson. It says something to the effect, I don't remember she doesn't even remember the exact words, but she says, oh, you're a domestic violence detective, starts inquiring about that, and then says, I'm a victim of domestic violence. Detective Wilson at that point in time puts her hands up, motions to Detective Janoris, and says, you need to tell them, not me, you need to speak your truth to them. The best I can surmise based off of the timeline and everything else, and also her deposition yesterday, which was taken. This is prior to even the first Miranda being read, in which the defendant invokes. I turned that over to Mr. Tomas yesterday, probably around 2 o'clock, I think, and then we ended up taking Detective Wilson's deposition around 3:30 yesterday.
Okay. Well, what's the ask for the Richardson?
Because I turned over a defendant's statement.
Oh, I'm sorry. You're saying
I violated
you turned over late.
Correct.
I violated it.
All right. Do you want to respond? He's saying it's late when he found out. It sounds like he found out about it yesterday and turned it over upon finding out about it.
Yes, Your Honor.
So the issue is willful inadvertence. Will be prejudiced in any way at this stage? What the state is saying is this domestic violence detective came in contact with this link even before the statement was turned over. So her identity.
Yeah, it's fine. I'm not necessarily seeking to exclude her at this point.
Okay, so we've done the Richardson.
I just wanted to make sure we did that before we did anything else.
All right, so it's inadvertence at this stage because everyone's on notice as to this Detective Wilson being a domestic violence detective and coming into contact with this link. The defense is not prejudiced.
Judge, we don't have to address it right now, but there was another witness that I deposed yesterday, which I believe what he would testify to is outside of the window of what you've already said was relevant as far as previous bad acts. So we can address that now or later. I want to put that on the record.
If I were to call him as a witness, it'd be for rebuttal, and we can address that at another time.
My understanding is the only thing that the state wants to go forward on today for case in chief is based on their motion for reconsideration of the jail call, right?
So we also are calling Detective Cruz just kind of to piece the timeline together. His testimony shouldn't take too long.
All right. Yes. Anything else you want to put on the record other than what's in the written motion for reconsideration?
I'll let Ms. DeLeon handle that.
I read the motion. Anything additional you want to put on the record?
Judge, good morning. ASA Jennifer on behalf of the state. And Judge, I have copies of the case law that I cited. It's the coordinated printed copies. Judge, the only thing the state would want to supplement to this motion is that it's imperative, Judge, to allow this jail call, not only to show consciousness of guilt, Judge, but I think that it's essential for this jail call to prove also it goes to the elements of our crime. Specifically, Judge, to the fact that this defendant lied to 911, Judge. She lied to responding officers. She lied to more than one officer that arrived on scene, acting like she didn't know what was going on, how he got shot, who shot him. It's imperative, Judge, to show as to the depraved mind element to our case in chief that she did this with that intent and depraved mind, because the jail call specifically says, had I known, basically, essentially, in the sum of it,
had I known what?
How much, Judge? She said 25, and Judge, I can play it for you so you can hear it word for word.
I accept the prop. Had I known, essentially what the offer would have been, I would have.
No, so she goes, Judge, it's specifically like this. She goes 25. 25
means what?
25 years, Judge. 25, I would have cut that motherfucker up, and I would have scattered him all over Florida. It's essentially what the call entails. She doesn't say had I known, quote unquote. It's just a sum of what basically the state was saying. And it's an additional admission as well, Judge. That's what the state would like to supplement to its motion. And I think it's imperative, Judge, I understand you accept my proffer to report. I think it's imperative that you hear the portion that the state wants to play so that Your Honor can hear the context of it as well.
I accept your proper. Do you want to respond?
Judge, I think you conducted the proper legal analysis last week. You made your ruling. Nothing in the state's motion adds any light to that. There's no case law that supports their position. You've made your ruling. They've given you nothing that to give you any reason to reverse your ruling, so I'd ask that you keep it.
Anything else you want to add?
Up to defense's argument, Judge,
This is the way it goes. You first, and second, and third. Anything else you want to add?
well, just to defense's final point that there's nothing in the case law that supports our position. On the contrary, the case law that I cited in the motions support our position.
The motion for reconsideration is denied. The statement's not coming in, / the alcohol. It's more prejudicial and probative. It also goes to a discussion on the breakdown of plea negotiations, as opposed to 3 years later, as opposed to what she was thinking at the time that the quote unquote trigger may have been pulled. All right. Your objections are on the record. The next thing I have is
They're trying to get all this stuff sorted out before the day starts in the Daisy trial today here.
Miss Link's mother and Miss Link's son are actually here. I didn't know this until late last night. They were jumping on a flight. So I haven't seen them yet, but I believe they're right outside.
Okay.
So the mother, the son, her sister, and her cousin are there, so they're ready to testify. David Perez, no. He's refused, so and that's why I asked the court to compel his appearance.
No, nice.
What else do you need from me?
Well, Judge, he's not even a witness, and you don't have jurisdiction over him.
No, hold on. Before I rule on your motion to exclude him permanently, at some point they had contact with him in the last 2 days, right?
Yes.
After he ignored you, I excluded him without prejudice. You reestablished contact.
Right. So I took 2 depositions yesterday. The state had set him for deposition yesterday. I had contact with him. He agreed to appear yesterday, and then the evening before, Sunday evening, he, without giving me any reason, he just said, "I can't make it, sorry."
Busy
and
today.
I advised him, "You're on probation. I can ask the court to compel your attendance. I don't understand what you're doing. Just come, get it over with, and you'll be done." And he just said, "Do what you have to do. Goodbye." And that was the last call.
He lives locally.
Yes. He's on probation in Miami-Dade County.
To the extent that we know he lives locally, because as I mentioned, I don't mean to interrupt, but as I mentioned about a week ago, 2 weeks ago, whatever it was, we attempted to take his deposition. At the time, he said he was at work, and I believe he was either in Fort Myers or Fort Pierce. He has a local address, but that does not mean that he lives locally.
Wow, it's getting spicy today.
The travel individual. The crux of his testimony is really for the incident that happened 5 days prior.
That is correct.
And you would corroborate the argument, the battery, as well as be able to authenticate the photographs of her injury?
Correct. And Mr. Jimenez attacked him as well.
Would any other witness here corroborate what David Perez would testify to?
Pedro Jr. can, and obviously Ms. Lund can if she testified.
So
the mother was not there when the pistol whipping incident happened. The mother was at the home a few hours before Mr. Jimenez died, and the mother did witness interactions between Mr. Jimenez and Ms. Link shortly before she left, which she left a couple of hours before the shooting, and she did witness Mr. Jimenez grab her and be aggressive and violent with her.
So I think we need to address Pedro Jr. He is not a witness right now, and there are a number of different steps before we can even get him to be reestablished.
He's only 9, right? Pedro Jr.
Reconsiders whether or not he can testify. I have to take his deposition. If this court recalls, a few weeks ago, I got on a plane. I went to Dallas. I was at the location that we all agreed upon the deposition was going to be taken. And then Ms. Perez, the defendant's grandmother, this witness's quote-unquote witness, because he's actually been excluded at this point in time, refused to provide him for deposition. I still need to take his deposition, which will take a significant amount of time. The rules are pretty clear when it comes to child witnesses.
rule 92.55. I was wrong, there's no per se exclusion.
No, but the court has to, they need to be deemed competent. So the court needs to have an inquiry whether or not this individual is competent. I don't know the rule offhand, but I'm proffering to the court as an officer of the court.
No, I brought it up and now I can't find it. So it has to do, I mean, I look at the rule regarding testimony of witness under 18, but it really has to do with whether or not you all have noticed something in the witness. And then I can further in.
I don't know, because I've been unable to take this deposition of this quote unquote witness because he's not even a witness here. I have literally been precluded by the defendant's family from inquiring from this potential witness, which then there is further investigation that needs to be done. There's a reason that depositions don't happen in the middle of the trial, right? It's because there's further investigation that needs to be done. There's further witnesses sometimes that need to be brought in and questioned. There's other photographs, videos, etc. of all these other things.
How long are they here?
I don't know. They just got here. I think they're here at least until this matter's over.
And we need to do that. Then the court needs to make a determination whether or not this person is competent to testify, which in the defendant's statement, she says that he's on medication. He has a behavioral disorder.
What other witnesses do you have here that might testify besides those two?
3 others.
So Crystal?
Crystal, Laylene, Josefina.
Did you depose any of them?
I took all 3 of their depositions, yes.
Okay.
And I think that, I know we're kind of doing different things at different times, but I think that the court is
I'm just trying to not waste this jury's time. Allow you to depose Pedro Jr., but the other 3 sounds like you've already deposed.
Right, but what I'm saying is I think for each of those witnesses, the court is going to have to give specific limiting instructions on what they're able to testify to based off the court's prior rulings.
Okay.
Because I don't want, I think that we are, based off deposition of at least one of the 3 of those witnesses, we are going to come very close to this one of the witnesses, and I'm speaking about Josefina Perez, rolling this entire trial off.
Who would you call after the proves?
Judge, I would call Crystal and Laylene. I'd like to have a little bit of time before I call Josefina, I have similar concerns, but I believe I can be under control, but I just would like an opportunity to speak to her for a few minutes.
And after Cruz testifies, you can get in at least one of them before lunch and call.
Certainly.
Sure.
Am I just bringing them in after you rest, or you want me to talk to either Crystal or Lee?
I think that you should bring them in as they get called. And, the additional part of this is I have reason to believe, based off of the emails that were sent to Mr. Tomas forwarded them to both Your Honor and myself, that there has been violations of the rules of sequestration based off of the email that Josefina Perez sent to Mr. Tomas saying, I've spoken to Crystal, I've spoken to Leyland, I have attempted to speak to David to convince him to come and testify. I have concerns that they have been violating that rule. And that's further, corroborated by the fact that Crystal Barreto was actively trying to log in the Zoom during the trial, despite the fact that we had already invoked that rule. I think that there are issues here, and I think that the court needs to instruct them individually.
Okay, so why don't we do this? Can you bring in Ms. Perez so I can tell her not to leave the jurisdiction?
Josefina Perez?
Yeah.
Yes.
Not to leave the jurisdiction.
1 moment.
With the child until I say she can.
They're bringing in the defendant's grandmother, who has the Pedro Jr. as in her whatever possession. So she's the custodial parent at this time for Pedro Jr., the defendant's son. The judge is going to tell her not to leave the jurisdiction with Pedro Jr., I believe. She's the guardian. Yes, there's the right word. Lots of spice this morning. Lots of spice to kick this off. There's mom or grandma at least. I'm not sure why they muted this.
back and forth. I've been informed by
Yeah.
Mr. Moss. You told him you had some challenges getting here, but now that you're here, you cannot leave Miami-Dade County until I tell you to do so. I'm not the great and powerful Oz. I'm not trying to bring down a hammer on anyone. He's been working very hard to put together a defense. It would be unfair to him and your daughter. So I'm telling you, don't leave Miami-Dade County, and that's a court order, okay?
Madam Honorable, I will be more than happy to stay. I won't do that. I just leave.
I'm gonna try to see if you all can't testify today. If that's not possible, then tomorrow, okay?
Very good.
But I don't anticipate me ordering you all, meaning you and Pedro Jr., to stay here past tomorrow, okay?
Your Honor, but we can go outside and things like that, correct?
Oh,
so
yes, you can. If you recognize anyone that's a juror, they usually have a little card on them. Ignore them.
Okay.
Please don't talk about the case.
No, I won't.
In the vicinity of anyone, just in case there's a witness lingering around that you don't like that you don't recognize it. That sort of makes sense, right?
Correct. And we just got here at 5, so I want to see if I can get him something to eat before he even comes in. He's so tired.
That's fine.
Okay.
You just stay in contact with Mr. Gallant so that he knows where you are.
Yes, ma'am.
Because I think there's a possibility that either you or Lelaine.
So I'm probably going to call Laylene and maybe Laylene and Crystal before we break for lunch. So I just need them to stay where they are. Oh yeah, take Pedro to eat something.
All right,
Yes,
thank you, Your Honor.
Something.
That's it?
Yeah, that's it.
Okay, thank you.
All right, Pedro gets to go to lunch. Mom and Pedro and everybody has to stay in the county. Defense might call them today.
Yeah, we can do JOA.
Still have the judgment of acquittal.
The
The state still has to arrest officially in front of the jury.
Yes. Yes.
All right, let's bring in second, please.
Now we've got a detective coming
Yeah.
in. And the jury.
Mr. Tomas, the state gave me another statute to look at when you stepped out for 2 seconds to go get this done. Whereas it's 90.603.
The state needs to arrest officially in front of the jury. They haven't done that.
906.
Apparently we're renovating the courtroom this morning. We're just demolishing it. Holy cow. Top right hand corner, we do have the trial out of Warren County, Ohio. We're watching the live feed there. Live feed with the counter on the verdict watch in the bottom right hand corner. Okay, court clerk has finished smashing all the IKEA furniture in the courthouse. And now we turn the mics off. Thanks. Send a hush to the court. Hush! Trying to hold court. All right. Because we can zoom on this one. So give me just a second to do just that. Let's see. 3 is 4. There we go. Let's zoom just a tiny bit. Oh, wait. That's 2. Okay, that's the wrong one. I need to do this one. Just rewound. It's just awesome. Okay. 7. You guys can't see it, can you? Here you go. This is one of our state prosecutors setting stuff right on the microphone there. I think we have a detective who's being either brought in or is on the stand right now. Everyone's walking around.
Yes, thank you, sir.
That's him.
Hey, John. Do you swear from the testimony about to give or the truth, the whole truth, and nothing but the truth?
Yes, sir.
Over here.
He was just wandering around the courtroom. Now he's in the witness stand.
Good morning, Detective.
Good morning.
Can you please state your name for the record?
My name is Joseph Cruz.
Okay. And Mr. Cruz, where exactly do you work?
I'm a sergeant in the Miami-Dade Sheriff's Office Robbery Bureau.
Okay. And how long have you worked with the Miami-Dade Sheriff's Office?
Approximately 18 years.
So I want to take you back a couple of years to around June 25th of 2022. What was your job and your role at that time?
I was a homicide detective with the Miami-Dade Police Department at the time.
Okay. And around that time, on June 25th of 2022, did you become familiar with the case involving the defendant, Daisy Lynn?
Yes, sir.
Okay. How did you become involved with that case?
I was contacted by Detective Morales.
Okay. And were you given a rundown of the situation, or did he just call you to say, come out to the scene?
No. He called me and told me that a homicide had occurred within the city of Homestead.
Okay. Now, you're with the Miami-Dade Sheriff's Office, right? You're not in Homestead.
No, sir.
Why? How does that work that you're going down there then?
Miami-Dade Police Department, or now the Sheriff's Office, is contracted by some of the smaller municipalities, and we handle certain types of investigations for them, and homicides is one of them.
Okay, so when you end up getting this call to go to Homestead, do you ever go to the actual scene itself, or do you just stay in the office?
No, I responded to the scene.
Okay, was that scene 1237 Northwest 14th Street, Homestead, Florida 33030?
Yes, sir.
Is that in Miami-Dade County?
Yes.
Okay. Now, what time did you first arrive to the scene?
I arrived at approximately 6:30 a.m.
Okay. Now, that's not when this incident occurred, though, right? 6:30 a.m. That's 20 hours after this incident had initially occurred.
Yes, that's correct.
No, how many hours?
Oh, I'm sorry. Approximately 3 hours.
Okay. So, when you're first getting to the scene, though, okay, you're telling us it's around 6:30. Do you have any team with you, or are you just by yourself?
No. When we respond to homicides, we respond together as a team.
Okay. Now, who's on your team with you for this case?
For this case, it was Detective Suyapa Hubbard, Daniel Morales, and Melanie Janoris, and Sergeant Jason Waite.
Okay. Now, as you're here with this team, are they all there with you at the same exact time, or are you there by yourself first?
I believe when I got there, I was by myself initially.
Okay. Were you determined at any point in time to be the lead investigator here in this case?
Yes, sir.
Okay. So how does it work in a homicide team as a lead investigator? What are you doing?
In homicide, there is a internal rotation, which determines whether you're up as the lead investigator or not. As a lead investigator, my role is to direct the other detectives to handle certain responsibilities, which I determine need to be done, such as obtaining search warrants or documenting crime scenes, possibly interviewing certain witnesses and subjects.
Okay.
That line of questioning
Now,
took 2 hours at the
as
Caribbean
the
trial.
lead, whenever if any type of evidence or anything is discovered, are you being informed of this, or are you kept in the dark?
No, I'm being informed of it as the case is progressing from start to finish.
So anytime something's discovered, you're being informed of it. You're being informed of it immediately, then, right?
Yes, sir.
Okay. Does that include whenever someone gets a statement from a potential witness,
Yes.
where they speak with someone?
Yes.
So then, essentially, as the lead, everything is being funneled through you, then.
Yes.
Okay. So I want to start from the beginning of this case, then. You're aware that there was a phone dump of the defendant's phone here in this case, correct?
Yes, sir.
And were you aware, and did you review any Ring camera videos that were captured and recorded on that phone?
Yes.
Let's go sidebar real quick.
Judge calls an audible and goes sidebar. Turn this one off. All right, I'm trying to fast forward through all these sidebars if we can because we are on catch up. But it's tricky. I have to go here. Skipping ahead. Okay, there we go. And we're back.
Okay. So when you went over this actual phone dump, did you happen to see, while you were reviewing it, what time it indicated the actual Ring camera footage was created?
I don't recall.
Okay, while that's getting pulled up, we'll revisit it in a few minutes.
Are we going to wait a few
You
minutes?
got permission for the witness to step down? So I'm now showing you a still shot from the actual phone, from the phone dump itself. Do you happen to see the defendant here in this video?
Yes.
Okay. And is that the only person that we see in this picture?
Yes.
Okay. Now, on the right-hand side, does this video have any type of date or time that this was created?
Yes.
Okay. What time does it state that it was created at?
3:06 a.m. on June 25th, 2020.
You can listen.
3:06.
So, we know the video started at 3:06 then, off of what you just stated. After reviewing the video, at any point in time, did you ever hear a gunshot in that?
Yes.
About how long into that video did it take before you heard that?
Approximately 5 minutes.
Okay, so what time would that put that then, when you hear the gunshot then, if you're comparing it to 3:06 a.m.?
I believe about 3:11.
Now, after hearing that the gunshot was at 3:11, do you happen to know when first responders were dispatching officers or fire rescue to the actual scene of the crime?
Yes.
At what time did that occur?
That was around 3:23 a.m.
So there was about a 12-minute gap between the shot and the 911 call then, right?
Yes, sir.
Now, do you happen to know at what time the first responding officer appeared and found the victim in the alleyway?
That was approximately 3:27 a.m.
And at what time was the victim declared deceased?
At 3:40 a.m.
So, now while all of this is going on, you said you arrived at 6:30 a.m., correct?
Yes, sir.
What's the first thing that you did when you arrived on the scene?
I spoke to Officer Nicholson.
And why did you speak with Officer Nicholson?
It's a standard procedure that we do in homicide, just to speak to the first arriving officer on scene to see what they saw and what information they gathered when they first arrived.
Do you happen to remember the time you actually spoke with Officer Nicholson?
Maybe it was 6:33.
Okay. And then after you speak with him and get that information, where does your investigation take you to next?
When I was done, I spoke to Officer Rodriguez next.
Okay. Now, what's the importance of speaking to Officer Rodriguez? What role did he play?
He was another officer arriving on scene. So I had spoken to him to see if he had his body-worn camera on or if he had heard or seen anything else when he arrived.
So was that around the same time that you spoke with Officer Nicholson then?
Yes.
So we could put that around 6:33 then, around that time?
Yes.
Okay. Now, does your investigation just stop there or do you do something else?
No, sir.
What do you do next?
I briefed the homicide team. They had arrived, and that was at approximately 7:05 a.m.
Okay. Now, when you're briefing the homicide team, is that just assigning roles, or what are you doing?
I brief them on whatever facts of the case I had obtained at that point, and then I also assign leads.
Okay. Now, after you assign everybody their roles and you brief your homicide team, where do we go next?
I actually went around the scene to take a look at it, to see what evidence was on scene, any type of casings, and take a look at the victim who was deceased in the back alleyway.
I fixed the
So you did a walkthrough of the actual property itself?
There's a new link.
Now, when you're looking around the home, do you remember if you found any type of firearm or any bullet casings?
At that time, no. I didn't see any.
Okay, so you couldn't see anything with your eyes where there was any guns or anything, right?
No.
Okay. Could you see anything with your hands?
So after your search of the area, do you continue to stay there on the scene, or do you go somewhere else?
No, I left and I went to our headquarters bureau, our headquarters.
Okay. And why are you going to the headquarters?
The defendant, Ms. Link, was transported there, and I responded as well with Detective Janoris, so that way we can speak to her.
And at what time was that at?
I believe that was approximately 8:28.
In the morning?
Yes, sir.
Okay. Now, when you're going over there to that headquarters then, do you happen to know if Ms. Link was in handcuffs or already arrested at that time?
No, she wasn't arrested, but she was detained.
Okay. So was she a suspect at this time?
Yes, she was.
But she was not arrested?
No, sir.
Okay. Now, you're on your way at around 8:38 to the actual headquarters. When you get there, do you just jump straight into the interview, or are you doing anything else before?
Usually, well, I know I had made a phone call to the state attorney, and also we have to prep the interview room to turn on the cameras.
Okay, and you did all of those things then?
Yes, sir.
Now, at what time do you actually go into the interview room itself?
I don't recall the exact time.
Would looking at a report that you drafted during this case refresh your recollection?
Yes, sir.
Your Honor, may I approach?
Yes.
Please take a look at the report. Keep your head down. When you're done, look up. Has your memory been refreshed?
Yes, sir.
Okay, at what time did you step into that interview room then?
9:55 a.m.
Now, what exactly are you doing when you're first speaking with Miss Link?
The first thing we do is we present the Miranda warnings.
Were you trying to get any type of background information?
Yes.
And did you get background information?
Yes.
Okay. Now, I want to direct your attention, you're still here at the actual headquarters, correct?
Yes, sir.
At any point in time, are there people at the actual scene working on the scene or looking for any type of evidence that you're aware of? Okay. What's happening while you're inside the interview room then at the scene?
I had asked Detective Siapa Hubbard to document the scene. And I had also asked Detective Morales if he can start working on a search warrant for the residence.
Okay. Now, search warrant for a residence. Was there ever a search warrant for the residence that was granted here?
Yes.
Okay. And that was reviewed by an ASA?
Yes, sir.
And that was reviewed by a judge?
Yes, sir.
And you guys were executing that warrant then at the scene?
Yes.
And you were informed of that execution of the warrant?
Yes, sir.
At what time did that happen?
That was at approximately 12:30 p.m.
Around 12:30? Okay. So during that search of the home and the vicinity, did that team find anything on the property?
Yes.
What did they find?
They found a firearm that was placed inside of a palm tree.
Okay. Now, that firearm, was that found around 12:30?
Yes.
And you were informed of that when that happened?
Yes, sir.
Did they find any type of bullet casings?
No.
Okay. Now, let's jump back over to the interview. When you're speaking with Miss Link, do you remember what her demeanor was like at that time?
She appeared very anxious.
When you guys first got in there, though, what type of clothes was she wearing at that time?
I believe she had shorts and a t-shirt on.
Was there anything that stood out about that clothes?
I believe there's some blood on there.
Okay. And did you guys attempt to give her any type of clean clothing?
Yes.
While she was sitting there in the interview room, at any point in time, did you guys attempt to give her some type of food?
Yes.
Did she accept any of the food?
She declined, sir.
So she hadn't eaten and she didn't get any water. I think she got water.
Now, at any point in time, did you guys begin to fingerprint the defendant?
Yes.
Why do you begin to fingerprint the defendant? What's the reason behind that process?
For major crimes, it's a standard procedure for the Miami-Dade Police Department.
Okay. Do you happen to remember what time that occurred?
No, I don't recall. Can I refer to my report?
Yeah, if that refreshes your recollection, you can look down and let me know by looking back up that you've refreshed your recollection.
No, sir.
Okay, we'll move on to the next question. So, around what time do you begin to start trying to get a statement from Miss Link in the afternoon?
It's around 3:30.
Around 3:30? Okay. Now, what time do you actually enter that interview room to begin speaking with her?
4:20.
So, let's talk about that process right there around 4:20. You enter the room, and what's the first thing that you're doing at that time then?
We had asked her, she had asked if she would like to speak, that she stated that she wanted to speak to us, so then we confirmed, and we read her Miranda rights.
Now, What exactly are Miranda rights?
Miranda was a case law that was passed to protect and advise the defendant or a subject, or anybody being accused of a crime, that they are still entitled to certain protections.
Now, when you go over this information with the defendant, are you just reading this to her, or do you have an actual document there?
It's an actual document.
And did you present that document to Ms. Young?
How is that different from just reading it? Was he just reading
I'm now
the actual
showing
document?
defense has been marked for identification purposes as State's Exhibit 1J. You recognize this?
Yes, sir.
Is this a blow-up of the Miranda form that you read to the defendant?
Yes, sir.
Okay. Is this a fair and accurate representation of that form?
Yes, sir.
State moves to introduce has been marked for identification purposes as State's Exhibit 1J into evidence.
State Exhibit 1J marked by ID will now become State Exhibit number 29.
It's a big one.
So, are these the questions that you go over with the defendant?
Yes, sir.
Okay, so do you have her read these out loud, or do you read them to her?
I have her read it out loud.
Okay. Now, what exactly is the signature in yes or no? Is that the defendant's signature?
Yes.
Okay. Now, if at any point in time she marks no, what do you do?
We would stop.
You stop the investigation?
Not the investigation, we would stop Miranda and stop talking to her.
Okay. Did she mark no anywhere on here when you're speaking with her?
No, sir.
Okay. Is that your signature at the bottom?
Yes, sir.
Is this your partner's signature right above it?
Yes, sir.
And whose signature is over here on the right?
The defendant's.
So once you go over those rights, do you then begin the interview?
Yes.
Deliberations for a verdict have been over 45 minutes now.
Now, at any point in time during the actual interview, does the defendant ever end up describing what the scene looks like to you?
Yes, sir.
Does she make any type of drawings?
Yes.
Are the drawings terrible and small on a lined paper? Yes, they are.
I'm now showing you a demonstrative of what's already been introduced into evidence here in this case. Is that the drawing that the defendant made for you while you were speaking with her?
Yes, sir.
Okay.
Today, June.
So, I'm now playing for you what's already been admitted into evidence as the interview of the defendant. Doesn't have the proper.
State Exhibit number 28.
State's Exhibit 28.
Could try to turn it down a little at the beginning because these get hard to listen to.
So, tell me where your house is. So you don't know how
your house is.
So I have the porch here, with the stairs. So at this point, I'm right here. I grab the gun. Okay. This is the house with a white marble. Okay, so this would be the front of the house. This is the back of the house. And this is the front. This is the front of the house. This is the back of the house. Because the house is side. Okay, that's what you're saying. So this is the door to your duplex, and then this is the door to the other duplex. This is, okay. What's the street? Yeah. Yeah, so that's the street. Okay.
Now, just to get a little bit of orientation, is this the street that she drew out on here when she was describing it to you?
Yes, sir.
So is it better to hold it like this then?
Yes.
I see what you're saying now. Okay. So I'm in the front, I'm in the back of the house. So that's usually where I consider the front, that's usually where I'm going out. Okay. So by that time, I remember once he started taking off, he started running this way. And he said that he was going to run the house and lock me out. Because he was sleep outside, bitch. So I ran right here, I was right here, I saw him right here, and I just shot. I didn't even really aim, I don't even know how I did it, I didn't even aim at him like that, and then I just shot it so he could hear the boom, and then he was scared, run away, and maybe he was asleep in the house. I'm tired of being locked outside, I'm tired of this shit. So as he's running away from you, that's when you shoot. Because he's running to go to someone in the house. Because he's running to go in the house to lock the doors. And what happens now after you shoot him? What happens? He was so lucky. He ran, he didn't want the house. He ran. Running up the house in the front right here. He was.
Okay. Now,
So she shot him while he was running away in the back.
your interview room, this recording has timestamps on it, correct?
Yes, sir.
At what time did this occur?
5:03 p.m.
Okay, I see 1703. That's 5:03. It's military time, correct?
Yes, sir.
So this happens at 5:03. Now, during your conversation with the defendant, at any point in time, does she speak with you about what happened with the gun itself?
Yes.
What time did that happen at?
It's approximately 5 p.m.
So right around this time then?
Yes, sir.
We were kind of on their porch. Okay. And I don't know where he went after that. So I was looking, I walked to the front, I was looking, and I couldn't find him. So then I went back in the car.
While you're walking to the front, are you on the phone with anybody, or are you talking to anybody?
No.
Okay, so you're not talking to anybody? No. As you're walking?
No.
Then where's the gun at this point?
I threw it.
So as you're walking by your house, where did you live at?
There's a tree right here.
Okay.
As I went to go over and I'm walking.
So where did she tell you the gun was?
She had threw it near a tree.
Now, it's 5:03, and you had testified earlier that the search of the home happened at 12:27. Had you all already discovered the gun by the time she's giving you this statement?
Yes, sir.
So it wasn't her cooperation that gave him where the gun was. The dog just found it.
At any point in time during this interview, does the defendant ever admit to shooting the victim?
Yes.
And at what time did that occur at?
Approximately 5:03 p.m.
And does she ever tell you that at any other point in time in this actual interview?
Yes.
Okay.
Scarlett O'Hara, this is today's testimony.
Where did this pistol get hurt? Right. Okay. So just to clarify this, so this is the street, this is 14th Street, right? This is the neighbor's house, and there's this in between, and this is your house, right? Okay. And you're telling me that the shooting did not occur in between here? Okay, what do I think that you're lying about? I'm bullshit? I don't know where I was. Okay, that's nice. What if I tell you that I have something that you told me shooting happened? No? What if I tell you that I have you on camera? Okay, and I'll quote exactly what you say on camera. So you know that I'm not bullshit. Or that I'm not bullshit, as you said. Okay, I'm never going to argue you'll be fine. That was 10 minutes prior to calling the police. And you're walking with a gun in your hand. You walk towards the back inside your house. You walk back out with the gun still in your hand again. Then you walk by the tree. I shot him. I don't even remember it saying anything at all. No, he didn't say anything. You said that. He didn't say anything. You're right about that. You said I might have been an artery, and I said you were fine. I don't even remember him saying that at all. No, you said that. You said that. Okay, he didn't say anything. You said, I might have been an artery, you'll be fine. You said that, and it's on camera. And you're walking with a gun in your hand. Okay. Okay? Listen, I'm not here to debate.
Now, we just heard in that interview the defendant said, I shot him right here. At what time did that occur?
Approximately 5:44.
Was that used in your determination to make an arrest here in this case?
Yes.
Do you see the defendant you arrested here in this case in the courtroom today?
Yes, sir.
Can you identify her by an article of clothing?
It's the lady wearing a black shirt to my left.
I'm sorry, can you be a little bit more descriptive of the shirt and what she, and
I believe it has a flower pattern on it.
okay. Your Honor, let the record reflect that the witness has identified the defendant. I have no further questions at this time.
Defense, cross-examination. This should bring us to the end of the state's case, I think.
Morning, sir.
Good morning.
So just very quickly, I just want to verify a couple things. You testified that the shooting here happened at 3:27 a.m. Is that correct?
3:27, Officer Nicholson had arrived.
Ah, okay. Do you know when the shooting occurred?
At 3:11.
3:11. And you testified a few minutes ago that you yourself began speaking to Daisy Link at 4:20 p.m. Is that correct?
Yes.
So would you agree that you began speaking to Miss Link 13 hours after the shooting occurred, correct?
13 hours.
Yes.
And she was, during those 13 hours, she was During the vast majority of those 13 hours, she was in constant police either custody or observation in some fashion, correct?
Yes, sir.
You mentioned that the police found, or that your team found the gun prior to Ms. Link saying where it was?
Yes, sir.
Ms. Link was not informed that the gun was found at the time that she informed you all where it was, is that correct?
Yes.
Okay, so she didn't know the gun had been found, but she volunteered the information and told you where the gun could be found, correct?
Yes, sir.
Thank you, sir. That's all I have, Judge.
Okay. Quick one.
Can I see if there's any redirects?
Any redirects?
So on cross-examination, you had indicated that she had been inside the interview room for about 13 hours from before the shooting had occurred, right?
Yes, sir.
Did you give an opportunity to Ms. Link to sleep inside that interview room before speaking with her?
Yes.
And did she sleep?
She did.
I have no further questions.
Thank you.
We're about to hit the 1 hour mark on the deliberation timer. We are seeing some motion in the courtroom.
They've rested, that means the state of Florida has nothing else to present to you by way of their case in chief. I just need a few minutes now with the lawyers and Ms. Link, so let's go back into the jury room, please.
All right.
Defense is packing up his belongings. Virginia, YouTube changed all the names, so we reset the points. They're tied to your name, so if your name changes, you lose points. Okay, 1 hour of deliberation now. Got judgment of acquittal.
I mean, Judge, at this point, I haven't put on my case yet, so I don't expect you would grant it, but I'll make it.
Well, the first January is after their, yeah, crime fish case in the license removal to the, right. I can reserve, I'm sorry, you can reserve argument until later, and I'll take it up a bit. All right.
He almost blew it right there.
I think the witness's name is, I'm gonna keep butchering it. I have to write it down. Lalani?
Ayden Gonzalez.
How do you spell that?
Leilene
Leilene, and her last name?
Gonzalez, Gonzalez.
Lanine Gonzalez.
She properly what you were discussing.
So she's a cousin of Miss Link. She lives in Texas. She came down with Miss Link's mother from Texas when they found out about the pistol whipping incident. And and she can verify that they were coming down to help Miss Link move. She can also verify that the locks were changed.
But the incident of violence she would be discussing is limited to that.
She can't testify to that.
Well, she did something by receiving information, right? So
no, she can't testify. The reason she cannot testify to the act of violence is number one. In her deposition, she said she was unaware of it. She says that's adult problems and she was unaware. But number two, that he self-serving hearsay, this is a statement by the defendant. Regardless of its effect, it's a statement of the defendant's own that she uses in her own self-interest. And this court has granted a motion in limine to preclude the defendant from eliciting testimony about self-serving hearsay.
Doesn't she take an action that's predicated upon her receiving this information?
She can say that she came down here to help Daisy move to Texas, but she cannot say why, because the only reason she has that information is because the defendant gives it to her mother, who then tells Lynn that we are going to Texas to chase Daisy.
So it won't sound like it's hearsay or hearsay.
As well as the defendant's self-serving hearsay. And in fact,
well, no, hold on. We're not doing this. 1, 2, 3. We're not doing this. Please sit down, Mr. Raphael, with all due respect. So you're going to argue this, Mr. Padilla?
Yes,
thank you. Okay. You can whisper to him. Have some notes.
Yes, sir.
All right. Thank you. You want to respond?
So, they received notice. They received the pictures. There's talk amongst the family.
Are you going to say I saw these pictures? I just
I mean,
want to make sure.
she did see the pictures.
I just want to make sure it's one incident of violence. 5 days before, so that there doesn't need to be any further limitation from my part regarding other incidents that this lady may have seen or observed.
I'm not going to go into that at all. I'm
I
just.
just say that we want to bring her in, or at
That's
this point, if you've already proposed her, Mr. Buda, and you already know the parameters of your testimony, Mr. Tomas is proper for that, why do I have to speak to her again? I mean, why do I have to speak to her at all?
Well, again, my issue is the self-serving hearsay at the time.
Well, it sounds like it's hearsay within hearsay, so it's not coming in.
Hearsay within
Then
hearsay.
we heard from Josephina that Miss Lynn may have been disordered.
Right, which is
So-
hearsay. And then her grandfather says you need to go with Josephina. They get on a plane, I believe it's that day or a couple of days after the fact, I'm not 100% sure. Daisy comes over to the house, then 5 or 2 days, 3 days after that is when they go over to Daisy's house and she's there to pick up her grandmother at that point in time. That's the extent of what her testimony really can be, other than she tried to form off.
It isn't, you can't ask her, what did she hear, because it calls, we already know it's hearsay and hearsay. So, you can ask her questions surrounding her travel from Texas to Florida, and what she observed and what she has personal knowledge of.
She saw the pictures. She knew that they were there to help Daisy move. She knew that the locks were changed. She actually verified it herself. And she saw Mr. Jimenez circling in the backyard, and she waved at him. He waved back. That's it. That's pretty much
But
it.
she can't testify about the pictures because the pictures come from the defendant, which is self-serving hearsay.
She can testify to the photographs if she cannot investigate. That's our rule over the state's objection. All right, shall we bring in Miss Lady? Just have her sit in the courtroom, please.
Sure, just a moment.
The Ellen Greenberg case, as I understand it, that's not a case because the medical examiner re-ruled it as suicide, right? That stops the investigation. Now, I think that ruling appears pretty shady on the surface, considering the injuries that she had sustained, but I don't think there's a case to follow. Is there? Am I hearing that wrong?
Want to just have a seat around here?
Yeah, just have a seat.
Oh, it's a civil
All right, so
suit?
can I bring the jury back in?
It's been.
All right, just move it back.
All right.
Miss Lady, this is where you're going to sit.
So loud in this courtroom.
Just stay there right now. Once we're going to do it, I think we're going to sworn and then we're going to sit right here. Thank you.
Mom of 3. We've heard there's fireworks at the end of today. We'll work our way through it. Trying to go as fast as we can. Parents sued for another autopsy. They settled, and they agreed to do another autopsy, and the other autopsy just came back as suicide as well.
Should be someone else.
All I heard is right on the floor, or you're trying to score Miss Lynn, you can have seats. Here's the last.
Thank you, Judge Perry. Just have a moment.
Okay, everyone stop banging things together. A herd of elephants in here.
So, Judge, at this time I call Laylene Gonzalez.
All right, Ms. Gonzalez, come on up. Jose's going to swear you in.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Come on over here, Mr. Speak. All right, Mr. Tomas is going to ask you questions. There may be another lawyer that asks questions once he sits down. No one's going to talk over each other. Okay? If you hear someone say objection, just pause. I'll get you to pause as well, and I'll tell you if you're going to continue answering or if we're going to move on to another question. Okay. Thank you.
No one's going to talk over each other.
Good morning. Can you please tell the jury your name?
Laylene Gonzalez.
Thank you. Ms. Gonzalez, do you know Daisy Lynn?
Yes.
How do you know her?
She's my aunt.
She's your aunt?
Yes.
Your aunt on?
My mom's side.
On your mom's side?
Yes.
Okay. Where do you live?
I live in Texas.
Back in June of 2022, did you also live in Texas?
Yes.
Okay. Did you know Pedro Jimenez, Miss Link's former boyfriend, husband?
Yes.
Oh. Now, did there come a time in 2022, in June of 2022, when you traveled down from Texas down to Florida?
Yes.
Can you tell us what the reason is that why did you come down from Texas down to Florida?
There was an incident that my grandma.
Objection, hearsay.
Okay, without telling us what someone told you, just the reason. Does that make sense? So you're not gonna say grandma told me, but you're gonna say why you came down, okay?
And if I can just add to that, Judge, I don't want you to tell me what anybody else told you.
Okay.
What I'm asking you is, what is your understanding of the purpose that you were coming down here for, as far as you know?
Okay. Do I?
Yes, please.
We were coming down there so that way we can bring Daisy and her kids back to live with us.
Okay, so your understanding was Daisy was going to come back with you and her mother to
Overruled.
come back
Hold
with,
on, just a grandma. Overruled. You can answer.
come back with you and Daisy's mother to, and her kids to go live in Texas, right?
Yes.
Now, at some point, without telling me the content, at some point, did you see some pictures that had been sent over of Daisy?
Yes.
Judge, may I approach the witness?
Overruled. Premature. You can approach.
So, Lailene, I'm going to show you, well, first I'm going to show you what has been marked for identification as States Exhibit A2.
Objection, lack of foundation, overruled,
You
premature.
recognize what I'm showing you.
Yes.
What is that?
The injury that Daisy had got to her head.
I guess more importantly, is this the picture that you saw that I asked you about a moment ago?
Objection, lack of foundation.
Let's go sidewalk.
Wow. Okay, so the objections you're hearing that are coming flooding in are from the state. They do not want this in. This first witness defense is put on the stand is presenting or getting a story across about Daisy being the victim of domestic abuse. And there's a picture. And they're fighting. They're saying objection, lack of foundation. The judge says overruled, premature. They show the picture. She identifies it. She says, yes, that's an injury that she had. The state's like, got a sidebar. We don't want. They're trying to stop this. Everything they can. They're trying to stop this. Remember, Daisy is presenting, although she's admitted that she shot him in the back, that she's trying to present that she was sort of doing it in self-defense, not of fear for her life. So we'll see if this is allowed to go forward. Why is she holding her arm? Did she do something? Maybe it's just a comforting position. Defense came and grabbed their stuff out of the courtroom in the top right-hand corner and cleared out. Wonder if they think this is going to be a little bit longer of deliberation. Already over an hour and 12 minutes for the Warren County jury. Long sidebar. Should we zoom? Thought it would be quick. Camera's wandering around. just lost. Witness is still in the stand. Keep.
State.
There we go.
March for identification. I don't think it, well, I'm going to give it to the clerk in a moment, but what's in evidence or will be in evidence imminently, but it's marked currently as state's defense exhibit A2. Now, is this one of the pictures that you saw before you came down to Florida back in 2022?
Yes.
Does it appear to be the same picture that you saw back then, a true and accurate copy? Has it been modified, altered in any way to your knowledge?
No, it looks the same.
Okay. I'm showing you defense, what's marked as defense exhibit A3. What is that I'm showing you?
That's the wound she had gotten.
Is this one of the pictures that you saw before you came down to Florida back in 2022?
Yes.
Does it appear to be the same picture that you saw back then?
Yes.
Does it appear to be altered, edited, changed in any way?
No.
Okay. Thank you. Now, before you came down to Florida, had you seen these pictures before?
Before I came to Florida?
Right.
Yeah.
But you saw them for the first time right before you came to Florida, correct?
Yes.
Well, are you going to introduce it?
Well, so Judge, just formally by, I believe, stipulation, I'm moving both of these into evidence.
All right, well, let's take the objection comes in, go ahead.
Okay, defense exhibit A2 marked by day will now become defense exhibit B. And defense exhibit A3 marked by day will now become state exhibit C.
Eventually, when you got down to Florida, you saw Daisy in person, correct?
Yes.
I think he meant defense.
Did you get to see her head and see if she had any wounds that are consistent with those pictures?
Yes.
And did she have wounds?
Yes, she did.
Were they the same ones that we see in those pictures?
Yes.
Not sure why he's leading. Could be
Do
a
you
court
know if
ordered him to do it, so she
if
doesn't
the
see
locks
it.
in Daisy Link's homes were ever changed?
Yes.
How do you know that? Can you explain?
Me and my grandma were going to Daisy's house to do some cleaning and packing, and she had given us a key. And my grandma went to unlock the door, but it wouldn't work. So I tried the key because I thought she was just couldn't do it. And when I tried to unlock the door, it wouldn't unlock. And so we called Daisy, and that's when she had told us, oh, she had given us.
Overruled. Yeah.
Go ahead.
She had given us the wrong keys, and that she was gonna come and bring us the correct keys for the new locks.
For the new locks?
Yes.
Now, at some point, did you and who's Crystal Barrett?
She's my other aunt.
Your other aunt?
Yes.
Is she Daisy's sister?
Yes.
At some point, did you go with Crystal to pick up your grandmother at Daisy's house?
Yes.
Okay. Do you remember when that happened?
I don't remember the date, but I remember the night.
Okay. Can you tell me what you observed when you arrived at Daisy's house, when you went to go pick up your grandmother?
I had got out of the car to go grab my grandma's purse. And as I was walking to grab her purse, I had seen Pedro towards the end of the building walking around, and he had seen me and he said hi to me.
Now, he said hi where you can hear it, or did he?
No, he had waved, like saying hi.
He waved.
Yeah.
Did you wave back?
Yes.
Where was he when you saw him? Was he outside, inside?
He was outside.
Outside?
Yes.
Where outside was he, if you remember?
Her house is like a long building, and he was towards the very back in like a big space area.
Like in the backyard?
Yeah, like the open area back there.
And what was he doing?
He was just pacing around.
Pacing around?
And he had seen me and just said hi.
How long were you at Daisy's house before you, Crystal, and your grandmother left?
Like 5-10 minutes. We just talked for a second and left. It was late at night.
Okay. While you were there, did Pedro Jimenez ever come inside the house?
No.
And once you left, once you, Crystal, and your grandmother left, where did you go?
We went straight back to Crystal's house to go to sleep.
Okay. Who stayed behind at Daisy's house?
Oh, just Daisy and her kids.
Daisy and her kids?
Yes.
And the next day, what, if anything, did you learn the next day?
The next day, I didn't know anything. I had stayed, or I was waking up early in the morning, and my grandma was said that she had got a call, and they told me to stay and watch the kids.
Oh, good answer.
They just told me to stay and watch the kids while they had to go figure something out.
Okay. Did you learn of anything later that day?
That Daisy had gotten arrested.
Okay. And Judge, if I may briefly publish the jury. And again, these two pictures I just showed you, these were the pictures that you saw, which led up to you and your grandmother traveling down to Florida, correct?
Yes.
So that Daisy could move to Texas with you?
Yes.
Thank you. That's no further questions.
You want minutes to confirm? You want a minute to confirm?
Yes, ma'am. That's fine, Judge.
Okay, all right, any cross-examination?
Yes, Your Honor. Good morning. Thank you for being here today. So, I want to go over a couple of things that you had talked about with Mr. Tomas, okay? So, you had stated that you were informed of the reason why you were going over to Florida, correct?
Yes.
Isn't it true, though, that your grandpa was the one that told you needed to go with your grandma?
Yes.
Okay. And that your grandma never told you what the reason was to come over here?
Wait, can you say it again?
Isn't it true that your grandma never told you the reason why you were coming over here to Florida?
The reasoning, we seen the pictures, but I didn't learn till why after. Cause she didn't want me to go at first cause I had some things going on, but my grandpa wanted me to go with her because she's older.
And to help her out, right?
Yes.
So when you were coming over here, you never knew the reason why you were coming over here then, right?
Not at first.
You were only coming over to Florida to just help your grandma and accompany her, right?
Yes.
Now, you had testified about the photos here in this case that you had seen, right? That was a reason that you found out later on why you were coming over to Florida, right?
Well, I seen the photos, and that was why we were going there.
But you only found that out later on, right?
No, I already knew about the photos.
Okay. Well, those photos, were you the one who took those photos?
No.
Do you know the date itself that it was created?
Yeah.
Oh, so then you were there then for the photo itself, right? If
No.
you know when it was created?
But when you get the photo, it has a date on it.
When you open the photo?
Yeah. And you slide up for information.
Well,
it's called metadata.
These photos, which are defense exhibit
B and C.
B and C, do we see any timestamps on here?
I didn't get a picture. It was through messages.
Through messages, okay. So you don't know then if those photos were taken a month before then, do you?
No.
It's possible that they were created a month before then, right? Or even 2 months before. Is it possible?
No.
No.
Well, how do you know that it's not possible then if you weren't there when the photos itself were actually taken?
Because when you send a photo, there's a date when it's taken.
Yeah, but can't you go into your camera roll and send a photo from a month before and it says the date that it was sent to you?
Not when it's taken through an actual camera.
So, it's your testimony here today. You can't go into your camera roll on your phone and select a photo from a year ago and send it to someone.
You can, but it's going to have the date from a year ago?
The photo itself.
Yes.
Did those photos that I just showed you right now have a date or photo or anything on there?
No.
Okay, so then it's possible then that those photos could be from another time then, right?
No.
Okay, I'll move on. Now, you had also testified on direct examination that you went with your grandma to go check the lock on the house, right?
Yes.
You were given a key.
Yes.
Who gave you that key?
Daisy.
Okay. Now, you tried to use that key on the actual lock itself, right?
Yes.
And it didn't work?
No.
Now, did you actually see that lock itself being changed?
No.
Do you know whether or not she might have given you an old key?
No.
Is it possible she gave you an old key and not one that was new?
Yes.
Okay. Is it possible that she might have given you a wrong key also?
Yeah, wrong key. Because it was to not the new locks.
Yeah, but is it possible that she just didn't give you the actual key and it could have been to another house or a car? Is it possible?
Yes.
Yeah. And to confirm, you never saw any locks being changed?
No.
And you live in Texas, right?
Yes.
So you don't even know if that's the right key, that actually belongs to a house then, right?
Yes.
Now, when you guys tested the lock, isn't it true that you guys only tested the front door then?
No, I had went to both doors.
You went to both doors?
She tried only the front door.
Who's she?
My grandma.
Just give me one moment.
Sounds like the prosecutor is trying to bring in reasonable doubt. Is it possible? This witness is like super chill. She's like, no. She didn't say metadata, but it's like, no, the picture has a date on it when it's taken. Couldn't you get one from a year ago and send it? It would have today's date? No. It's pretty funny.
Now, before you ended up testing the lock sill, you had said on direct examination that you had seen Mr. Jimenez, the victim here in this case, around the house, correct?
Yes.
Wasn't it true that he was in the area where the kids play? in the area outside the home, like the little playground where the kids played?
No.
No? So it's your testimony here today that that's not where he was located?
What are you talking about? Like,
When you saw Mr. Jimenez for the first time?
I thought we were talking
That
about
day.
the locks.
He was where?
Are we not talking about the locks anymore?
No, we've moved on.
Okay.
Yeah, so that day when you went to the home.
Yes.
We're not talking
Mr.
about the
Jimenez.
locks anymore.
The first time you saw him when you're here in Florida that day, he was outside in the area where the kids were hanging out, right?
Yes, he was saying hi to Junior.
Oh, he was saying hi to Junior.
Yeah.
So he was near the children then.
Yes, he came to visit them.
And he was waving at you, right?
Yes.
He wasn't angry.
No.
He wasn't mad.
No.
He wasn't screaming.
No.
He just waved at you, right?
Yes.
Acting like a normal person.
Yes.
Aya, welcome. Great to have you here. Big sigh from the prosecutor.
And that's at the actual house itself, right?
Yes.
Now, you had testified as well on direct that you saw he never went into the house, correct?
Yes.
Were you there up until 3 a.m. in the morning?
I was there up until 10 p.m.
Okay, so from 10 to 3 a.m. you weren't at the home then?
No.
So you don't know if Mr. Jimenez ever went inside the home at that point in time then, right? Because you weren't there. You don't know if he could have gone into the home after 10 p.m. when you left the home, right?
What day are we talking about?
The night of the incident, June 24th going into June 25th.
So you said the first day I saw him there with the kids at the playground.
Yep.
The day of
And he
the
waved at you.
incident, I did not see him there at all.
So it's your testimony that he was never there that day?
Of the incident, no. I didn't see him there until I went to pick up my grandma later that night.
So when you left the home at that time, we'll focus on the first day, when you left at 10 p.m.
The first day, I did not stay there.
So then, on that day that you see him and he waves to you,
Yes.
he's there at the property. He's not inside the house, but he's there on the property, right?
The day he waves at me, I went to pick up my grandma. It was like 1 or 2 in the morning.
Okay. So then, when are you saying that you saw him and he waves to you? At 1 or 2 in the morning or at 10 p.m.?
1 or 2 in the morning.
Okay. And he was outside
Yes.
where the kids were, and he was visiting the kids.
That's a whole different day.
I thought you had said that when you waved to him, he was seeing the kids.
That was on the first day I came there. The night of the incident, he was in the back of Daisy's house. She has like a duplex. The front is right here. He was over here in the middle, in the very back.
Okay, but you're saying that's the day of the incident.
That's the day of the incident.
But didn't you just testify 2 minutes ago that you didn't see him on the day of the incident? You only saw him the day before?
1 or 2 in the morning, it was the day of the incident.
Yeah, but that's what you're saying. You're saying on the day of the incident you didn't see him, but now you're saying that you saw him in the back of the house the day of the incident.
But I didn't stay there. I just,
So did you see him or did you not see him that day?
I saw him.
Okay, so you saw him then on the day of the incident?
Yes.
And he was at the house?
Yes.
Okay, so then after you left that house that night on the day of the incident, okay, you could have seen, he could have gone inside the house at any point in time because he lived there, right?
We didn't live there.
Okay, and you live in Miami?
No.
So you know who lives in that house?
Yes.
Because you go there every day?
No, because
You're
then.
not arguing with this. Ask questions.
Do you go to that house every day?
No.
Do you see who goes in and out of that house?
No.
Okay, so it's possible. Is it possible that you don't know who lives inside that house then?
No.
Brandon, just 1 moment to confirm. There are no further questions.
All right, can you redirect?
Wow, he's so frustrated. Just say metadata.
Did Pedro live in that house, in Daisy's house?
No.
when you saw him in the backyard, it was 1 or 2 in the morning, correct?
Yes.
So the kids were sleeping,
The
right?
kids were sleeping.
He was just walking around in circles in the backyard at 1 or 2 in the morning, right?
Yes.
Leading. He's gonna re-ask the question.
So at 1 or 2 in the morning, you see Pedro in the backyard. What's he doing?
He's sitting there walking around, staring at his hands, walking in circles.
So you had been to the house on another occasion?
Yes.
Right? Okay. So I'm not talking about the other occasion. We're just talking about the last time you saw him, which the next day you find out that Daisy gets arrested, right?
Yes.
Okay. And again, just to be clear, you and Crystal went to Daisy's house to pick up your grandmother.
Yes.
And you all left with your grandmother at 1 or 2 in the morning, is that correct?
Yeah, we were just there for like 5-10 minutes.
Okay, thank you. That's all I have.
You can step down. You can step down as well. Thank you.
Wow, interesting witness.
All right, folks, we'll go ahead and take a lunch break now until 2 We'll come back so that we start at 1:10 p.m.
So this was their lunch break.
So we've got a clock now, it's 12, we're moving Roberto, we'll instruction there. Please remember my instructions from last meeting. Not to talk about the space amongst yourself or anyone else, not to do research about the case.
Why does she allow this?
Outside, folks that you recognize, ignore them, they're in the right strict order to ignore you, as are the slink and the lawyers. Okay.
All right, for the jurors, third floor, please.
It's like she doesn't care if the jury's hear that instruction. I just have to say it, or else I get in trouble. And so you guys can make all the noise you want. Everyone pack up, be banging books around and slamming binders and clipboards and everything else. She's just cool with it. All right, there we go. Let's skip through lunch, shall we? We've got a lot to cover. Oh, hang on. They do something during lunch, I forgot. Let's see, here we go.
And then the fourth potentially is Pickles Jr., right?
Well, Judge, I can't happen to that.
Oh, sorry, he's the one that needs to be closed. Can you all arrange for his deposition?
I'm asking my trial coordinator to help me set that up. That's going to be today, hopefully, but it depends on how long we are in trial for today.
Well, let me ask you this. You have 3 more witnesses besides Pickles Jr., right?
Pedro Jr., Crystal Barreto, Josefina, depending on what happens with David, and this one.
Well, you also need to litigate whether or not this is really with Pickles, so it's not also asking for.
Cool, David Price?
Correct.
We're not there yet, he's on jump around. So let me take her up today. So in theory, if we broke a little early, if Isabella agrees, the deposition of Ayden Jr. could be done to support her.
Oh, yes.
I need a videographer because the rules require a child to be videographed, and we could potentially by stipulation in the video is that I'm doing research throughout this detective cruise as well as there are several statutes, several rules that think that come into play here. And I'm good at more attentive if this court is going to reinstate Pedro Jr. as a witness. I'm good at more attentive that he be allowed to testify with closer television. It is standard is that moderate emotional distress if he testifies in front of the defendant. I think that we need to have a hearing on that as well.
But in theory, I could do that as early this afternoon, right? Right? So he could be the last witness that we put on, correct?
Yes, ma'am.
So the next 3 or 4, the state's on notice of.
Yes.
Okay, so that sounds like a plan for today. That's all I care about for today.
All I care about is today, one day at a time.
You all have a stipulation regarding the next time via closed circuit television. I've done that before. It's usually in sexual battery cases. The state moves to protect the victim. It's a whole procedure. They literally sit in an office and it's via Zoom. there's no difference between closed circuit television and Zoom, in my opinion. I'll let you all bring up whatever legal issues you think that brings. But if you all agree to that, by stipulation of the parties and this link, we could just do that too. At some point in the near future, it doesn't have to be live testimony. Okay? So the state's putting it out there.
I'm also going to direct the court to section 603, as well as, I just want to make sure I'm right here. 716, regarding competency of a minor witness.
You've never met him, right?
I'm sorry?
You haven't met him yet.
No, I don't. But
so at this stage, you have reason to believe that he is not competent under the law. You know?
I'm sorry.
The state is suggesting that I do a hearing to make sure that this 11-year-old can testify as a legally competent witness. Do you know?
I'm not opposed to that, Judge. I can tell you I've spoken to both her kids. I felt that the younger child was not, but I've been speaking to Pedro. He's a bright kid. I think he is. Okay. I think he is. So, but I leave it to the court to make that
decision. The state is going to depose him. They haven't met him. You have. We'll just take it one issue at a time.
Yes, ma'am.
So,
before we break, Your Honor, and I mean this with the utmost respect, I'm going to ask the court to stop admonishing the state in front of the presence of the jury.
From doing what?
Well, you snapped at me last week. You snapped at, or excuse me, I don't use the word snap. You interjected yourself to a sponte with no objection from defense with Mr. Tala recently that he's not allowed to argue with the witness, and he's merely asking a leading question, which we are allowed to do on cross-examination. I think it is disrespectful to the state. I think it is implying something to the jury as well. I'm not just saying that the court is purposely doing that, but I do think that it is implying something to the jury. So I'm going to ask the court to stop admonishing the state in front of the presence of the jury. I have no problem with admonishing us outside the presence of the jury. You've done that to me plenty of times.
Am I allowed to order on the court?
Absolutely.
And at what stage did I tell Mr. Atala to stop arguing?
When the witness wasn't giving him a straightforward question.
When he was going back and forth to her about where she did. That wasn't an open-ended question. You don't know what you're doing.
Well, that is cross-examination rule about scope. He merely asked when she said Pedro doesn't live there and said, you live in Texas, you don't come here every single day. And then the court said you're not going to argue with the witness. She was not giving a straightforward answer, and so our call was merely trying to get an answer from her. Again, I don't have a problem with this court maintaining order. I do have a problem with this court admonishing the state in front of the presence of the jury. It does imply, I'm not saying the court is, but I'm saying that it does imply to the jury that something is amiss.
Okay, but I understand that's what we disagree. But you laid your objections. All right, thank you all. We'll see you at 1:10.
Okay, so this is lunchtime, and they've already gotten spicy. That was lunchtime. They already got a little bit spicy, so now we get to skip through lunchtime and come see what the attitudes are like. And I guess everyone's just a little hangry right now, right? They've been sitting there for a while. No food. They haven't eaten since breakfast. Okay, let's just see here. No wonder they get spicy this afternoon. Ooh, seen a little motion in the court down there? Nope, they left again. Bummer. Okay, let's see if we've got any. We're still at lunch. Still at lunch. Let's use the mouse a little bit. Where's my mouse? There it is. Oh, somebody's coming back into court in the other courtroom, but it's not the right people. Yes, it is. Hang on. Pause for a second. Let's keep lunch just going where it is, and let's jump down here to this guy. Our defense is back. Looks a little early. Hang on. Where's the clock gone? I just got rid of it. We're at 1:43 right now, an hour and 43 minutes. It's still going. It's still early, I think. Recap the link drama, please. Basically, the defense and the prosecution are not having lunch together. Not today, not yesterday, not ever. They hate each other. They have to sit 3 inches apart. The judge has ordered them not to look at each other during this trial because apparently that was a thing. They just hate each other. And every time one side wins and the other side doesn't, his feelings are hurt. And the judge, who has failed to control her courtroom thus far, is getting walked all over by the first chair prosecutor. And he just did it again. He's just like, I'd just like to I'd ask the court to stop admonishing us in front of the jury. I don't have a problem being admonished, but don't do it in front of the jury. And they're mad. They're mad because the judge said to the, I guess you could say third chair, who was questioning the last witness, when he was like, "Oh, and that's because you live there all the time, right?" And he got a little lippy with her, and he's like, "Stop." She says, "Stop arguing, sua sponte. Stop arguing with the witness." That's what he's mad about. It's like, why do you shush me and not them? You know, don't hush me and not them. I think that's a line from, I don't know, it's like A Knight's Tale or something. But yeah, that's what's happening. And there's been some spicy argument. The judge has already ruled against the prosecution so far today, where it looks like we might have a verdict. They've already ruled against the prosecution, where they wanted to reconsider and bring in the jail phone call or jail record of some sort, and the judge would not allow it in. And they're livid. So today was the motion they made for reconsideration, and she shot that down on the four corners of the motion. And so they're just pissed off. Sorry for the French, for those of you who are over in Europe. They're just mad. They're mad at the judge, and they're mad at the defense. And defense is winning things. They're getting things in that the state doesn't want, that makes the state look bad, that makes Daisy look like a victim, which they don't want because that's harmful to their case. They just got stuff in right now that said that the victim, the one who was shot, didn't live with Daisy in the house. That wasn't his house. And he was, 2 o'clock in the morning, was outside the house, wandering around, with no business being there, basically. Anyway, let's see. We have, do we want to do it? Do we do it? Do we play the music? All right. This stream we're watching is live right now from Warren County, Ohio. I think we've got everybody there, so let's do it. The timer is 1:47 and 10 seconds, 11 seconds on the clock. We believe we have a verdict in this case in Warren County, Ohio. This is an interesting case. It was one that initially I thought, why are we even bringing this to court? This is a slam dunk. We've got an inmate accused of assaulting a guard in a prison, and they have it on camera. It turns out that not everything was as easy as it seemed. And through the course of this trial, we've heard of what could only be described as misconduct and overreach and possibly even abuse of power by a number of guards at this prison. Ohio has a number of prisons that are less than desirable. None of them are really good, but less than desirable, probably some of the worst. And this is one of them. The victim says, "I was in fear for my life." And as we watched the video and heard the story, defense made the motion, or made the suggestion in the closing that really resonated with me, and that was that of all the witnesses we heard on the stand, the defendant's was the one that matched up with the video evidence. The defendant, incarcerated for an unknown time period. I don't know how long he's in there. He's a bad dude, or he's done some bad things, and he's done some bad things in prison. But in this case, he may not be responsible, and it's actually the guards that may have escalated this situation, which started as a jail cell search, right? They were going through looking for contraband. Started as that, but it escalated very quickly to something much more than that. 2 officers were injured, a couple others had their pride hurt, and one defendant says he was doing all of it just because he was in fear for his life. So, jury, we believe, has a verdict as the defendant is now taking his seat right now. We're just waiting for the judge to come in and the jury to be brought in, and we will hear if we do, in fact, have a little quick prayer from the defendant there. If we do have a verdict and what that verdict might be. If the jury comes back and says not guilty, that will mean that they had found that this incident was, in fact, self-defense. The state having stipulated to most of the elements of each of the charges. And if they find him guilty, then that would mean that he, in fact, was responsible. Judge is taking the bench right now.
All right, we are back on the record in Mr. Thomas's case. It's 4:57. The jury rang the bell and advised Ms. Kuroko that they wanted to adjourn for the evening and come back tomorrow. So
whoa!
I'm going to give them the standard instruction not to talk about the case, do any research, bring them back tomorrow at 8:45.
You get music again tomorrow. 8:45 we start.
Judge, is it your practice to bring them into the courtroom in the morning, or to just
Yes.
let them? Okay.
Yes, I will bring them into the courtroom, make sure that they followed my instructions over the night, and then send them in and get them to work.
Do you want us here for that?
Yes.
If you want to be here.
I don't need to be here. Just, I couldn't remember if you brought us in for that or not.
The prosecution
They usually do, but I don't know.
I mean, it doesn't matter.
Do I have to be here for court?
Also, or?
I'm okay either way. If it's easier for the state, then we can both not be here. I have to be in the courthouse tomorrow morning anyway. So.
I mean, I'll be here too, so
Defense
that's
says,
fine.
I'd like to be here.
Court's pleasure.
This is so weird. Prosecutor, do I have to be here, Judge? Yeah. I know this is like a trial and all, and I'm the prosecutor, but do I really have to be here? I'd rather not. Jury's coming in now.
May I be seated? Welcome back, ladies and gentlemen. Ms. Kuroko advises me that you have informed her that we want to break for the evening. Is that the case? I'm seeing general nods. Who was our foreperson?
I guess that's me.
Okay.
I guess that's me.
Ms. Grimes?
Yes.
Ms. Grimes.
Jury wants to call it for tonight and come back tomorrow.
Yes.
All right. So,
Well, do you guys want me to ask about the phone? Yeah.
What?
Yeah, I think there was a question about the phones for a few of us that
Whoa.
after we asked about leaving at 5, some of us would need to make phone calls if we're going to stay later tonight to our families to let, take care of kids and such. So it's a possibility we could stay later, but a couple of us need to make phone calls to family to make other arrangements.
all right. So,
They want their
want
phones.
to keep
though.
going tonight? If we take a break, give you your phones, let you make some calls.
Yes.
Maybe.
And I think the majority of us would prefer to stay this evening.
Oh.
And finish it.
Do we have anybody that cannot stay this evening?
Me, Judge. No, just kidding. I'll
'Cause
be here.
what I don't want is, I don't want to time, like if somebody has their favorite show to watch at 8 o'clock tonight, I don't want that to control our deliberations.
They can
You
be
know,
on
we
rewatch
have
crew.
two choices. We can break at any time, come back tomorrow, or we can keep going. The choice is yours. We'll keep people in the building if that's what you want to do.
We want to take a break and come back tomorrow. Sorry, take a break and continue.
All right, so what we're going to do is, we're going to take about a 10-minute break. Ms. Kuroko, do we want to see the outside, or do we want to just take a break while we're in the building?
I think the majority of people just need to make a phone call.
Okay, so we're going to take a break. We will, Ms. Kuroko will reunite you with your devices, and then at 10 after, she will box up the devices and take them, and you will resume deliberations. Do not
So we're not
deliberate with her in the room. Do not discuss the case with any of the people that you call, other than to tell them, hey, we still got more work to do, and we'll let you know. The alternative thing that we can do also, if you want, is you can provide your family member with Ms. Kuroko's contact information. Sometimes it makes them feel better to be able to text somebody and say, hey, is the jury still working? And she just says, yes, they are. So if you want to do that, that's fine. Anybody an objection to that plan? Okay. All right. Well, I'm not going to see you again. You're just going to resume deliberating once either 10 minutes have passed or everybody's made their phone calls. We've retrieved the items and Ms. Kuroko is out of the room. Don't begin deliberating until all 12 of you are together in the jury box.
Wow. Jury would like to say, look, even inmates get one phone call, Judge.
Can you let them know at the front that there was a change of plans?
Yes, sir.
Let the sheriff's office know that the night crew is pulling a long shift tonight. We'll need a few bailiffs to stay a bit later. Transport.
All right, we are on the record outside the presence of the jury. We'll keep you posted. I'm going to have Ms. Kuroko inquire of them as to whether or not they want dinner. I'll let you know what they say.
Okay.
All right, we're in recess.
Do tell us what they get as well, Judge, because that's important. All right, we're about to jump back to whatever happens after lunch in the Daisy Link trial, because we're getting caught up on everything all at the same time here today. We're over halfway through the Daisy Link trial, just trying to find the exact moment they come back to court, and it's about right here.
Am I bringing her in?
Okay, there we go. All right.
The next witness you're going to call.
I'm going to restart the timer because apparently they're still deliberating.
Limitations?
Yes, John.
Okay. What were those limitations?
It'd be the same as really all the witnesses. Ms. Barreto has no personal first-hand knowledge about the incident prior. She received text messages from Daisy. Then, in response to saying, "Who did that to you?" she said, "Pedro." In her text messages, she has no first-hand knowledge of any of that. She can't testify to that. It's self-serving hearsay from the defendant. She can testify, I went to go with my mother. I went over to Daisy's house. Daisy came to my house a few days prior. I saw those injuries. But that's the extent of what she can actually testify to.
I communicated with Daisy thereafter I went to her house.
Sure.
All right, what's your response?
I agree, that's essentially it. And also, Judge, she was at the scene after the shooting.
That's right.
And I believe she testified to this at an Arthur hearing some time ago, a long time ago before I was on the case. So there'll be some questions about that as well. That's the extent of it.
Right. I have reason to believe she could have denied making that spontaneous statement. She was actually there.
Can we
Bree, that is
do
so
you
good.
anticipate the spontaneous statement coming out in your direct?
Yes.
All right. I guess we'll just take it one thing at a time. Can we just remember spontaneous statements, as Mr. Rodriguez pointed out, and I was conflating with the whole issues, but as he pointed out, they're hearsay, and they might fall into a couple of different categories that affect on the listener, which is why I was conflating it. But because of their initial reliability, they come in as substantive evidence. But the foundation has to be laid. So in other words, similar to an excited utterance, there has to be some event that precedes the spontaneous statement. I've already given a limiting instruction. I would just caution you all, if that spontaneous statement is going to come out, and you all want it to be considered for some sort of substance, evidence, as opposed to an effect on the listener, there has to be these little breadcrumbs, you use the phrase breadcrumbs, that also need to come out also. Again, because of the reliability, the spontaneous statement is preceded by some sort of an event. It doesn't have to be a startling event, but an event. I think we're all on the same page, right? I think we're all on the same page.
Yeah, I think there's just she's going to deny ever making that statement. And it's already been brought up with Detective Morales. I think that's the extent that is going to be.
Part of the reason that I let it in with Morales is he did say it was spontaneous, but he also talks about what he's observing as he's investigating, trying to narrow down who is actually responsible for the homicide of paper offense. That's part of the reason that I let it in. But I guess two things can be true. You might be able to come in for two different reasons. But it is a pretty damning statements, if I can use that word. It's pretty important, so that's why I took the extra steps to get a little bit of instruction, because I didn't believe that it was introduced in the full context of a spontaneous statement. For Mr. Lamas, I did do some research based on what Mr. Rita argued regarding the self-serving statements from our opponent. You guys have your hearts, it's 90.80318.
The judge gives a little master class on hearsay and self-serving statements and spontaneous utterances
And
right there. So
it
it's
doesn't
a basic
indicate that.
foundation.
So it talks about admissions being offered by party opponents, but it doesn't have to be an admission. In other words, it doesn't have to be against someone's interest, such as a confession. It can just be statements. And two things can be true.
I said that today.
Statements by defendants introduced in court can probably fall into a couple of different buckets, right? Effect on the listener, they make certain actions. But when they are offered by the defendant, only the state can introduce them, because it's a part of the problem. If you can convince me otherwise, then you know, us. All right, let's begin this right, please.
You want the first thing.
I think we're going to stay on until we can finish, get caught up with Daisy. It ends with fireworks tonight. What's funny is I think the judge told everybody that they had a verdict. Or at least that's what the message that went out, because he says, tell everyone there's a change of plans. Or I don't know, maybe the judge just assumed they were all going to be going home and said there's a change of plans, they're staying. But
All right, Mr. Lorenzo, just come up a little bit. I'm sorry. All right, yeah.
That's Ms. Barreto. Ms. Gonzalez already testified, so she's here, and he's not a witness.
Am I speaking to Mr. Lorenzo?
I think it's not a bad idea to give her limiting instructions.
Ms. Lorenzo, you testified during the argument, remember?
Yes.
So you're just going to answer the questions that are asked. Please don't add anything extra. The lawyers may have some way to give you what we call leading questions by loud.
Here's one of the TV.
But otherwise, just answer the question that's asked of you. There are some limitations regarding the past incidents between Gabriel and Daisy that the court's already limited. So for the time being, the only prior incident of violence is the one that occurred 5 days before. And unless someone has personal knowledge, such as being there, you can't testify to it. If someone saw injuries a couple days after, they might be able to testify as to what they saw a couple days after. Does that make sense?
Yes.
Okay. All right, just have seats. We'll bring in the jury, and then we'll have them go and sit in front of them in a minute.
The problem is there's one microphone that it's actually like a conference room center phone microphone that's in the center of the courtroom, and it's sitting on the court clerk's desk, which is the busiest desk in the whole courtroom. All evidence goes there. All exhibits go there.
About if one child testifies about whether or not he's going to be on camera or on video, I advise the court should be the one to make the determination.
You mean live in court? Oh, we'll have a conversation over here, as they'll probably just angle the camera to the seats. Right?
Legally blonde.
Thumbs up from the camera, folks.
They just asked me before.
Oh, okay.
Fun, right? That's what I was thinking.
Is that in person?
Yeah.
We're waiting for the jury to come in. I didn't want to fast forward here, but we can. hear water. And a halfway contained sneeze. Red Pan, I can't find the invite.
Yes.
I need an invite every time you make one, so I'm not on your account.
All rise for the jurors.
All rise for the jurors. All right for the church. It was close.
All right, welcome back everyone. Be seated, all jurors who are present, accounted for, orders, okay, do you have another witness we're gonna call?
Yes, Your Honor, at this time I would call Crystal Barreto.
Ms. Barreto?
Crystal Barreto.
Raise your right hand. Do you swear from the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
What's that pattern called?
I just want you to step up and down. I'll tell you what I told you in the witness. Question, answer, try not to talk over each other, even if you think you know what the answer is going to be or you know what the question is going to be. If you hear the word objection, please pause and I'll let you know if we're going to continue answering. The rule first, the state rule second, and then the rule third. Okay?
Okay.
Thank you.
You're welcome.
All right, good afternoon.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Crystal Barreto. I am the sister of Daisy Link.
Okay, so Daisy's your sister.
Yes.
Right. Do you live in Florida?
I live in Homestead, Florida.
Okay. Back in 2022, did you also live in Homestead, Florida?
Yes.
Back in June of 2022, around June 19th, June 20th of 2022, did you come to learn about something that happened to your sister, to Daisy?
Yes, I did.
Okay.
Big sigh.
Without telling me what was told to you, did you at some point receive some pictures?
Yes.
How did you receive those pictures? From who?
From Daisy through text message.
Through text message. So, Judge, if I may approach?
Sure.
I'm showing you what's already in evidence as State's Exhibit. Well, I'll start with State Exhibit B. Is that one of the pictures that you saw, that you received from Daisy?
Yes.
And what is that? What do you see in that picture?
Daisy's with blood all over her shoulder area and looks like some hair and on her shirt.
Okay. I'm now showing you what is in evidence as Defense Exhibit C. Is that one of the pictures that you received from Daisy on that same instance?
Yes, it is.
And what do you see in that picture?
It's Daisy's head, opened like a gash in her head with blood on her head and her hair.
So after you received that notification from Daisy and you received these pictures, did there come a point after that where you met with your sister Daisy in person?
Yes, when she sent me the pictures, I offered to take her to the hospital, and I went in person to her home to get her children so that she would be able to go to the hospital and get treated for her injuries.
Okay, now when you went to her home for that purpose, do you know how long it had been since she had received those injuries?
It had been maybe a few hours, maybe 24 hours. I don't really know the time frame of when it happened because I wasn't there when it actually happened. I was only there, after the fact and to get the children from her to make sure they were in a safe place so that she could get treated for the injuries that were on her head that looked severe, in my opinion.
And and that was going to be my next question. When you saw Daisy, did you have an opportunity to actually see her head and see her injuries?
Yes.
And what, if anything, did you see when you made that observation?
I seen open wounds on her head area. It looks like you can see like her skull, lots of blood, lots of swelling all over her head. I urged her to go to get medical treatment because I felt like something could happen to her, because it didn't look, anybody who would have saw that injury would have been worried for her safety and for her life.
Okay. So you took care of her children, and what did Daisy do when you took care of her children, as far as you know?
As far as I know, because I was checking up on her through the time frame of how she was and how she was feeling, she went to the hospital to get medical treatment while I stayed with her children.
Okay. Now, without telling me what you said or what anybody else said, at some point did you communicate with somebody else or share those pictures with somebody else?
Well, as soon as I saw the pictures, and I immediately contacted my mother, and I let her know that.
So remember, just gotta answer the question. So it's the same. If you're gonna pause, and he's gonna ask another question. Okay.
Okay.
I don't.
Objection, hearsay.
I don't want to get into what you told her or anything, but in your communications with your mother, did you send her those pictures that I just showed you?
Yes, I did. I did send her those pictures.
All right. At some point after that, your mother lives in Texas, right?
Correct.
Some point after that, did your mother come down to Florida?
Yes, she did.
Around this time, were you, just for context, around this time, did you have some kind of medical issues yourself?
Around this time when this was happening, I had just given birth, and I had a cesarean section, and I wasn't able to really do a lot to try to help Daisy and with the kids, because my mobility was kind of limited and what I was able to do as far as, trying to help out in a way that I really couldn't help out.
Okay. All right. So your mother came down.
She wants to talk.
To Florida. What was your understanding of what your mother's plan was in coming down to Florida?
Objection, hearsay, infringement, hearsay. A little, if you know. So I'll guess, if you know.
So what I know, what we communicated, what I asked of her was to come down to Florida because the injuries that I saw looked really severe, and I figured they could be life-threatening to me, in my opinion. Please come down, take Daisy and her children to Texas, which was a safer place for them.
And as far as you know, was that the plan?
Yes, that was the plan.
Right. Now, you live in Homestead. You live relatively close to Daisy, correct? Or you lived relatively close to Daisy, correct?
Yes.
Okay. At that time period, as far as you know, was Pedro living with Daisy?
From what I know, he was not living with Daisy.
Okay. Now, I want to fast forward to shortly before Pedro lost his life.
Mm-hmm.
Did you go to Daisy's house at some point to pick up your mother?
Yes.
Okay, can you tell me about that, please?
She had called me, I don't remember exactly the time. I know it was like early morning hours, maybe 12 midnight, maybe 1 in the morning. I don't remember exactly the time, to come and pick her up.
Objection, hearsay. Don't tell us. Well, if you have an answer. Remember, you want to say what other people told you. So with that limitation, you can continue.
Okay, so we went to pick her up, me, my ex-husband, and Laylene.
Laylene was with you also?
Yes, from the home.
I stayed in the back. I didn't get out the car because, you know, I was with injury. And I don't remember exactly what happened when I got there. I just remember going to pick her up and leaving, you know.
So you went and it was around what time?
It was late. It was maybe early morning. It had been maybe 12 p.m., 1 in the morning, but I know it was like early morning hours. Okay. I'm sorry, 12 a.m., 1 a.m., around there.
All right, around 12 a.m. to 1 a.m.
Right.
Okay. So you went, you stayed in the car, right?
Yes.
Did your cousin Laylene, is Laylene your cousin?
She's my niece.
Your niece, I'm sorry. Laylene, she got off the car?
Yeah, she got off the car to maybe help my mom with whatever she had, her bag or something. She got in the car, my husband was there.
And you guys left?
Then we left, yes.
Now, at some point later, do you end up coming back?
Yes, we ended up coming back.
Okay. All right, so without telling me what anybody told you, how is it that what happened that caused you to come back?
There was a phone call to come and pick up Daisy's children from her home because an accident happened.
Okay. So when you arrive, do you recall having any interactions with any members of law enforcement?
When we arrived, when we first got there, there was a detective. I don't remember exactly his name. He introduced himself from the homicide. He was, I don't remember his name. I just remember what he looked like.
What did he look like?
He was kind of tall, slim built, young looking guy. He had asked us for our identification when we got there, and he introduced himself from the homicide.
When you say he asked us, who are you referring to?
Me and my mother.
You and your mother. Okay. He asked you for ID.
Right. He asked us for our ID. He said he was from the homicide. And he said that my sister was in the police car.
Okay. Was that the extent of your exchange with that particular detective?
No. After he took my ID, he then called me to the back of a car. And then he proceeded to tell me that he had far worse news for me than what was going on there. And I was confused. I didn't understand, what exactly news he had for me. And he told me that my driver license was suspended for over a year and that he could take me to jail if I was driving. And I asked...
Hearsay, relevance,
I asked him if he was trying to intimidate me. And he was like, well, your driver's license is suspended for over a year and I could take you to jail. So I told him,
the state's mad.
Isn't there something more important going on here than a suspended driver's license? Because you told me you were from the homicide bureau, so I'm guessing somebody's passed away here. And you're worried about my driver's license being suspended.
And then what happened?
And then he proceeded to try to ask me some questions, and I told him that I did not want to talk to him anymore after that. So he then had a woman detective come question me.
Before we get to the woman detective, what you just described, was that the entire extent of your exchange with that male detective, or was there anything else?
Just about my driver's license being suspended and him wanting to detain me.
At any point, did you tell that male detective, Daisy must have killed Pedro?
At that point, we really didn't know what had happened because we had just gotten there.
Did you at any point to any detective or any member of law enforcement ever say, Daisy must have killed Pedro, or anything like that to anyone?
No. Only whatever I wrote on my statement, that was the only time I talked about any issues that were going on.
Okay, so you said you spoke to a female detective after that?
Yes.
Can you tell me about that exchange or that interaction?
When I spoke.
Hearsay. I'm sorry, what was the question? There was a female detective.
I'm asking her what occurred when she had this exchange with this female detective that she spoke to after the male detective.
So remember, you're not going to say what anyone told you, right?
Right, just what I
Just
said.
asking about the exchange.
Right. We just exchanged what happened a couple days before the incident.
Objection, hearsay. Oh.
So we.
Did you show anything to the detective?
Correct. I showed her the pictures of her injuries.
The same pictures I just showed
pictures.
you. Okay, you showed it to the female detective.
Correct.
And
I also showed her the messages that we had exchanged during that period of the exchanging of the photos.
Okay.
And she then proceeded to tell me that she wasn't interested in that part of the situation, that she was only interested about what happened the night of leading up until the events of when Pedro passed away.
Okay. Was there any more to the exchange? Did it end there, or was there more to it?
I just basically told her what I knew from that point on. That I dropped my mom off, that she was going to leave with my mother after the incident had happened, and that was basically what happened up until the point where he had passed away.
Okay. Thank you, ma'am. That's all the questions I have at this time.
Here comes the state. Let's see if they get a little feisty with this one. I think it's the female prosecutor, second chair, that should be doing the question, and she was the one objecting. There she is.
Good afternoon, Ms. Berta.
Good afternoon.
So you were asked on direct examination about the statement you made to police, and I don't want to misquote you.
Mm-hmm.
So you mentioned that you never told police anything about if Pedro is dead, Daisy must have shot him.
Correct.
You said you never told police that.
No, they asked me if I recall telling them that, and I told them, no, I did not recall saying that.
I'm sorry, Ms. Barreto, so I want to get this clear. On direct examination, when the defense attorney asked you, do you remember telling the police if Pedro was dead, Daisy must have shot him? You said, I never told police that. Did I misquote you?
Are you talking about when he did my deposition?
No, I'm talking about right now when he was asking you the question.
Correct.
That's what you said?
Right.
You remember giving a deposition?
I do.
The state was there?
Yes.
The defense attorney was there? A court reporter was there?
Yep.
And they were typing everything you said?
Okay.
Is that a yes?
Yes.
And you swore to tell the truth, right?
Yes, ma'am.
The whole truth?
Yes.
And nothing but the truth? Just like you're doing here today?
Just like I'm doing here right now.
Now directing court, counsel, and witness to Ms. Barreto's deposition, page 28.
Court, counsel, and
starting
witness.
at lines.
Whoa, the drama.
22.
It's getting hot in here.
Question.
Hold on. She's talking.
Permission to approach the witness, Judge?
You have to give her a copy.
I'm going to start here. Question. Do you remember saying that if he, meaning Pedro, is dead, that Daisy must have shot him? Answer. No, I don't remember saying that. Is that right?
Yes.
But today, you remember 110% you didn't say it.
Right.
So is it that you don't remember or you didn't say it, Ms. Barreto?
Well, the question was, did I remember when he asked me? And I said, no, I don't remember.
No, the question was, did you make the statement? And you said you didn't. So my question is, did you not make the statement or is that you don't remember?
But I think you just read me the question and it said, do you remember saying that? And I said, I do not remember saying that.
Absolutely. So Ms. Barreto, I'm going to ask you again. Is it that you did not make the statement for sure? Or is it that you don't remember making that statement?
I did not make the statement 100% for sure. Unless I was a psychic, then I would have made the statement. But I'm not a psychic.
Okay, so now I want to talk about other questions you were asked on direct examination.
Okay.
You were also asked about the pistol whipping situation.
Okay.
You weren't there when that happened though, right?
I was not there when it happened.
So you don't know how it happened?
I don't know how it happened.
You don't know why it happened?
No.
Where it happened?
No, I wasn't there.
Right. So the only thing you know is what Daisy herself told you happened?
Correct.
Okay. Now, you are Daisy's sister.
I am.
But you didn't live with Daisy in 2022.
No, I didn't.
And therefore, you didn't know if Daisy and Pedro were living together in 2022.
I didn't live with her.
So that's a no.
I wouldn't know who's living in her home, only what she tells me.
Right, so that's a no. You wouldn't know if Pedro was living in the home.
I didn't live with her, so I wouldn't know unless she told me something.
Okay, and you never, and Pedro was a trucker, right?
From what I know, yes, he was a trucker.
And Pedro would support Daisy and the kids?
I don't know that.
Do you don't know that?
No.
Did your sister work?
She was working.
Sorry, you can answer. Did she work?
From what I know, she was working.
Where?
At a towing place.
That was in 2022?
I don't remember what year it was. I just remember her working there.
But, so my question is specific. In 2022, do you know if she was working?
I don't remember if it was 2022, what year. I just remember her working at a tow place.
First chair comes in, hands a note. Second chair shakes her head.
So you're not sure, sorry.
No, I'm not.
Okay. Now, you were also asked about the pistol whipping, the injuries. You mentioned that you called your mom and you told your mom to come get her.
Yes.
But when your mom came down, she didn't go directly to Daisy's house right away, right?
No, she came to my house.
So that's a yes, she didn't go directly to Daisy's house. She went to your house.
Correct.
So your mom was concerned, but she didn't go see Daisy right away.
No, she went to my home where the kids were at.
Okay. And you also mentioned going to the hospital, and I believe you said with those kind of injuries, you would want to go to the hospital right away. Did I quote you right?
Yes, I would.
Do you know if Daisy went to the hospital right away?
No, I believe it was the next day.
So do you know if she called police that day either?
I don't know, I wasn't there.
Okay. Now, I want to talk about the night of the shooting. You mentioned that you went to pick up your mom from the house that day.
Right.
But you didn't get out of the car?
No.
So you didn't see Pedro?
No.
You didn't see Daisy?
No.
And you didn't see any of the kids either?
Nope, I didn't.
Now, you also mentioned that your mom came down to get Daisy because she was scared for her.
I asked my mom to come down and get Daisy because I was scared of what I saw in those pictures.
Okay, but you don't know if Daisy and Pedro were communicating from the day of the pistol whipping. You don't know if they kept communicating up until the night he was shot.
I don't know that information.
Would it surprise you to learn that they were still communicating?
It would surprise me.
Would it surprise you to learn that she went to go pick him up the night he was shot from his friend's house?
It would surprise me, yes.
Moment to confer, Judge.
It's getting spicy. It's getting spicy.
No further questions.
You were asked a question a few moments ago about you only knowing what Daisy told you, right?
Correct.
Well, you saw pictures for yourself, right?
Yes, I did.
And you saw those injuries for yourself, right?
I did see them.
And those injuries were fresh, right?
They were pretty fresh.
And there was open wounds on her head, right?
Open wounds, blood, and you can see her skull bone.
So that's not just what she told you, right?
No, it's what I saw in person.
You saw with your own eyes, right?
Yes, with my own eyes.
And what effect did seeing that have on you?
Objection, relevance.
Oh, you can answer.
I felt like it was life-threatening. I felt like...
I'm sorry. Sorry about that, Crystal.
Sorry.
You're going to pause that answer.
Do I go this way or stay
She's like, do I come to sidebar? It's so loud. Do I come to sidebar, Judge? You want me to? Which way do you want me to go? Okay. Deliberation continuing, I believe. 2 hours and 20 minutes in the Warren County case. Exposed skull, that's serious. Serious for infection, for sure. Could be other, if the wound went all the way to the skull, there could be bigger problems. Objection sustained. So she made a mistake.
Once you see that, you do, and what if anything is crossing your mind?
When I seen that, I felt like the situation was an emergency situation to where either Daisy herself or her kids had to be taken out of that situation. To me, it was not a very good place for either of them to be, and it was a very dangerous situation to where if somebody would have did that to me, I would feel like they were trying to take my life away.
All right, thank you, ma'am. That's all the questions I have.
Thank you.
Wow. It's just getting hotter and hotter in this courtroom. Each exchange gets a little more fiery.
All right.
Jury's going to step out. Prosecution is mad.
Jurors are well present as well as absent. You guys asked if you're going to confer with the first two witnesses that testified. Are there any other questions that you thought from us should have asked? I know for the first one, you were to, what about the second one? Since they're here, you wanted to call them for anything, you have that option. Does that make sense? This is the third witness that you're going to call, and do I have to also talk to them about?
It's her mother.
So let's bring in stories.
Okay, we're doing a proffer now, possibly. Of her mom. The jury is out. Who gets sanctioned first? Mom's back.
You're right there. Yeah. She already talked to you, but since you're here, it's going to take a minute. I'll go through it again. Remember, you're going to answer just the questions that are asked.
Mm-hmm.
And I've already ruled that the only incidents of prior violence at this stage that are coming in are only the incident from what the lawyers are calling the pistol whipping incident.
Mm-hmm.
I expect you to say something along the lines of came down based on injuries you saw, right? Did you observe, is there another incident of argument, Mr. Glass? Was there no incidents of violence, right? There may have been incidents.
Yes, Judge, so...
And she's already testified to that in that position, right? And I'll also be record here. I remember the record here.
I don't recall from that position. I wasn't there for the hearing.
I remember there may be an argument that you observed, after you came down from Texas.
She observed him grabbing her, and she observed some physical altercations between them.
Other than that, I don't think we expect anything else to come in.
No, just she learned about the pistol whipping incident. She got the picture. She came down, and she observed interactions between
So you
Daisy
just have to
and
be careful not to say what other people told you.
Of course, yeah.
Unless I instruct you, you can, or unless it's pretty clear from the way that the lawyers are asking that they're suggesting that answer. Sometimes they are allowed to do that.
Judge, and I'm sorry, can defense just say when is it that because I'm reading her deposition and I didn't see an instance where she mentioned they were scuffling around or something?
I don't remember specifically. I just remember her sitting and observing an argument. That's from my memory of the argument.
Correct. So when she gets picked up a couple of hours before the shooting. Prior to that, she observed interactions between Mr. Jimenez and Daisy Lincoln. There were a few times where he physically assaulted her, and she could also observe their interactions and him being told to leave, and she told him to leave, and all that stuff.
Again, Judge, I don't, if the defense can point you to a page and line number of where she testified that to at deposition at an ARPA hearing, that's different standards than at trial, and under her deposition, I do not remember reading her statement.
No.
Was she asked this for?
I don't recall if she was even.
I do remember asking her specific acts of other violence.
Yes.
I actually might hear about it here.
And she testified, because I thoroughly read it, as to the prior years, but as to the night of the incident, I do not remember her saying anything about her saying him get into a scuffle or her saying for him to leave. Anything that the defense is just proper, and I have her deposition in my hand right now.
Well, if there's a question where she says that she didn't, then great. But if there isn't a specific question, then I'm not.
Well, then we go to the other one.
Hold on,
Hold
on, stop. The reaction can't be what sounds like a nuclear option at this point. Let's just go and see first.
Judge.
If there is a question, as Ms. De Leon is flipping
Judge,
through.
It's not a nuclear option, due respect. There is certain discovery obligations by defense. There are certain things that they have to put the state on notice. Their obligations are very different than the state, yes. But the reaction from defense counsel to, well, if there's not a specific question, I don't know what to tell you, is completely flippant and against the rules of criminal procedure and case law.
Let's just check to see if someone asked her, what did you observe?
This
They
is
are
so
doing,
fiery.
with their hands on each other, things of that nature. Let's see what's in the deposition first.
Right, so that what's been going on is there's a deposition that this mom was in where she was either she was or she wasn't asked about the violence that she observed between Daisy and the victim. And if she didn't say it in the deposition, the state says you shouldn't be able to say it in the trial. Defense is saying if you didn't ask her about it, that's your fault.
And the last time I read the word, you don't swear, but you do affirm, right?
I promise.
Well,
Yeah.
right now, there's one choice over the other. Do you swear or do you affirm?
I affirm.
Okay, that's fine.
No,
Well,
no, no.
we'll say he's gonna swear you in front of the jury.
I did say something about that night, and I never.
No, just ask the lawyer to
Okay.
double check to see what
Okay.
specific questions were asked.
Okay, Judge, so I want to direct the court to, I want to direct the court to the witness's deposition starting on page 33. And when the question is asked about, I'm asking you between the years of 2016, 2017, that's when the incident of the arm grabbing situation occurs.
I'm sorry, 21.
2016 to 2017. 33. So what defense was saying is that she said that this happened the day of the incident because she was in the car, which is a ridiculous detention, Judge, because I'm reading the deposition and I will finish, because now we're asking about the date of incident. So once I finish, I will let you know if any of that was disclosed.
Whoa. She just snapped at the judge. She's not. Second chair is not happy about this. The judge started moving forward and the judge just took it. Wow. They're all looking into this deposition to see what was brought up about violence between Daisy and the victim. If anything, and depending on if it was brought up or broached or answered or presented in the deposition, that's going to impact whether or not we can hear about it during this testimony. The state is, from their frustration, might be losing. Defense is quiet right now. But they're also looking at the deposition, so I guess.
State's looking to if you find it or not.
Someone's laughing out in the hallway when the door's open. This is a little bit like strategy, but it's also, like the state said, the defense does have a burden when it comes to disclosure. There are some things they have to disclose, and they say this would be one of them. And the defense getting up there and saying, well, it's your fault for not asking, is, flies in the face of what the rules and, the spirit of the rule and everything else.
Okay, Judge, I'm going to quote this page to the court. I found it, and it's not what the defense is saying. We're going to start on page 70 of the witness's deposition. Line 23. Let's talk about the actual incident night itself. How long were you with Daisy that day? I got there at 1:30 a.m. or p.m. p.m. on the 24th. On the 24th, and you stayed until when? Close to 2 o'clock in the morning. Why did you leave? I was exhausted, really, I was jet lagged. And after this meeting, what was going on back? Question, and I don't know what that means. I'm going to have you explain. Whatever was going on, what does that mean? Answer, I got there at 1:30 and I was there with Crystal. We were waiting for Daisy to get there. She said she was going to be there a few minutes. She was at the post office. Then she pulled up in a rental, the same rental car that I'd seen her with. And so Pedro didn't know I was there. He had no idea that I arrived to Florida. So he was getting out of the car, and then he saw me, and his face just turned like a ghost. He couldn't believe I was there in front of him. So I told him, you lied to me. You were saying here that you caught Daisy with the man, and I confronted him, and I said, but you didn't tell me that you asked her back. And that you were punching her in the face, and she has wounds on her head. I said, and she said, yeah, go ahead and tell my mom why you did that to me. And so he said, I'm not going to stay. I'm really going to leave. I'm going to leave. I said, no, I think you should do a police report for me. And he said, I already called some friends. I only came with her. This is what he said, because I helped her get the rental car.
She's
her
terrible
to the shop, and since the car's still in my name, I have to take the rental car. I said, yeah, but I want you to know why you did that to her. He said, because I caught her with another man, and I know you told too late that it was your nephew. I said, but so you get to do that to her, and I told you that was my nephew, but you didn't tell me that you did that to her. And he was like, well, I'm gonna leave now. Anyway, so this white man pulled up another vehicle and he's out there talking to these 3 men. And he said, look, I haven't touched Daisy since 2016, and yeah, I lost control, but I didn't mean to hurt her. And so before he left, he pulled out a credit card and said, there's $17,000 in this car for her trouble. I'm sorry.
Can we stop for a second? Let me just, page 75, line 21. He was there, but he was choking her, and then he ran out the door.
Boom.
Is there something that preceded that? Is there other questions that preceded that?
Right, and she sits down.
In other words, in the city hall.
There was a lot of back and forth kind of all over the place during this deposition, as you heard. He grabbed her, again, page 75, line 3. Line 2, question, arguing is not violence. Tell me about the violence. He grabbed her by her throat and slammed her against the wall, trying to choke her, and I told him to stop. I'm calling the police. He said, no, don't, I'll lose my career, I'm leaving, and he runs out the door. Then a little bit further, he talks about choking her. Where's the surprise? I don't understand.
Defense is winning this one.
But the back and forth between that, I don't know. She's not specifying that it was the date of incident.
I'm going to picture all that. I think we're clear. Anything else?
As long as I can impeach her, Judge.
Okay. Have a seat. Once the jury comes back in, you'll come sit right here next to me. Similar to the argument, right?
It's coming in.
So we're the jury.
It's coming in, but the state wants to impeach her.
All right, the jurors.
Wow. Maybe it can come in through the vents. Oh my goodness. Red Pen, I got the thumbnail and I like the vents on it.
I'm your head count, presence. Y'all can be seated. Lawyers are present as well as still.
Yes, Your Honor. At this time, I call Josefina Perez.
Okay. Here comes Mom. Mom's taking the stand.
Do you swear from the testimony about to give will be a truth, the whole truth, and nothing but the truth?
To the best of my ability, yes, sir.
To the best of my ability, yes, sir. The mom said she would not swear, but she would affirm or promise. The judge says you have to swear or affirm. You can't say promise. but she said.
Good afternoon, ma'am.
yes
Could
on the
you please
affirmative.
introduce yourself to the members of the jury?
Hello, I am Josephina Perez, mother of Daisy Margaret Link.
Daisy Link's your daughter.
Mm-hmm.
Do you have another daughter?
Yes, I have several daughters. Crystal Jean Barreto is my daughter, and Gloria Gonzalez is my daughter, and Valentina Perez is my daughter, and my granddaughter that you just saw in here. My granddaughter is Laylene Yasmin Gonzalez.
You speak a little soft, so I'm just gonna ask you to keep your voice up, okay?
Okay, sorry about that.
You reside, where do you reside?
I reside within the state of Texas.
Back in 2022, did you also reside in the state of Texas?
Yes, I did.
Now, I want to direct you to around June 20th of 2022. Did there come a time around then where you traveled from Texas to come down here?
Yes.
To Florida?
Yes, I did.
What caused you, without telling me what anyone told you, what happened that caused you to come down here from Texas back then?
I saw some photos of my daughter Daisy with her head bashed in, covered in blood. She had a giant scrape on her neck. She had a giant bruise on her arm, and the message, whoever got it, when they gave it to me, said...
So remember, we're not saying right
Okay,
now.
sorry about that,
What
ma'am.
someone else told you, but you observed photos, and then you came down to Miami.
Right, but there was like a little text with it, and all it said
You
was...
observed photos and text.
Yes.
Okay. The last one, that's fine.
So these photos, Exhibit B and C, Defense Exhibit B and C, are these two of the photos that you saw which preceded you coming down here from Texas?
Yes, yes. Mm-hmm.
All right. So what were you looking to accomplish when you were coming down here?
I was supposed to be... What I was looking to accomplish when I arrived before my original date was to remove her and the children to safety immediately. We had already had plans to do that. I just had to, do it at an earlier date because of this.
Now, when you say you already had plans to do that, what are you referring to?
I was supposed to come instead in around July the 4th, and once we had all the stuff packed and the children would already be out of school, that she was going to leave with us, and Mr. Jimenez wasn't going to know about that. It was just going to be on a random date, and he wouldn't have known.
So that plan was already in place for around 4th of July.
Right, yeah, we were coming for 4th.
But you were looking to implement that plan earlier,
right?
Mm-hmm. And
Stacey,
what caused you to do that was finding out what happened here?
Right.
Objection meeting. Oh.
All right, so you come down here. What happens when you come down here?
I arrived, well, as you know, I received a message with these photos, and I arrived...
Let me stop you for a second. Without telling me what the messages were, who were these messages from?
My daughter, Crystal.
Your daughter, Crystal.
Mm-hmm.
Okay. When you traveled down here, did anybody other than Crystal know that you were coming down here?
No, nobody. Well, on my end, yes. On my family side, yes, but nobody on this end.
You didn't inform anybody that you were coming down. You just came down. Is that
right? Mm-hmm.
All right. So you come down, and what happens when you get down?
Well, like I said, I arrived within hours. I arrived at 5 a.m. and I had Crystal's husband pick me up at the airport, drop me off at Crystal's house, and he had to go to work. And I saw Daisy later in the afternoon. She didn't know I was here. I didn't want no one to know I was here.
You didn't want her to know you were here?
No, I wanted to see what was really going on. You know, I want to observe. So when she came, I saw her. Yes, I did see the physical open wounds on her head. She had a giant bruise on her arm. She had a scrape, like a mark here. And I told her, you know, that's it. We have to get out of here now. And I need you to, we're going to pack everything up and we're just going to leave.
Okay. Now, I want to fast forward to the last night that you saw Pedro Jimenez.
Mm-hmm.
You know the night I'm talking about?
Mm-hmm.
All right. So let's start off from the beginning of that day. When do you first see your daughter Daisy, or when do you first go to her house that day?
I arrived at 1:30.
In the afternoon?
Right.
Okay. And all right, so what do you do? What do you observe?
I sent her a text and I told her that I was here, you know, at her place. And she said, okay, like more or less, I'm not going to be specific. I can't remember word for word. I'm on my way.
Okay.
So.
Now you said around 1:30 p.m.?
Yeah, in the afternoon, yes.
All right. Do you recall approximately when it was that you finally left Daisy's home that night, or later that day?
Around like between 1:30 to 2 a.m.
1:30 to 2 a.m.
Right, somebody picked me up, so.
All right, so you were there for around 12 hours.
Right, but not at her house, exactly. I was with her, but I went to my other daughter's house too, with her.
So during that day, during those 12 hours, you were with Daisy for those 12 hours, but you weren't necessarily in the same spot. You went.
Right.
You went, at some point, you went to Crystal's house, right?
Gloria's house.
Gloria's house. Your other daughter.
Yeah.
And you came back. Do you recall around what time it was that you went to Gloria's house and when it was that you came back to Daisy's house?
Not exactly. I know it was nighttime when I left. And I think it was still daylight because the children were playing outside. So I would say I can't say exactly, maybe 10, 10:30, 11. Between 10:30, 11, we left from Gloria's house.
To go back to Daisy's house?
Yeah.
Gas XO, welcome to
Did you have a chance to see Pedro Jimenez that day?
That night, yes.
That night. You didn't see him prior to the evening?
Just when I arrived at 1:30.
This makes you an OG.
Okay, what did you observe when you arrived? At 1:30 p.m.
Yeah, in the daytime. I was sitting in the SUV with my daughter Crystal. We were waiting for her.
Waiting for who?
Daisy.
Okay. Go ahead.
And Pedro came out of the vehicle with her, and he had this look of shock, like he couldn't believe I was there. Oh, and then I told him, you know, why did you lie to me?
Oh.
Go ahead. You told him.
I told him, why did you lie to me? You know, you're saying that Daisy's trying to hurt you and stuff, and what did you do? Why did you do that to her? You did that to her. She didn't do anything to you. Why did you do that? So he said, I haven't touched her since 2016. So I should get some.
Objection, narrative. Sustained. He's going to ask another question. And motion, and then judge, maybe go sidebar? No, it's sustained.
Nope, no sidebar.
Right, so you have an interaction with Pedro, okay? And he was there. Did he leave at some point?
Yes.
Around when did he leave?
You mean like after I said something to him? Or what
after
time?
that interaction?
In like 30 minutes, 3 men came and they picked them up.
3 men came and picked up Pedro?
Right, he doesn't have a car, so.
Okay. All right, so he left. And when was the next time that you saw Pedro after he left with those other men?
I saw him that night I don't know the exact time, maybe 11 something, going to 12. She was supposed to take him directly home. He doesn't have a car. And she said, I'm going to take Pedro home. And
You say she, you're talking about?
Daisy said she was going to take Pedro home, so he won't come over, because if he comes, then we're going to have a problem. So let me give him a ride home. And I told her, okay, go.
Objection, narrative, hearsay. Oh, you're almost done with your thought.
Yeah, I'm just going to say that, and then I sent her to the store, and he did come instead of going straight home.
So Daisy came back with Pedro to Daisy's house.
Right.
Now, once he's there, do you observe any interactions or altercations between Pedro and your daughter Daisy?
Yes.
Okay, what did you observe?
First, he choked her for a reason, a conversation that they had, and her response made him very, very angry. And then I told him, I'm going to call the police. The second observance was
Hold on,
when...
before we get to the second.
Okay.
What, if anything, did Pedro do when you told him that first time, I'm going to call the police?
He said, don't call the police on me, or I'll lose my career, I'm leaving, and then he ran out the door.
He ran away?
Yes.
Do you know where he went?
No.
Okay.
It was inside the house, so I don't know.
Did he come back at some point?
Yes.
All right, when did he come back?
About maybe 15, so many minutes later. I was with her sitting out front by the AC unit. That's the front door. So I turned my head around, and Mr. Jimenez stuck his arm in the door, in the window. There's a broken window that is punched out. And he unlocked the door and went inside, started knocking things over. And then Daisy opened the door in the front. They have one door is on this side, one is on this side. And she said...
Objection, hearsay. Oh.
Go ahead.
Oh, go ahead. She said, get out of my house. Give me my stuff back.
Wow.
Now, she said, get out of my house. Did Pedro live there, as far as you know?
No, but, he would just stop by, like when you have your time out from the truck driving.
Right.
Yeah, he would just show up, so.
So I just want to ask you some follow-up. Mm-hmm. You said that he stuck his hand through a broken window and unlocked the door?
Right.
So was he outside and he stuck his hand into the house to unlock the door from the outside? Is that?
Right. I'm sitting at the front window, so I see the door. I see him put his arm in. He's turning the knob, like little knob that you have there. And so I just turned around to Daisy real quick and I said, hey, he's coming in through the back door.
Objection, hearsay, narrative, overruled. That's the end of her question. An answer, you can ask the next question.
All right, so he came in, he started knocking things down, and then he was told to leave. Is that right?
Yeah, I told him, no, I didn't tell him. She told him, get out of my house now, get out of here. And he grabbed her purse that had her cell phone in it. It was a red purse. And she had a pint of whiskey on top of the stove that she had bought, And so he took it and he ran out the back door.
Okay. Did you see where he went?
No. Actually, we weren't trying to cause a problem with him. That was the whole point that she made.
Hold on, there's no pending question. The question was, did you see where you went? No.
No.
I was going to ask another question.
All right. At some point, does he come back, and if so, when?
The third time he came back, it wasn't that he came back, he was hiding in the alley behind the truck.
Let me stop you. If you remember, this third time, do you know more or less what time this was?
No, we were sitting outside, in the front by the front door.
Is it dark already?
Yeah, it's dark.
Okay, all right, so the third time, you were saying?
I didn't know it was him at first. It's like really dark, and it's a shadow. Like, you know, you can see someone standing there. So I said, Pedro, is that you? Pedro. And then he moved, and he came towards me, and then he laughed. He was saying he was going to tell me some stuff, you know,
Okay.
some stuff about Daisy.
Okay. Is there any other physical altercation that occurs at that point or after that point?
Then the last one was when she went to the back. We thought he was going to be gone by then. And then she said, I'm going to look over. She went to the alley to see if she could see her purse thrown there, since she kept standing around the alley. So I told her, let's wait till the morning. She goes, no, just in case, all my things are in there. Like my cards, my phone. Let me see if it's there. And then he came, I'm trying to figure, from this way. I don't know east, west, or north. It was dark out, but he went like this, and he saw her, and he came running like this, and he clotheslined her. You know, like when you go like this, and knocked her back.
That night?
And then he said some cuss words and grabbed her by her hair and then hit her like this. You know, like you pick someone up and he put her face on the... It's like a gravel. Yeah, I could see him. And I told him, now I'm not playing with you. I'm going to call the police for sure. And he didn't say a word to me. He ran away.
Non-responsive. You finish your thought, you can say a word to you, and then...
He left. That was it. He ran off.
Is that the last time you saw him?
That's the last time I saw him, yes.
Okay. So that was the last time you saw him. Before that, if you know, how many times was he told to leave, either by yourself or by your daughter?
Many, like the parts that I didn't discuss with you. She was saying, leave, get out of my house.
Hold on, so the question is how many times?
Oh, maybe about 5 times between the both of us.
Okay, so he's gonna ask another question.
Okay. All right, so that was the last time you saw him. He left.
Was gonna be so fiery.
At some point, you leave Daisy's house as well, correct?
Right, I left later, much later. About, like I told you, the time.
How long after this last time that you saw him was it that you left?
Maybe 30 minutes. And I looked around, I didn't see him anywhere, so I told her, you know, I'm gonna go home. I'm tired, and you know, I discussed it with my other daughter. I said, I need a ride home. You know what? I don't want to be around this stuff. I told him to go, and hopefully he'll stay gone until the morning we can figure out what's wrong.
Okay. And what was the plan for the following day?
We were supposed to have a barbecue since I had just arrived. And then we were going to plan, you know, like basically her escape without him knowing. Like, I told her, you know, we can't let him know anything. You know. And so that was our plan for the next day.
Okay. But then at some point, not long after that, you ended up going back to Daisy's house, correct?
In the morning, after the police called me.
The police called you?
Yeah, it was, they told me that to come get the children and get them away, so I did.
Okay. If I can just have a moment, Your Honor.
Wow. The judge is letting everything go. Lots of things I didn't see the exception for, hearsay related, that they're letting in.
Judge, that's all the questions I have at this time.
Let's see if the state has any questions.
Oh, the state has some questions. Wait for till you hear the tone from the state here in just a second. We're going to start straight with impeachment.
Good afternoon, Ms.
Good afternoon, ma'am.
I want to talk about the story
Cowboys.
that you said on direct examination.
The story.
The characterization. Move to strike.
Yes, Judge. So
Sustained.
you mentioned on direct examination that you told Pedro on the night of the incident, get out. Did I say that right?
That I said to him?
Yeah, that's what you testified to. I just want to make sure I heard it right.
Because I got to make sure at what point, the first time, the second, or the third, because I said different things.
So you tell Miss Perez, did you, on direct examination, testify that you told Pedro on the night he was shot to get out of the house?
I told him to leave.
Okay, you told him to leave.
Right.
You remember giving a deposition?
Right.
The state was there? The state attorney was there?
Will there be a difference, the word leave and get out? I don't, there was.
So Ms. Perez, my questions.
Finish the thought.
If you're saying leave or get out, we said it so many times. I could make a mistake and say I said one thing or the other, but we did say it.
I understand, Ms. Perez. I don't want you to make a mistake here today, though. So I'm going to ask it again, okay? Did you testify on direct examination that you told Pedro on the night he was shot to leave the house?
Can you refresh my memory? Can you reread that to me? Like what was the question and the deposition?
Ms. Perez, so is it that you did say it, or is it that now you're not remembering?
No, I know what I said.
Okay, so did you say
However, on the day of the deposition, you had a mic problem, so I want to make sure that.
I understand, Ms. Perez, but my question is
I'd ask that
very
you allow
clear.
the witness to finish her answer, please.
Sustain. Finish your answer. We're not gonna go in back and forth, okay?
Right, I just don't know if that was the time that the mic kept going out.
Sorry, Ms.
Another note from
What I was saying was that when I was being depositioned, the mic kept cutting in and out. So every time I would get a question, it could have been the beginning of one question and the end of another.
Okay.
So that's why I'm asking you, at what point are you stating that I said to leave?
So I'll ask my question very specifically and you can answer, okay?
Okay.
Did you say, right now, as your testimony in court,
Right.
did you say that you told Pedro to leave the house on the night he was shot? At any point, did you say that during your questioning?
During the inside, yes.
During your questioning?
Yeah.
You remember giving a deposition?
Right.
The state attorney was there.
Right.
The defense attorney was there.
Mm-hmm.
A court reporter was there.
Right.
And she was writing down everything you said.
Right.
And you swore to tell the truth.
It's not that you swear to tell the truth, it's that.
Ms. Perez, if you allow me to finish.
Okay.
Thank you. And you swore to tell the truth, the whole truth,
Right.
and nothing but the truth. That's a question.
To the best of my ability.
To the best of your abilities,
Right.
you swore to tell the truth. Just like you did here today?
Of course.
Okay. Now directing court counsel and witness to the witness's deposition conducted on September 9, 2025. Ms. Perez, I want you to look and see where is it that you say that you told Pedro to leave the house? Any point of that page?
Improper. Sustained
Can you
improper.
point
She's
to,
gonna re-ask the question.
can you?
Where in this deposition did you tell Pedro, where in the deposition did you tell Pedro to leave the house?
No objection.
Sustain.
I cannot see.
No.
We're gonna have to re-ask the question.
Okay.
The judge is not letting in this impeachment.
Judge, may we go sidebar?
Sure, says the judge. Bring it. Come on over. Oh my goodness. Oh man. Can I just say, I'm going to call this one right now. If this trial ends in a conviction, it will then result in an appeal. Can I just put that on the record right now that's where I'm putting my money. This trial will not end with the conviction. It will end with an appeal and a new trial. This is a mess. It is so it's so convoluted and twisted, and you've got so many players involved because the judge is acting like a third attorney table. Sometimes the judge has made mistakes on simple things, simple things, like getting definitions of words opposite, wrong. Reversed herself. Lots of sua sponte type stuff where she just interjects herself in the court without an objection on the books. There has been some questionable decisions. I think several of the ones we just heard with this witness sitting on the stand, allowing all sorts of hearsay statements by the defendant in by another witness in the defense's case in chief. The whole purpose of, the defendant needs to take the stand to get those things in, and instead we just got statement after statement after statement. I realized that some of them could have been excited utterances or, effect on the listener. They've got all these things, but we heard the whole story. The whole night came in with objection overruled from the state. And the state's frustrated. And the judge is probably frustrated as well. And I think, to me, it seems like it's personal to the judge. Not the case, but the lawyers. Or it's personal to the judge. I don't like it. I don't like it when the practice of law gets so messy that the justice might be tainted or never achieved. So I would not be surprised if this ends in a mistrial. Well, I would actually. I don't think the judge would ever grant that. Like ever. Like no matter what happens, I don't think the judge would grant the mistrial. They hated each other in high school. They never got along. Change the word to spice and we have a thumbnail. We went from the only van to contraband. Now we're going from the only vent to spice. What? I don't understand. If this ends in a mistrial, on motion, we do not follow 2.0. If there's a 2.0, it needs to be a different courtroom and a different judge. We need audio that works. This is terrible. Can we zoom? Yes, we can. I'm sorry. I'm sitting here getting caught up in everything that's happening. Give me just a second to zip ahead. Oh, it's a long one. Okay, hang on.
Permission?
There we go. Okay.
Permission to approach, Judge? Now, Ms. Perez, where on this page do you say, I told Pedro to get out? Page 70.
So objection overruled was now overruled by the judge. Judge reversed herself. We're now getting the... Now we're getting into the impeachment using the former. I don't like this question.
Please let us know when you're done with the page.
Where did you say that? I don't like this type of question at all. But I have a terrible memory, and I'd never be able
about it?
Do you see on this page 70 where you stated that you told Pedro to get out of the house? Is it yes or no?
We're not even in the house at this point. You said you're asking me at 1:30.
Where on this page do you mention that you told Pedro to get out of the house? It's just yes or no.
What is this in reference to, ma'am?
Okay.
That's why I'm confused because I'm not in the house at this time.
We're going to start with this line where it says, starting on line 23, let's talk about the actual incident night. And I want you to start reading from there.
Yeah, it says I got there at 1:30.
So the question is,
Yes,
the question
ma'am.
about tell us what happened that night.
Right.
Okay, review the pages in front of you.
Right.
Did you ever inform the lawyer who was questioning you that way?
That you told Pedro to get out of the house?
I never got a chance to tell him anything. That's the truth.
Ms. Perez.
That's your answer. Let's ask another question. We have another question.
Okay.
So that's a no. Okay. So now you were also asked about coming to get Daisy after the pistol whipping situation.
Right.
You weren't present when that happened, right, Ms. Perez?
No, I wasn't.
You don't know how it happened?
Not based on my own knowledge, no. I wasn't here. I wasn't there.
You don't know where it happened?
Nope.
You don't know the context of that whole pistol whipping situation, right?
As if knowing that would make it better.
I knew about it, but not because I was there. Someone told me, the other party that was there.
And that someone that told you was your daughter?
No, my nephew also told me.
Okay, but you only know from what they
Right.
told you because you weren't there.
Of course.
Now, you live in Texas, correct?
Yes.
And you lived in Texas since 2011, is that right?
Mm-hmm.
And Daisy has lived in Homestead since 2011, you would say?
Since she was born.
So since she was born,
Right.
so that's a yes?
Of course.
Okay, so, and your relationship with Daisy isn't close, you would say?
Well, we talk every day almost.
Okay.
Even
so-
though we're far away, yeah.
But you don't know about the relationship with her and Pedro on a daily basis?
Only verbally, by conversation.
Only what she tells you?
Right.
And you would actually speak to Pedro on different times?
Yes, I do.
You had a good relationship with Pedro, a consistent relationship with Pedro, I would say.
It wasn't good, and it wasn't consistent, but I did keep a relationship with him as well.
He would call you.
Right.
Now, you were also asked about the
Legally
date of
blonde, thank you
incident.
very
So
Mm-hmm.
you came down to get Daisy and pack up, right?
Yeah. Mhm. That was the plan.
But then you mentioned you were going to have a barbecue the day after.
And
So were you having a barbecue or were you trying to get her out of Miami fast?
the barbecue has nothing to do with how I was going to get her out. I mean, we were going to have a barbecue as a family.
So I'm just trying to figure out at what time between you coming to Miami and you having the barbecue, what time are you packing?
Off and on. She already had stuff all over the floor to wash and everything. We're not making it obvious that she's trying to leave. It's supposed to be like nobody's going to know.
Okay. You also mentioned you saw Pedro that day. Is that right?
Are you talking about?
The night of he was shot.
Yes.
Isn't it true, Ms. Perez, that Pedro was the one who got the rental for your daughter?
Yeah, the truck was still in his name.
So he was the one who got the rental for your daughter?
Right.
And isn't it true, Ms. Perez, because you were there, that they were driving up and down together?
No, they arrived together at the apartment. I don't know if they were up and down. He didn't even know I was here.
We'll break it down then.
Okay.
When they arrived to the apartment, they arrived in a car?
Yes, and
They arrived together in the car?
they arrived together.
They were with the kids as well? At one point?
No, they weren't with the children.
So if I were to show you ring camera footage before he was shot with him, Daisy, and the kids, would you recognize that?
I don't recall the kids getting out of the car. I recall him and her getting out of the car. So, I mean, yeah, you would have to check that.
So, Ms. Perez, I'm kind of confused with your timeline. You were there at the house the night Pedro was shot, correct?
Yes.
And the kids were also at the house before he was shot.
They were with us, though, not with him.
But Pedro at one point comes to the house with
Right.
Daisy in the car.
She was supposed to give him a ride home.
Okay, so we're going to start at the beginning. When you first get to Daisy's house, isn't it true that Daisy and Pedro arrived in the car together?
They arrived together, yes.
Okay. Now, isn't it also true that they were driving multiple locations together?
When they arrived together, okay, and he saw that I arrived there, and we got into that conversation about what happened to her, I told you he left with 3 men.
So he left the house?
He didn't go in the house. He stood right outside and talked to me about the incident, and then he left. He said, I called some friends, I'm
He
leaving.
left with his friends?
Right.
And isn't it true, Ms. Perez, that your daughter went to go get him from those friends' house?
She went to go, you want me to tell you why?
Ms.
Okay.
Perez, I
It's
just want you
either
to answer yes or no.
Okay,
Isn't
yeah.
it true that your daughter went
Yes,
to go
she
pick up
did.
Pedro from his friend's house?
Right.
So your daughter is so scared that she goes to pick up Pedro after he leaves from the friend's house?
She was supposed to take him home so he doesn't come and harm us. So she's trying to cooperate with him.
I understand, Ms.
Okay.
Perez, but isn't it true that your daughter was the one who decided to go pick up Pedro?
Well, it'd be better than having him come to the house where the children were.
Ms. Perez, my
So
question is very specific. Isn't it true that your daughter was the one who decided to go pick up Pedro? He didn't ask her to go pick him up.
I don't know that.
Would it surprise you to learn that she told the detectives that she went on her own will?
No, sidebar, please.
Whoa, the judge just chimes in, no, sidebar, please. Okay, now the judge is getting mad. I think the prosecution just went somewhere they were not supposed to go, and she had told them not to do. That's the tone you get from the judge. No, sidebar, please. This is so good. I'm sorry. I wish the audio were better. Let's zoom through this here really quickly. There's tiny volume, but it's just so bad I wouldn't be able to turn it up and hear it at all. It's a long sidebar. Holy cow. Oh, here we go. There we go. Not sure when the jurors left.
Georgia, give me more cups, please, so I can put it in this. Does anyone have cups? Is that?
I have some cups on in the room over there.
What kind of cups?
All right, do me a favor, we'll bring you water outside, can you just step outside?
Over there?
Yeah, maybe you want to do it.
Who has cups? We go drink your water outside. What is going on?
All right, let me see these text messages. Yes, Judge.
The state's trying to look busy. I think they're about to get ripped a new one. Upset Baguette, thank you very much. It is a long stream today, but we're going to get this one done and get caught up. All three attorneys.
It's just those first two.
Prosecutors are doing a huddle at the podium right in front of the mic.
I'm looking for June what?
19, Judge. It's a little box at the top.
There's a line of
that.
question, or there's a line of text messages from the defendant's mother where she says something to the effect, "You're hanging around with certain people, you're on drugs again."
Who has cuffs? Then she said, go drink your water. Maybe the judge was saying, cuff up, cuff up. That loud laughing right outside the courtroom. The bailiffs in the hallway should be putting a stop to that.
Judge, I want to bring this to attention. I stepped outside for a moment because I heard laughter, and honestly, I went to use the restroom. Each and every one of the defense's witnesses are all sitting next to each other, all discussing things. I don't know the context of what they're talking about, but the rule of sequestration has been invoked. This has been a problem throughout the entirety of this trial.
Okay. Please measure your response. Mr. Tomas, can you just go check outside to make sure we're not discussing your testimony?
Yes, ma'am.
Wow. Just poked my head outside.
Apparently one of the witnesses is watching the trial on YouTube right now. And I think that's what they're laughing about.
One of the witnesses is watching the trial and is in the comments?
I'm sorry, we're not talking about your testimony.
Judge, the entire trial is
Hold on,
playing.
the last one here. Let's just go to the last one. Yeah.
This is a mess. Wow, this is great.
Did you?
Yes, she wasn't talking about her testimony.
That was made. I told Mr. Rita that he's still not talking about the testimony. He's made a comment, and I don't think we realized you weren't here. The students here that they're laughing about it. We tried online, so I said we're still not talking about their testimonies, and then we came back to him.
Right, she wasn't talking about her testimony, but I told her, look, just when you're in the middle of your testimony, just sit over there and just don't talk. So that's what they're doing.
Judges were watching the trial.
Who's trial?
Any of the witnesses. We were informed that the last witness, which would be Josephina Perez, is actively watching the trial, watching playback of the trial, laughing at comments of the trial.
Says who to you? Do you want me to, if you're going to make these allegations, please make sure to back them up so I can have an evidentiary hearing. So if I need to hold someone in contempt, I can do it appropriately.
As soon as Mr. Alcala comes back, I will ask him who texted him this, but that is wildly improper for a witness to actively be involved in a trial to that manner, and I absolutely think that we should be having that evidentiary hearing.
You need to bring me names and a body, and then we can have evidentiary hearing.
I'm getting that information right now.
Okay, somebody texted prosecution saying a witness is watching the trial, and he just walks out. Everybody's texting now. DSN, thank you for the super sticker. This is so bad. It's gonna be a defense witness. Obviously, all the state's witnesses have pretty much been released. State prosecutor number 1 goes back out in the hall to check on defense witnesses. Storms out of the room. Slams the door. This is what losing looks like, and losing badly. The judge is at fault for a lot of this. She should have much better control of her court. Defense is just sitting there smiling.
Okay, so the text message you guys want to introduce is, I'm going to come here to finish the job, something you should have been doing. You should have been doing yourself. You've been hanging around Pager's friends. That's why he's no good, and neither are you, but he's going to jail, and so are his friends. I'm going to find you for it. That's what you all want to introduce?
Judge, sorry, can you read it again?
Which text message do you think she opened the door to? I have it on page 16.
It's where it starts. I'll tell you right now. It starts.
He keeps going.
Yeah, I know you hung up. Starting with that one.
What page?
Page 5, Judge. Well, I don't know if you have page 5. Judge Ennis, I can just point it out to you. Yeah, approach.
Number 1 just headed out to the hall.
Can you stand up, please?
Which text message is it? Is this the only one or is there more?
That was the only one.
Tripping over the power cables. It's like this courtroom is a major OSHA violation. Just
Yes.
going over text messages, I think, between her mom and maybe Daisy.
Guys, I need the messages so I can make a rule.
So it's these two? Okay, so I guess it's page 10 and page 5.
And 16.
Yeah, there's a context that starts out with pictures from what we just saw here, right?
No, Judge, the pictures of a baby.
Judge, those pictures are in evidence or have been in evidence?
No, my question is, these text messages between Ms. Lincoln and her mom, right?
Oh, yes.
Right.
Yes, Judge.
What starts the back and forth between her and her mom? Aren't there pictures from the quote-unquote pistol whipping incident?
Well, Judge, we know that from her testimony.
Okay, well, am I not looking at these in context?
Okay, so you want the first pictures?
Yes. So.
Look at the arms
so first is
folded.
page 6. And then, Judge, if you want the context, then can I see page?
I know the context, but they're in order, so
Right.
let's put them in order.
And so here's page 11 to 11, 12, 14, I think you have 16. Okay, you have, so start, this is the first page of 16, 44, 17.
Okay, so do you want the text message on page 7?
Yes, Judge, so the state is requesting the text message on page 7, on page, I think it was 11, on page 16, and if the court wants to give context in 17 as well.
This is from this
So
afternoon.
the text on page 7, what else?
7, 11, 16, and 17.
Shelley Kelly, this is all spice. The prosecution is spit and fire, alleging all sorts of sequestration violations.
Do you have 5, Judge? So it's 5, 6, 7.
They're trying to impeach Daisy's mom right now with some text messages.
Right, so it starts on 5. And then,
Well, I need to figure out today before you lose the kids for this time.
yes, that's the.
Having people you don't even know watching their kids, like leaving them, like leaving the OR with your kids. What bullshit is that? That's what you think she opened the door to?
Yes, Judge, because if you continue to read the messages, so basically she said she came down here to bring Daisy to Texas, but those messages, which are highly relevant because there are 6/20/2022, which is.
So, okay, the one on page 5 that I just read is from June 16th, 2022.
Yep.
Okay. The one on page 7 is from June 16th, also 2022. And which one do you guys want to introduce in that one?
What page are you on? 6, Judge?
On page 7.
No, Judge, we don't want page 7, but the court was saying context.
Okay, so. Withdraw withdraw the request from page 7.
Yep.
All right, what about page 11?
Page 11. Judge, we want page 10 and 11 to give context. All right, so if you start on page 10, she starts talking about before that was a head injury, so it's a continuation of it.
This is nuts. Prosecutor number 2 is making me laugh.
Well, what's the text message in page 10?
Where the witness literally says, I don't give a shit about you, now all I care about is the kids.
And how does that open the door?
Judge, it opens the door because this witness is literally saying that she came down here for Daisy's safety. She was so scared about Daisy. She was so scared for her safety. And these messages literally prove that she was trying to come down before this incident to take the kids away from Daisy.
And page 11, send them to me before they take them away from me forever?
That's the kids.
Okay. And what's on page 16?
Page 16. Okay.
I'm going to come here to finish the job, something you should have done.
Yeah, Judge.
You should have done it yourself, because you've been hanging around with Pedro's friends, and that's why he's no good, and neither are you. But he's going to jail, and so are his friends. I'm going to find each one of them. So, This to me indicates she has a problem with Miss Link having her kids hang around Pedro and Pedro's friends. How does that open the door to any other motive that this grandma has to come and pick up her kids?
Judge, the messages
so to keep the kids away from Miss Link and not from the outside force.
The messages before that, she talks about taking them away from Miss Link because of Miss Link. Now on this page, she's adding to that and mentioning Pedro and everyone else. But if you go back, she's first talking about Miss Link. And she says, if you don't get your shit together, it literally says that.
Which we also have a court order entered into evidence already by defense for something of limiting the parental rights, which we know that Ms. Link also had her parental rights limited. There was a family court case based off of that alone, which this in greater context when the defendant's mother says, look how hard you work to get your kids back. Do you want to lose them forever?
What's on page 17 that you all want?
Not sure if the judge is convinced. They're trying to open the door to something that has not been allowed in. They think that...
Nothing, Judge.
17 is also drawn. All right, Mr. Tomas, what's your response?
Judge, I don't think she's done anything to open the door to that. I don't see how this impeaches her.
Judge, yes. So the defense opened the door because the witness has testified on multiple occasions at this point that the sole purpose that she came down here was to take Daisy away from Miami to move her to Texas. And that's basically she was scared for her safety and she was scared about Pedro. So the witness has opened the door, Judge, because these messages go to prove the exact opposite, which was that she wasn't scared for Pedro. She was literally, a couple days before this entire incident, was going to come down here and try to take the kids from Miss Link based on Miss Link's actions and what she felt was not being fit of a mother. And then add to the other text message about Pedro and his friends.
So would you agree that part of this message has to do with Ms. Perez discussing some prior action by Ms. Link, maybe drug use, but also the behavior of Mr. Jimenez and his friends? When you're talking about her being a bad mom, do these messages contain both of those quote-unquote allegations from Ms. Perez? You want to impeach her by saying,
yes, Judge.
No, you really came down here because Ms. Link is a bad mom, right?
Yes, Judge. Yes,
so when in the text messages it talks about not just how hard Ms. Link fought to get the kids back, maybe some drug allegations, but it also talks about Ms. Link letting her kids hang around Pedro and Pedro's friends, right?
Judge, so...
Right?
Okay.
In context, right?
Judge, if you want to give it context, that's correct, Judge. But again, I feel like the court is shying away from the very first start of these messages are about Ms. Link, her drug use, or whatever she's accusing her of, Judge. Now you come to the end of that conversation, and the court is now emphasizing, oh, it's also Pedro and his friends.
You know what's relevant? Hold on, you know what's relevant right now for my purposes? Let's start on page 8. When the pictures are sent 5 days before the shooting, because just about everything beforehand is not relevant to me.
Judge, so the page that the state wants is not relevant? I'm confused.
Answer my question. Is there anything else you want to add to the record? I'm not inclined to let them in. Try to convince me otherwise. I don't see that this is opening the door. Also, in the full context, Ms. Perez is complaining about Mr. Jimenez as a father. Complaining about him as well.
So you just stated, the court just stated, you don't see how we open the door. I, on cross-examination then, am going to ask her, did you have any concerns about the kids being with Daisy at any point up until before Pedro was shot? And if her answer is no, Judge, the case law is clear that we can impeach by any means, including extrinsic evidence, and if she denies those messages, then they come into evidence.
You guys really want to try this a second time, right? You guys really want the conviction to try this a second time?
Judge, it's not
my frustration of how
of course, Judge.
Me into error.
Judge, I understand the court's frustration, Judge, but you also have to understand.
Leading me into error by focusing on her parenting skills, number one, maybe drug use, uncharged crimes, number two, and how in the full context of which you want to extract essentially half of the text messages to show how Ms. Perez thinks her mother is an unfit mother. There's also parts of this where Ms. Perez thinks Mr. Jimenez is an unfit father.
Judge, so I understand the court's frustration, but you also have to understand the state's frustration because the defense was allowed on direct examination to present all of this testimony, essentially, basically saying that Pedro was this sole aggressor, that basically putting in the light that he was the one that caused everything, that everyone was scared of him, Judge. But you have to put it into context, Judge, which we are allowed, and she also mentioned, Judge, let me ask, that I asked her, are you close to her? And she says, we're close, we talk every day. And these messages go to show that they don't have the great relationship that she has painted on direct examination. We should be allowed to tell the story, not based on what defense is just saying. We should be allowed to impeach witnesses with their own testimony about things that they're painting in a different light. We should be allowed to explain that and impeach.
All right, thank you. The request is denied. Everything must be seen in context and relevancy. She didn't necessarily open the door.
That was one issue.
On some level. One introduced text messages out of context relating to the possibility of uncharged crimes that are years old, because we know that there may have been a DCF case against Ms. Link, but it's years old. And her testimony is not inconsistent with regards to the primary reason that she came down to retrieve the kids. And I might add, those text messages start a chain of conversation, which starts out with pictures of Miss Link's injuries to her mother. It's not inconsistent with what she was talking about, which is her primary motive of coming down here to retrieve Miss Link as well as the kids.
Okay.
Your objections are only for the
Next issue.
Judge, I'm going to ask at this point that we have a
evidentiary hearing.
Do you want to mark them so that if it just goes up on appeal, you have it?
Sure. I'm also going to ask that we can conduct a contempt hearing at this point. I just also received screenshots of Ms. Paredo's Facebook page where she is actively posting and commenting about this trial while the state's witnesses were testifying. I have numerous pages of screenshots showing that. News articles, commentary from YouTube, etc. Ms. Paredo just testified a few hours ago.
So it sounds like something I can take up after we adjourn.
Sure. I think
I'm not going to waste this jury's time. I had a hearing right now. So we're going to keep this moving for now.
I understand that, Judge, but we also need to potentially also have one for Ms. Perez. I have somebody from the state attorney's office who actively saw as she went out, she was speaking to Laylin and Crystal with a minor child still there who has yet to be deposed, talking about this case.
What is she saying? What are the words that will come out of her mouth?
I can bring that person in, like I said, but it doesn't really matter.
You have to have a good faith basis. It doesn't matter.
I absolutely do have.
Ooh, I got back in there.
No,
that could be talking about.
No, they were watching the YouTube feed of this case and laughing about it.
You have to be specific. If I'm going to pause these proceedings, have a contempt hearing, we're going to have an evidentiary hearing for the past.
Contempt hearing.
Judge, like I said, I can bring that person in who saw it.
Will we do it right now?
What's the other remedy here, Judge?
The other remedy is for you all to be prepared to ask me to pause this so that I'm not having this jury hang out in there for 30 plus minutes.
Judge, the remedy is to pause this trial now because this witness's testimony, who's actively testifying in this case, has been actively watching the proceedings of this case. When the rule of sequestration has been invoked, we need to get to the bottom of what she actually has been watching and doing during this trial because her testimony very well will be tainted.
Yeah, but you're guessing.
I'm not guessing. I have this.
I don't know what's going to happen when I bring this witness in, but it better not be a waste of this jury's time.
Judge, I absolutely have. I have screenshot of Crystal Paredo's Facebook page posting these things from 5 days ago. It is one thing to say, my sister's on trial and I'm really scared for her, etc., etc., etc. It is another thing to do when this court has already kicked her off the Zoom once, when we're about to start opening statements here, when this court has instructed the defendant that her family is not to be involved in these proceedings, to actively be doing those things. I get that this is a high-profile case. I am well aware of that.
Listen to me. I've been doing this for 21 years. I take every case seriously, whether the cameras are here or the cameras are not. Every defendant matters, whether it's a drug case, something simple or something more serious.
I agree with the court.
Cookies are here.
I'm not saying the court is doing that.
Cameras don't matter to me.
I agree.
I wish they mattered, they didn't matter to others as much as they do.
I agree with the court.
Go ahead.
I'm not sure we'll get to the end of the day without a mistrial.
Coffee's gonna buy us more time.
I agree with you.
Then move this along. How else do you want to proceed?
I think we
All right,
have.
Mr. Tomas, go outside. Please tell Ms. Perez not to discuss this case with anybody else. We've already told her that. Make her sit far away from others.
Yes, ma'am.
Bring in the state attorney person that told you.
Okay, here we go. Oh my goodness. We're doing a contempt hearing. Judge slams down her empty coffee cup. She bought the jury coffee and cookies, I think, which has just been delivered. That'll buy us some time, she says. The state is alleging that the current witness has been posting on Facebook as long as 5 days ago about things she's watched on the trial as she followed along on YouTube. It's getting rough. It's getting hot in here. The judge seems to be a pendulum, swinging back and forth, and now she's picked a side, sort of. I hope she wasn't watching our feed. I hope she wasn't. Don't think she was. Haven't seen her in chat at all. We are streaming this one. We just had they had a break yesterday, so we had another court case that we were picking up during the break. Yeah, this is mistrial. This is the final dust is clearing after the train wreck in a mistrial. Yeah, it couldn't be us on this one. We do not condone witness to watch, but please like and sub. That's funny. All right, bring in the state attorney person who is going to testify to exactly what the witness did and or said when she walked out of the courtroom just a few minutes ago.
Judge, she's in the middle.
Can you go get Mr. Tomas?
I don't know what it is.
Now we're missing the defense attorney.
Would you like me to forward these?
Hold on, so we're gonna wait until Mr. Tomas comes back.
No, I'm asking the court if you want me to forward these to you and defense counsel.
Hold on, just wait for Mr. Tomas.
He's now forwarding the screenshots of the Facebook page for Crystal Barretos. Amber, do you have this page yet? Yeah, we need more screaming goat for this one. Here's the.
Yes, sir.
Mr. Tomas is in the back room.
We assume that in Warren County they're still deliberating.
Sorry, Judge, mental question.
So, Judge, Mr. Perez is in the middle of taking a plea in front of Judge Brinkley. To me, from what I've been told, I don't think that he needs to testify here. But what I do think needs to be put into the record, and Ms. Barreto should absolutely answer for these. Yep. And then I think that Ms. Perez also needs to be questioned. As I mentioned before, Ms. Perez, Ms. Gonzalez, and I believe Ms. Barreto were all outside speaking as I stepped outside briefly. with the minor child in tow. I have no doubts based off of these, and I'm going to send these right now to everyone, that they have been actively speaking about this case. And I think the court needs to do an inquiry of these witnesses about that, because this is actively a violation of the rules.
You're guessing right now.
Judge,
You just send me what you have, and I will review it.
It is not a yes when I'm holding it
They
in my
are
hand.
family. They are family, right? So if
They're not just
talking-
family.
If they're talking to each other, what are you expecting to do when you stand outside? You have to bring me something more than just, I walked out.
Judge,
We're
we
together talking.
Judge, no.
No?
Absolutely not, no.
Okay. Did you overhear them discussing this case?
I watched Ms. Perez be handed things, yes. I saw the YouTube feed myself, yes.
Let me see what you have. Go ahead and give it to me.
Wow. I saw the YouTube feed myself. Barretos, I think it was. Something like that.
It was just something.
Anyone can make it fate. They're talking about them literally watching in the hallway on their phone right outside the courtroom. Like they're watching this there. Oh my goodness. This trial needs more goats. Judges talked about cameras, and I'm a little nervous that the fix going forward might be to get rid of the cameras.
Okay, so in context of what? This is Ms. Moreno sharing it on her Facebook page?
Right, and I've actually watched some of those videos. There's live feeds in there. I don't recall the very first post, but I've watched that video myself, in which that person is actively talking about what the state's testimony was. There was conversations about how we went sidebar about hearsay objections in that as well. These articles specifically talk about what was said and what was not said in trial, what came out during trial as well. Again, these are not just family members. These are defense witnesses, one of which has been excluded that I'm hoping to take the deposition of today, who very well be, and I will remind the court, only a few weeks ago, Ms. Link herself said that she was talking to the child about the case. There are huge issues when it comes to witnesses speaking about the case prior to and during and after their testimony, and there's a reason that the rule of sequestration exists. There's a reason the only person allowed in a trial during other witnesses' testimony is the defendant and not other witnesses. So that way they don't change their testimony to corroborate other testimony. That is what this is showing, that Crystal Pareto is actively watching this case, actively, whether it's on a live stream because Your Honor kicked her off of the Zoom, posting about it. There's no commentary, sure, but there's a difference for, like I said before, being scared for your sibling because they're facing charges versus violating rules, and that is clear as day here.
What's your response to us?
Judge, my response is what I just saw in the email from the state shows that a post was shared. That's it. So you can certainly inquire.
Multiple posts.
Multiple posts were shared. That doesn't mean she viewed it. That doesn't mean she consumed it. You can inquire, but there's no.
Isn't one remedy to call this, to have her called back and the state can impeach her?
No, I think the actual remedy here would be exclude all of her testimony.
Okay, that sounds like a movie.
Kathy!
Judge, I don't know how many times we have to have somebody violate things, do things they're not supposed to. There is, the other remedy would be what? To impeach her and say, you watched this case?
Bring her back in. Bring her back in. Bring Crystal back in.
Crystal, correct?
Yes.
I think she may have gone downstairs. She's not out there, Judge, but I'll
Can you bring Ms. Perez back in here also?
5 days ago, Crystal Barreto did post on Facebook Kathy's GRI Daisy Link Day 1.
You're still on the road, okay?
She also posted some.
Talk to anybody before you testify here today about what you would be testifying to.
Did I talk to anybody? No, because I didn't know what I was supposed to be testifying to.
Did you watch any coverage of this trial?
No, I did not.
I have to open it up to the lawyers to question you, to see if any witness, including you, has been talking to each other, because that's not allowed. Once the rule of sequestration has been invoked, witnesses are not supposed to talk to each other about the case. For obvious reasons, they can't match up their stories, right, or their testimony. They also can't know what other witnesses testified to, because that would affect their testimony. That sort of makes sense, right?
Yes, it does.
So let me see if the lawyers have any questions for you.
I know the state does.
The state judge? Yeah, you guys, you can go first.
Ms. Perez, how did you get here today?
I came by car.
Who did you drive with?
I drove with my daughter Crystal.
Did you and Crystal discuss the case of your testimony on the way over here?
No, I just got here at 5 o'clock. I got to her house at 5, and then my sister was the one who brought me from the airport to here. And then I went to sleep for a while, and then we were on our way.
Were you watching the YouTube channel that records the entire trial?
No. Actually, I don't live here. I'm with the kids, so I'm not going to put the YouTube channel on.
Are you aware of Ms. Barreto watching the YouTube channels that capture the entire trial?
No, I don't know. I just got here today.
5-10 minutes ago, when you were excused from your testimony, were you and Crystal and your other family members watching this trial actively on YouTube and laughing out loud?
No, I told her I got put out, and I don't know what's going on. That's what I told her. I said, I don't know what's going on. They told me to leave.
What were they doing?
I don't know.
You don't know what they were doing?
No, they were sitting there.
On their phone?
Yeah, I think so.
So you couldn't hear anything?
No. Ma'am, I just approached them and told them, they asked me, why are we out here again? I said, I don't know what's going on. Why? She goes, oh, they were laughing. They said, oh, you probably said something, or you just kept running on, and then Mr. Tomas told me to go sit on the other side.
They didn't ask you about your testimony?
No. They didn't, no.
You know you're under oath, correct, Ms. Perez?
Yes, sir. He should know. He was standing out there right by me. And I told my granddaughter, look, go outside.
And was PJ in the middle of them?
I don't think so.
Where was PJ?
He was sitting with them outside.
So when I asked if PJ was
He's supposed to. He's only 11. Do you want him to sit by himself?
So Ms. Perez, when I asked you if PJ was in the middle of all of that, you said no.
In the middle of all of what?
Was he with them when this was going on?
When they asked me why I got put out?
When they asked you why you got put out, when they were on their phones, when they were outside?
Ma'am, I don't know what they were looking at on their phone, first of all. What he saw or heard, I don't know. I just walked right out the door, and Mr. Tomas came a few minutes later and says, you're not supposed to be sitting together or else they're going to think you're talking. I didn't talk to anybody. I just walked up to them and said, I don't know. I got put out right now. I don't know what's going on.
Ms. Perez, what's in your hand?
Oh, my cell phone.
No, what paperwork is in your hand?
I don't know. Am I supposed to have this?
Ms. Perez, what paperwork is in your hand?
My testimony, my deposition, right?
Ms. Perez, who gave you your deposition in the middle of your testimony that you are live testifying?
Yeah, I didn't have this. I just came in with it right now.
Judge, who gave it to you? Who gave it to you, Ms. Perez?
Aren't I supposed to have this?
Ms. Perez, who gave you your deposition? Hold on, we're going to get back and forth.
I don't know what's going on. Am I not supposed to have this?
You can have it. Where did you get it?
I thought I got it from the attorney.
Judge, she thought she got it? Judge, she's not.
Wait a minute.
I'm done with your question.
Judge, Ms. Price.
What?
About 5-10 minutes ago, when you finished up with your testimony, he handed you that deposition.
I've had this in my hand, but,
While you were testifying.
no, I had it, it was outside.
Right. Who handed it to you when you walked back outside?
I don't remember.
Okay, so.
And I'm being honest with you.
Right. I can tell you because I watched it.
Okay. Yeah, I thought you were watching for something, but I didn't know what it was.
Lynn gave it to you.
Oh, did she? Okay.
And Lynn was sitting right next to TJ.
Okay.
You remember that?
Yeah, I don't know.
And then you were actively looking at a computer with a live feed of the YouTube feed from Long.
I was?
Yes.
No, I was not. I just walked out the door. How is it that I watched a live feed when I just walked out the door?
When you walked up to Lynn, she handed that to you, and there was a live YouTube feed from Long Prime. Do you remember that?
No, I don't. And you know what? I'm going to say something. That is the truth and the God's honest truth. I just approached them. They asked me what was wrong. And you know what? I am so exhausted with you, sir. I got here at 5 in the morning. I didn't hold a conversation with no one. I passed out when I got to my daughter's house. Then, if somebody even handed me this right now, I wasn't even paying attention to that. And now you're accusing me of watching a live feed? You think that I would allow that little boy to watch a live feed? That's insanity what you're saying right here now. I would never do that.
You're not going to get that. Do you know why you're not going to get that? Because you have to lay a reason to do it. Do you understand? We don't go from 0 to 10 like this.
Judge, I would ask that this witness please be excused before we make further.
Why don't we do this? Why don't we give the other side an opportunity before we start making requests in front of the witness?
I wasn't making a request. I just asked.
Mr. Maria made the request, right? Why don't we just measure our words and our requests? Yes, Mr. Tomas, do you want to hear from Ms. Perez?
Briefly, Judge. Ms. Perez, earlier today, when I first saw you, I gave you a copy of your deposition and I asked you to look through it, correct?
Right.
And that was well before you testified.
Right.
Have you looked at any of that since you began testifying?
No, actually I've been walking around with it in my hand, sir. I tried to look at it and guess what? I didn't. That's why I'm asking them to read it to me because I didn't read it.
All right, thank you. Please go step outside.
Okay.
I think Crystal's out there now.
Here. Let me give this to you because...
Ms. Perez, I want to remind you, don't talk about your testimony with any other witness.
Yes, ma'am.
Thank you. Ms. Perez.
Wow. You caught that? That was a well-read copy.
You're still under oath from earlier today. You're still under oath from earlier today.
Okay.
5 days ago or so, you shared some posts from the coverage of this trial on your Facebook page.
Yes.
Did you watch them?
No. Post them because people always coming to me about my sister, asking about things about the trial. So anytime I see anything that's on my feed that just pops up, I guess, because it pops up on my Facebook feed, I just share it to my story or share it to my page.
You did not watch any of the coverage?
No. Well, I was told I couldn't watch anything of the trial.
Did you talk to any witness about your testimony before testifying?
About my testimony?
Did you talk to any other witness, such as your mother or Laylene, about your testimony before you testified?
No.
Did any other witness talk to you about their testimony, such as Laylene or your mother, before they testified?
No.
I have to open it up to the lawyers to see if they have any questions for you.
Okay.
When you said that's how you were done testifying, did you watch the live feed on YouTube?
No, I was just scrolling through my Facebook.
Okay, so you never looked at YouTube?
When I went outside after I was done testifying, no.
So if I have no further questions, then I will be on the witness.
Okay. Do you have any questions for her? All right, you go ahead and step outside. Who's the other witness you can call?
I'm going to be calling on Derek.
All right, bring Mr. President.
This is a mess. I do not think a prosecutor would put their career on the line to lie and say, I saw somebody watching the live feed right outside the courtroom. If it didn't happen. I mean, this might be a situation where security cameras might prove this. But I do have credibility issues with the last two witnesses we just heard from. It just doesn't sound right. Somebody from the Attorney General's office is going to stand up there and put his bar card on the line to make a false allegation. I just don't see it. Let's subpoena some phones. Let's get celebrating here. I've had a problem with the laughter out in the hallway. I realize that's the family. But the whole family's been subpoenaed. They've been sitting out there all day. They're going to talk, as long as they don't talk about the trial. The Facebooks have Kathy GRI day one posted. Automatic gal, this is a mess. This is a mess. We're watching the last little bit of trial here for Daisy Link today. While we're doing that, we're also watching the courtroom in Warren County to see if the jury is going to reach a verdict, which I don't know how late they're going to stay. They might have gone home by now. The camera will never stop. Oh yeah, it's YouTube X, Facebook, YouTube, all the YouTube's on there twice, but yes, all the social media platforms probably have somebody covering this trial in one way or another. But the judge saying, "You really want to do this trial twice? You really want to do this trial twice?" Oh my goodness! Is that guy watching the security video? He might be. That particular bailiff normally is on Facebook or Candy Crush or something on his phone. Now using the computer, and the court clerk is taking a peek as well. Yeah, the security video could solve this. I'm concerned that the prosecutor is out there with his witness right now, discussing what he needs to testify to. I think everybody's shading it. I don't trust anybody in this courtroom anymore. Nobody. The whole lot of them. We can zoom, but I think it's going to come in here in just a minute. My wife brought me a taco salad. A couple cherry tomatoes. I sort of want to hear the hot mic as well. So. Skip ahead 5 seconds. 5 seconds at a time. Here we go.
Can someone please give a sheet of that?
Yes, Your Honor. I believe he's just trying to get our witness.
We're going on 45 plus minutes. Here we go. Is this Mr. Perez?
It is, yes.
She's at the podium. Raise your right hand. Do you swear or affirm that the testimony must be the truth?
I do.
State your question, then.
You please state your name for the record. Andres Perez.
And Mr. Perez, where do you work?
I work for the State Attorney's Office here in Miami.
How long have you worked there?
Well, in total, 3 years, give or take.
Now, a few moments ago, can you describe to the court what you saw?
Right, so I was heading over to the courtroom across the hallway, courtroom 2-1, for a hearing that was scheduled for 1 p.m. I would say approximately a couple minutes before that, as I was walking down the hallway, I recognized a witness who had previously testified in this trial. She is a female. She was wearing a shirt that has like squares patterns on it. In my knowledge, it was the witness before the one you just had.
How do you know that?
I've been watching somewhat from my office. I have the YouTube feed on for Long Crime Productions. So I recognized that the witness was watching the live feed also of the other witness that was testifying. And I knew that it was that because I recognized this courtroom. I'm familiar with YouTube. I have an iPhone. She was watching it on an iPhone. So pretty sure what I saw.
Were there any males present as well?
There was. So she was sort of lounging with her leg up on the bench right outside and laying on a male.
Now, to be clear, you're in charge, right?
Yes.
And you have a bar card?
I do.
And you have to take an oath that is different than other people when they come to testify.
Correct. I am an officer of the court.
And if you were to lie in court, there would be significant consequences even outside of the court.
Oh, yeah.
I have no further questions.
Is there any questions for this Mr. Perez?
How far were you away from this woman?
So she was literally sitting on the bench right outside of the courtroom I was going into, so I walked right past her, arm's length.
Okay, did you stick your head in to look at her phone?
No, but I was very familiar with what she was looking at because I had seen it also, which was this courtroom, the proceedings.
Did you hear anything?
No.
Okay. And what was she wearing?
She was wearing, I don't mean to be rude, but she's a heavier set woman. She had like I'm not good with women's clothing, I don't know, but the sort of the design was like squares that are like gold.
Fendi logo. All right.
I don't know what that is, sorry.
Okay.
Venti.
So was she sitting down? Was she leaning back? Which way was she facing?
So she was, if I'm walking towards you, she was lounging on the bench with her back towards me so that her phone was facing me as I walked past her.
She was lounging facing this direction?
Away from me, so that as I walked past her, I could see her phone because her phone was facing me as I walked past.
Couldn't you hear anything?
No, I couldn't hear.
All right, and you saw, what exactly did you saw on her phone?
I saw she was on YouTube, which I'm familiar with because I have YouTube on my phone. I know she was on a live stream because she had the comment section open and it was scrolling pretty fast, consistent with a live stream, with a live chat. And I recognized that the image on the video was this courtroom.
Was she the only person watching that stream?
You know, I don't know if she was the only one watching it. I don't know if the male that she was lounging on was also kind of looking, but he didn't seem to be paying too much attention to it.
The male that she was lounging with, was he an adult?
Yes.
Other than this woman and this male, was anybody else watching that stream?
I don't think so, no.
Okay. And you said this was, when was this?
right before my hearing. As I walked in, my hearing was scheduled for 1, so I was probably maybe a couple minutes before 1. I don't know the exact time.
Okay, that's all I have.
Before you go, was the volume on the live stream?
Wasn't audible, and I can't tell you if she was wearing headphones because I didn't pay that close either.
From where you were standing, you didn't hear anything?
No, I didn't.
No meaning, no sounds from the live feed?
I did not hear anything.
Anyone want to follow up based on what I just asked?
No.
Okay. You can step outside. Thank you. Okay. Say you can go first.
Sure. So I think that it is very obvious that Ursula Burrito lied to the court.
So you want me to still remove her testimony from this jury's consideration?
I really don't know the other remedy here, because if Ms. Burrito is in question on the stand about whether or not she was watching things, posting things, etc., I'm going to be calling Mr. Perez as a witness to say, what, that he saw her watching a YouTube feed afterwards. We know already that she was logging into Zoom. That is on the record from a few days prior. We know that she was actively posting about this case during the middle of the trial. 5 days ago, I think it is highly unlikely that she did not click any of the links, that she did not post, or excuse me, did not do this, watch any of those videos, do any of those things, when we know for a fact that she just lied to the court. We know that for a fact. We had an attorney come in, under oath, said, I watched this happen, and he was very forthcoming in the things that he did and did not see. Ms. Burrito, on the other hand, lied to this court.
Okay, so what do you want to do? You're about all her testimony? That cannot be the remedy. The issue right now is whether or not, twofold, whether or not there's been a violation of the rule of sequestration, number one. What the remedy is, if you all believe there has been a violation, you can call whatever witnesses you want and impeach them. Or bring out that they are conforming their testimony with outside influence.
Then I'm going to ask the court.
Or you want me to do a contempt hearing for her lying to the court, supposedly.
Yes.
What do I do with her testimony? What remedy do you want?
Judge, I'm looking at case law about what the actual remedy is, because quite frankly, I have never had such blatant violations.
One is very obvious. Ms. Burrito, you know that you're not supposed to be looking at other outside information, speaking to other witnesses so that you can testify independently. Did you do that? Maybe she says yes, maybe she says no.
She said no, and she lied.
Then you may be able to cross-examine her on her posting. All right, that's a suggestion. Mr. Thomas.
So, Judge, I don't think it's been established that she was able to hear anything that happened. Perhaps she could have read some of these comments. I don't think these comments would inform her on anything that she's not supposed to hear. So I'm not sure that she violated the rule of sequestration based on.
Do you agree with me that my approach is twofold, whether or not there's been a violation of the rule of sequestration, number one, or whether or not she's lied to the court?
Yes, ma'am.
Okay. So with regards to the rule of sequestration, your suggestion on my remedy to the state, they can bring her back and/or Mr. Perez to somehow suggest or argue to the jury that her testimony was not as truthful because she may have been looking at live feed after she testified, and/or had been posting about this story, the trial 5 days before she testified. That would be the two lines of inquiry.
Judge, that's fine, I guess, and I would suggest that we do a full contempt hearing for her lying to the court, but there is an additional issue of witnesses who have not yet testified and not yet been deposed being involved in this. I went, again, as an officer of the court, I stepped outside to use the restroom, and I saw Ms. Perez being handed her deposition transcript by Ms. Gonzalez, while PJ was sitting right next to her.
And what is wrong or illegal about that? If we know witnesses are allowed to have a copy of the deposition, don't most witnesses reserve their right to read it?
Absolutely, yes.
Okay, so what is wrong with her having a copy of the deposition?
That is not the issue. The issue is, PJ hasn't given the deposition. As far as I'm concerned, he's not a witness in this case. Right, we can revisit it if and when that time comes, but at this point in time, he is not a witness to this case as far as I'm concerned. We are supposed to be taking his deposition. When? I don't know. But him having access to that deposition, having access to YouTube, having his family members violate the rules of sequestration, which I think that we well established that they have.
How do we know he's reading the deposition? How do we know he's looking at the YouTube live feed with Crystal? How do we know they're talking to him about this case?
We know that Ms. Link herself was talking to him about his testimony. She said that 2 weeks ago.
How do I know right now what's before the court? Because I've been at this for about an hour now on possible violation of sequestration. How do I know without jumping, speculating that PJ, they've been talking to him about his testimony or their testimony, thereby unduly influencing him?
Judge, circumstantial evidence is still evidence, number one. And number two, again, Ms. Link has actively told this court that she was talking to the witness about his testimony. That's how.
There's no evidence at this time that there's been any violation of the rule of sequestration. If you want to somehow bring back Ms. Moreno to ask her if she's been posting and or observing coverage of this trial because she's posted it on Facebook, to somehow make an argument to the jury that she is changing or conforming her testimony based on outside influence, you're more than welcome to do that. Okay, because you know what, I'm ruling right now, I'm done, we're done. We went back and forth, I am ruling right now. I am ruling right now.
It's just Perez, Judge.
That's it, nothing else.
We haven't discussed everything with Perez.
Well, I'm not there yet, am I? I don't see any violation of the rule of sequestration unless you all want to bring her in regarding the Facebook post and or what she saw. Ms. Perez, she's allowed to have the deposition transcripts. There's no evidence or influence. There's nothing for me that suggests that she was trying to change her testimony before she comes back on the witness stand. Okay. If you all want to question her about whether or not Mr. Tomas talked to her about her testimony prior to, I think that's allowed, Mr. Tomas.
He's absolutely allowed to.
Then I don't know what your remedy, what you all want me to do a remedy for Ms. Perez.
The jury instructions specifically can say that a witness kept speaking to a lawyer should not be given anything. Because it is entirely proper.
So what do you want me to make of her having a copy of her deposition?
It's not just her having a deposition. It's not. And the court is focusing on her having a deposition. I give every single one of my witnesses before they testify a
So
copy
what's
of
your
their
remedy? I brought her in here. You questioned her. You all cross-examined her.
And
what did she do wrong, and how do you want me to fix it?
She lied to the court.
About what?
If you want to swear me in, feel free, because I can testify.
So you want me to have a contempt hearing with Ms. Perez?
I think so. And you need to have them for Crystal Brady, because again, she lied to the court.
Okay, we'll take that up later on. I need to get this case concluded.
Judge, we can't conclude a trial, a proper and fair and impartial trial, with witnesses actively violating the rules.
I suggested a remedy for Crystal. You're not giving me a remedy for Ms. Perez, because there's nothing before the court right now. That suggestion has violated the rules of sequestration. We just went on an hour-long evidentiary escapade. And I'm looking at the state and I'm saying, what's your remedy? You all are taking me up on Barreto. There's nothing for me to remedy on Perez. There's nothing for me to remedy Perez. Maybe I have a contempt hearing with her at the end of the trial.
Judge, can the state present a remedy for Perez, please?
What's your remedy for Perez?
Judge, given the fact that she was giving her deposition in the middle of live testimony, which is not allowed, the state should be allowed to, on cross-examination, ask this witness, when you stepped outside on a break, were you given a copy of your deposition? Who gave you a copy of your deposition? Your family members. Did you review that deposition? Do you know that you were live in testimony on track?
Ask away. I don't know what's going to come out of her mouth. Ask away. Let's take a 10-minute break. You all probably need a comfort break and still needs a comfort break. Also, I'm not letting anybody else into Zoom. If any lawyer wants to come and watch, whoever's in is in, whoever wants to come and watch, my doors of the courtroom have been open since the beginning. Thank you.
All right.
Except for the one guy you threw out, Your Honor. Excuse me. Oh my goodness. Let's take a little breather. I think we need to listen to like some soft, soothing music or something. But let's see, where's my mouse? I gotta skip ahead and see where we are. 7. We're almost done. Like, really, really close to being done. We're currently at less than half an hour from being done. Skipping ahead, skipping ahead. Okay, here we go.
My intention is to bring back, Mr. President, you sit down somewhere. My intention is to bring back Ms. Josephina Perez and continue with her testimony. You all want to follow up any other witness right now?
Mr. Perez does want to make one correction to his testimony.
The pleadings are closed. I've already ruled. Put it in writing. File a motion to reconsider.
No, Judge, that's not what it is. He wants to make a correction because I will be calling him in rebuttal. He wants to, as an officer of the court, if he got something wrong, he would like to let the court know the time that he said his hearing was incorrect.
Did he let Mr. Tomas know?
He told me that 15 minutes ago.
Inform Mr. Tomas in front of us.
Whoa,
Would you like to tell first in open court?
You can say it as loud as you want, and I can hear it.
Okay. So during my testimony, I stated that my hearing was at 1 p.m. It was actually at 2 p.m. And the things that I testified to were shortly before 2 p.m. That's it.
All right, thank you. So let's go ahead and see if,
This is a mess. This is a circus.
Jason, right? Jason? You can go ahead. Can you help us with Josephina Perez? He's one of our court reporters.
And Judge, I'm allowed to inquire about what we said was the state's remedy, right?
Yes, but I don't know what's going to come out of her mouth. Remember? We talked about that also.
I can guess.
Understood, Judge.
Does anyone know if the jury went home for the night in Warren County?
It's Joseph Perez, right? Josephina.
Josephina.
Oh, man. I think the final portion of this trial will be a cage match. She's back.
All right, the jurors.
Jury's back. They're like, what was the holdup? We heard some yelling. Almost expect the bailiff to be, let's get ready to rumble. Said they wanted to stay. Haven't seen anything in the court.
Our counsel thank you. We can see that this trial is still on the witness stand. The state shall continue their testimony.
Yes, Judge.
Audio gets better
Now,
here.
Ms. Perez, when we took a break, you stepped outside, right?
Yeah.
Sorry, couldn't hear you.
Yes, yes.
And when you stepped outside, isn't it true that you were given a copy of your deposition?
Yes.
And you were given a copy of your deposition by your granddaughter,
Right.
the young lady who testified here earlier?
Yes.
And she gave you a copy of that deposition knowing that you were still in the middle of your testimony?
Speculation.
Sorry, what was the question?
She gave you a copy of that deposition knowing that you were still in the middle of your testimony?
Sustain, hold on, sustain. Re-ask the question, please.
Did she know you were testifying still?
I don't think she knows what the rules are so she just handed something to me and I put it right next to me.
Ms. Perez, my question was, did she know you were still testifying right now?
Does she know right now?
Did she know you were still testifying?
On the case right now?
Yes.
I believe so.
So when you stepped outside, did you tell her you were on a break?
I didn't tell, I just told her that we got put out. You didn't give me like any instructions if I was on a break or anything.
Right, so when you told her you got put out is when she
Ma'am,
decided to
I
give you
don't
the
know
deposition?
I don't know any of your rules and regulations.
Ms.
You
Perez?
just said go outside and she handed it to me, that's it.
I understand what you're saying. My question is,
Mhm.
when you told her you got put out, she then proceeds to give you a copy of your deposition.
She just handed me the document and that's it.
So she gave you the document.
Right.
Did she tell you to do anything with the document? Did she tell you to read it?
No, she didn't tell me anything.
And Ms. Perez, you used to be a clerk for Miami-Dade?
Objection relevance.
What?
So hold on, sustain. She's gonna ask another question.
So I want to talk about what you didn't see, okay, Ms. Perez?
She used to be
On the night before Pedro was shot, your daughter came to pick you up. Crystal?
Say it again. Can you repeat the question?
Sure. Before Pedro was shot, your daughter Crystal came to pick you up.
It was her husband that was
So
driving.
Crystal never picked you up?
I called her to pick me up.
Okay, so Crystal wasn't in the car?
I don't think so.
So it was just her husband who was in the car?
Yeah, and my granddaughter.
Okay, so Crystal wasn't in the car. So her husband came to pick you up,
Right.
and you left.
Yes.
So you didn't see what happened between Pedro and Daisy after that?
No, I didn't.
You didn't see Daisy shoot Pedro?
No, I didn't see anything.
No further questions, Judge.
All right, let's see if we can do that.
Wow. This is
Mr.
Miami-Dade.
Perez, you were asked a while ago about the barbecue that you were going to have with some family members. Do you remember that?
Yes.
Again, you were here from Texas. Did you have, besides Daisy, did you have other family members who you don't get to see very often because you live in another state?
Right.
And your intention was to move Daisy back to Texas without Pedro finding out, correct?
Right.
It was a relevance issue, not relevant.
All right, that's all I have.
It's very insightful to us, but not relevant to the
I'm
trial.
done? Thank you, ma'am.
Can I go back to watching the live feed? This is so bad.
Just need to talk, I don't think she's gonna be so quick, we'll just talk to the lawyers, sidebar about scheduling.
Okay, quick sidebar. all that for this? You happy with that? What do you want me to do? Throw her in jail? Yes? Okay. There'll probably be a contempt hearing after this trial's over. She's already been ordered not to leave the county. I think we're almost done. I think this is a scheduling issue. I think everyone's tempers are a little bit hot. I think we need to go home. We need to rest up. We need to listen to maybe Daisy in the Wall or some other nice, soft, soothing song, and then come back in the morning and do this again after we get the verdict in the Warren case. This is why I don't claim Miami as a Floridian. This is nuts. The judge having the audacity to say that since the beginning of this trial, my courtroom's been open. You kicked somebody out because you didn't know who they were. And he said, I'm not connected with this trial. I'm just a court watcher. I'm just a member of the public. I've come to exercise my right and to view court as it's open and open to the public. And she says, you're not getting in here until I've got my questions satisfied. She kicked him out for the day.
Tomorrow, sorry that it was a shorter meeting today than we had planned, so we'll still plan on going from 10:30 to 5:30 tomorrow. These are the court's instructions about not talking about this case with anybody else, not looking up this case. You obviously know that the cameras are here and it's being monitored and covered. So please don't do any research online, for example.
Yeah, the last thing we need is a witness to be watching.
If you find out of any violation of these court orders, bring it to my attention as well as verso. Please ignore anyone that you may have seen. And also, don't listen to any of the lawyers or this link, please ignore them. They're under my strict instructions to ignore you. So we'll take your notepads and virtual, we'll collect them after the day, and we will see you all tomorrow so we can start at 10:30. Thank you. Have a good rest.
All right, you're adjourned.
Let's let the jurors out, make sure there's nothing else we need to talk about before we end the day. And we'll get ready and play some music, maybe. Everyone be seated. Volume. Volume, please. Cameron's got one job. I could boost this so I could hear, but if he turns the volume up, I would go deaf, and you all would as well. There we go.
And investigation into anything that he may or may not have said.
Let me ask you this, what if he appears tomorrow and he's ready to testify? What do I do? Let's say I go along with you and but he's here tomorrow, what do I do?
He's not a witness. And the court is requiring me to take a deposition at 4 o'clock, but I'm still prepared for it.
Well, let's just focus on the issue of David Perez. We're talking about PJ, let's just focus on David Perez.
David Perez and PJ go hand in hand. The reason why is because my hands are being tied, I'm being forced to take a deposition that I'm still prepared to take at this point in time, as I've been in trial all day. If David Perez naturally shows up tomorrow at 9 a.m., I'm going to be able to prepare to take his deposition because I have not actually prepared to take his deposition. The 4 or 5 depositions that I take, I had to do and sit and research into what those people were saying. There are reasons I asked the questions I did. I do not know David Perez. What he says, John Smith was
killing me.
I'm going to want to talk to John Smith. This is why depositions do not occur in the middle of a trial. This is why witnesses get excluded. And quite frankly, Your Honor, I'd be hard-pressed to see what would happen on the reverse if I magically made witnesses appear that were excluded in the middle of trial.
The rules are different for the state as they are for the defense. That's law school 101. Hold on, I waited for you. Please let me respond, because you're done with your thoughts. Mr. Perez has been set for deposition prior, has he not?
3 times.
All right, so you're telling me that you were not prepared those 3 times that you set him for deposition?
That's not what I said. I said I would be ill-prepared tomorrow if he magically shows up. And you're right, the rules are very different obligation-wise for defense and state. But the rules for discovery for defendants say they are listing people they intend to call as witnesses. David Perez is not a witness in this case, and if the court is, this would essentially be, at this point in time, trial by ambush, because there's a difference between proffering what someone is going to say versus what they actually say and testify to under penalty for agreeing to deposition in that trial. I don't know what he's actually going to say. I have a general idea of what he's going to say. The proffer is, but I don't actually know what he's going to say. I don't know who else was there. I do not know anything about his conversations with Ms. Lynn via jail call or in his text messages as well, which is avenues that I'm going to want to explore.
Your objections are for the record. So tomorrow we're just taking one step at a time. Isabella, you can stay later on for PJ's deposition. Okay, so you guys can have my courtroom for PJ's deposition. The state will accommodate us meaning all the parties, Mr. Gillespie, regarding recording it on Zoom, okay? So, Ms. Lynn cannot be present for that deposition. So, I'm sure corrections will give you a few minutes to her, and then once we're done speaking to her, you all will bring in,
I'm just watching the clerk.
Well, I reminded Ms. Flores as well as Ms. Flores and actually he reminded the county. So please have the record on it. In the event that I need to have any more interactions with them or report periods. All right? Thank you all. I'll see you tomorrow.
Have a good one, Judge.
Good one, Judge. Oh my goodness. Oh my goodness. Wait for it. Ready? Isn't that great? Go wait and watch. Are we not done? we not done?
Yes, sir.
You too.
Judge is gone. We can fight now.
He's asking who's asking.
The clerk is still beating over the evidence.
They have a cutoff of 14 from
Yeah, so you guys aren't.
Well, we are, it's just you won't get your transcripts.
Yeah.
Somebody's mad.
Okay. No, I understand.
I need them. We're probably going to trial. It's not your fault.
We could also set it for tomorrow. She doesn't.
No, she wants to get this over.
Then today, just get it later in the day tomorrow. That's what I heard. All I know is we won't get it in the morning, for sure. It's cut off at 4.
The clerk has loaded all the evidence into his backpack and he's going to take it home. Oh my goodness. Oh my goodness. What a trial. And we're back again tomorrow. What I don't know is if we're done here. I don't know if, because this view right here, this is the same view we get at the end of the day when the court has gone home for the day. The only difference is normally I think they turn the lights out at some point. And I don't know when that is. But normally they turn the lights off. And maybe, I don't know, it looks like they need to come empty the garbages. The janitor needs to come through. I'm looking around the courtroom here. Yep, judge. His computer still appears to be there. But not his main one that he brings in. If he went home, the courtroom would be dark. Okay, so here's what I'll do. I'll just keep the tape rolling. We've already listened to Daisy and the Wall today. We need a song to end us on. I'll keep the tape rolling, and if they come back with a verdict, we'll watch it the first thing in the morning, I guess. I don't know. Let's see. Let's see what song we've got. Filter for public songs. Waffle House Romance is a good one. Butt Dials at Midnight. It's been a while since that one. Got the Jim McIntyre song, Master of the Sly. Yoga in the Courtroom. Gray is the New Green. Gray is the New Green. It's calming. Let's do that. Let's do that, everybody. Since we're all friends, we're not fighting with anybody, right? Let's see. Do we have audio? I think so.
In the land of pixels, here we meet. Gray's the color of our simple seats.
One more.
No flashy lights, no fancy scheme. It's low-key love in a cyber dream. Slow mode life, we're taking it easy. Calm in the chat, everything looks breezy. No golden throne, no crown on screen. Yet still I feel like royalty unseen.
Unruly Julia, thank you very much. 5
Gray is the new green, don't you know? In the digital glow, we take it slow. No need for cold. We're riding high on this mellow road. Gifted green lights up the scene.
Yes.
A ticket to a world unseen. But here in gray, we find our creed. No extra flair, just what we need. No temp seats, no quick retreats, just hanging out in these cyber streets. Gray dust clouds, our silent beam, a hidden treasure in the live stream. Gray is the new green, don't you know? In the digital glow, we take it slow.
Special K, thank you so much.
No
It's
need
huge.
for emojis or special code. We're riding high on this mellow road.
Thank you, Special K. Appreciate that. That is massive support. There we go. All right. Thank you very much to a couple of wonderful people. Obviously, Aurelia Julia kicked that off with 5 memberships. We also had Selena K gifted a membership, followed by, let me see if I can do this right, Nikki Zeebs. Nikki, there you are. I've got to click fast. They're going quickly. Hilda B, thank you very much for gifted membership. Marianne R65 gifted a membership. Let's see, Selena K gifted another. Is that right? Maybe Nikki Zeebs gifted 2. I don't remember. Hilda B, member for 10 months. Wouldn't want to be anywhere but here. Congratulations, Hilda B. And then a huge super chat. Huge super chat from Special K. Best place to watch trials. Special K, thank you. Wouldn't be the same without you here. All of you. Wonderful, wonderful day. We've got so much more in store tomorrow. The jury time, if you look at it quick, 4 hours, 38 minutes and counting. I'm going to keep the tape rolling on the courtroom in Warren County. If something happens tonight, late at night, we will catch it. We'll catch it and we'll bring it to you in the morning. So you can rest easy knowing we will get the resolution if there is one. If not, we'll be back first thing in the morning, about 8:45, 8:30 time to start and check out what's happening there as the jury should start deliberating again. They said they should get pulled back into the courtroom in the morning. Not sure if the prosecutor will be there, not sure if the defense will be there, but the judge says he'll pull the jury in. So, Ann Cloutier gifted a membership as well. Thank you very much for your generosity, all of you. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again tomorrow morning, 8:30-ish in the morning. I don't know if I can do 8:30. It's a late night tonight. Oh my goodness. A huge, huge shout out to our amazing moderators who, surprise, surprise, have lives of their own. Very demanding lives. Important things, serious things going on in their lives, and they're here helping out day after day. Thank you very much. You're absolutely the best. I could not do this without you. You guys have a good night. We'll see you in the morning. Josh! Josh, I was about to click the out. Josh, thank you very much. One of our great mods. Best chat, my favorite mods. Thank you, Josh, for your generosity as well. You guys are the best. You guys be good to each other. Rest your ears. It's been a rough day. We'll see you tomorrow.
It's bigger than you. It's bigger than me. It's bigger than all of us.
In front of the Walmart.
I think I'm about to catch a whooping.
Ivan, I don't think YouTube is even possible to process that. And don't give them 30%. See you guys tomorrow.